Good morning, everybody. Thank you for being here. I'm just recapping today. This is going to be a recap of the last hour of Ken Paxton's impeachment from yesterday. Okay, and I'm not sure if I'll be able to do a good job streaming today because I'm going to be working. So we'll see how it all plays out. Okay, but so forgive me, and I'll have this little banner up here. Let's see. Have this little banner up here sort of explaining that. This is just a recap of day 3. Okay, so we're going to put that up there. And let's go ahead and get this started.
One of your concerns on September 30th was that if you didn't go to the FBI immediately, someone would think you were co-conspirators with the elected attorney general in this state, right?
That was one of the concerns, yes, sir.
And your attorney that you hired before you went to the FBI is a man named Johnny Sutton, correct?
That's right.
And he's here today, correct?
He is.
And he's sitting in this courtroom, yes?
Yes, sir.
Would you indicate him for us?
It's right there.
Yes. And he represented a number of you employees at the Attorney General's office, correct?
Yes, sir.
And by the time that you went to the FBI, Mr. Vassar, just tell these senators, did you know who performed the home repairs and renovations at the Paxton's home?
No, I had no direct knowledge.
You didn't have any indirect knowledge, did you?
It was discussed when all of the events came together and we met as deputies on September 29th. That was mentioned as one of the potential concerns of bribery of the Attorney General.
Who mentioned it?
Based on my recollection, it may have been Mr. Brinkman.
And Mr. Brinkman heard it where?
I'm not sure.
He heard it from someone else, correct?
I'm not sure.
You don't know?
I don't know where he heard it.
But one of the criminal complaints that you and your group of people who went to the FBI alleged was that the Paxton's home was being renovated at the cost of someone who was under federal investigation, correct?
You said one of the criminal complaints. I'm not, we did a verbal complaint.
Yes.
At the office, but I'm not sure.
Let me be clearer. One of the things that you told the FBI in your meeting with them was that you were concerned that someone else was paying for the home renovations to the Paxton's home, correct?
Me individually, I had no knowledge, but yes, in the meeting with the FBI, with all of us present, there was a roundtable discussion about some individuals' good faith belief that the Attorney General was involved in bribery.
A good faith belief based on what?
I'm not sure. It wasn't my direct knowledge.
You were in the meeting.
Yes, I was in the meeting with the FBI. But
what was the basis?
I'm not sure. I think it was redoing the kitchen countertops.
Redoing the kitchen countertops? Is that what you heard?
I'm just giving you the context of what I recall.
Did you see any documents exchanged with the FBI in this meeting?
No, sir.
Not one?
No, we did not provide any documents to the FBI.
And let me be clear, because I think your testimony was a little bit confusing, at least to me. It may have been to the senators as well. But you learned about Brandon Kamak's signed contract with the Attorney General after you reported the Attorney General to the FBI, correct?
I think that's correct, yes.
I knew you knew it. I knew you knew it.
So when you went to the FBI and you told presumably some FBI agents that Brandon Kamak was out serving grand jury subpoenas without authority, you did not know that that man had a signed contract with the Attorney General of the state's signature affixed to it, correct?
That's my recollection.
Well, surely when you found out, you went straight back to the FBI and told them, right?
No. I mean, at the time, we were represented by Mr. Sutton.
Surely at that time, Mr. Sutton asked you to go back to the FBI and correct that misinformation, correct?
What information, what misinformation? That Mr. Kamak had a contract?
Yes, he had a signed contract affixed with the signature of the elected Attorney General of this state, correct?
Yes, based on What he had provided to us was a signed contract, and General Paxton had confirmed to us that he had signed a contract.
And you had it in hand, correct?
Yes.
And surely your lawyer said, guys, we need to go back to the FBI and tell them that there's a signed contract with the affixed signature of the elected attorney general of this state, right?
There wouldn't have been any reason to provide them with a signed contract because that wasn't part of the complaint that we had filed with the FBI.
Part of the complaint, let's be clear about the complaint, okay? Part of the complaint to the FBI was that Brandon Kamak was out serving grand jury subpoenas to support someone else's agenda besides the people of the state of Texas. True?
Yes.
And at some point after your meeting with the FBI, you discovered from Brandon Kamak that he had a signed contract with the elected attorney general, correct?
That's absolutely true. For nothing that he was doing.
For nothing that he was
I'll
doing?
get to the non-responsive portion of the question
Yeah, what the
or answer and move to strike, Your Honor.
Strike the last comment.
Now, let's be clear about something else. After this contract that was signed by the Attorney General of the state of Texas, Ken Paxton.
Oh, sorry, guys. I didn't realize my mic was still on. Sorry.
Correct?
Yes, I believe he did.
And that's because over 4 million voters in this state gave him that authority, correct?
Yes.
And that authority exists to bind this state. And if the voters don't like it, they can vote in someone else, correct?
That's, yes, how the political system works.
That's my understanding as well. At what point in time did you come back to the FBI and say, well, maybe there was some authority for Brandon Kamak to do what he was doing? Did you ever do that?
No, sir. And just because
Object non-responsive to anything after no, sir, Mr. President.
Please keep your answers to the questions.
In your meeting with the FBI, did you tell the FBI that Ken Paxton had illegally disclosed some confidential material to someone?
We filed a complaint based on activity that we had formed a reasonable belief that...
Mr. President, I will object at this time as non-responsive.
Sustain.
Madam Court Reporter, would you mind reading my question back? I should have a, I'm sorry, I don't have one. Yes or no?
I disagree with the phrasing of the question.
It's a very simple question. Did you tell the FBI in this meeting, did someone in this meeting tell the FBI that Ken Paxton had illegally disclosed some confidential information to someone? Yes or no?
In the meeting, we alleged, based on a reasonable belief, that that activity could have occurred, but we were not investigators. That was what law enforcement was for.
That's right. And Mr. Vassar, I want to see us on this point. You're a lawyer and you're doing some, I mean, you have very good command of the language. You had a good faith belief in certain information, but you didn't know that Ken Paxton had disclosed anything to anyone when you made this report to the FBI, did you?
No.
You were hoping the FBI would sort it out for you and not think that you were co-conspirators with him, correct?
No. The purpose of the complaint to the FBI was because we had formed a belief in good faith that the Attorney General was involved in criminal activity.
This is something that I keep hearing over and over again. We formed a good, let me make sure I get it right, formed a good faith belief that the Attorney General of this state was engaged in illegal activity. Did I say that right?
That's accurate.
But you didn't know, right?
Well,
you didn't know, right?
That's the point of the good faith belief, is we had no evidence that we could point to, but we had reasonable conclusions that we could draw.
You went to the FBI and reported the Attorney General of this state with no evidence. Do I have that correct?
We reported the facts to the FBI.
That's not my question. You had no evidence that Ken Paxton had done anything illegal. Did you?
Your Honor, It's not necessary to yell at this witness. I suggest it's disrespectful. I request he quit doing it.
I apologize. Let me do this again at a lower volume. Madam Court Reporter, would you read my question back for me, please, at an appropriate volume? Yes?
Repeat that, so, because they could not hear her on the microphone.
Yes, Mr. President, I will. Watching the live stream over there? Hold on. Let me ask this question again. Let me get this straight. You went to the FBI and reported him for potential crimes without any evidence. Do I have that correct?
We went to the FBI and reported
Please answer my question, yes
our
or no.
belief that criminal activity had occurred.
That was not my question. That was not
Witness
my
needs
question.
to answer the question, yes or no.
Did I ask it again, Mr. Vassar?
Please.
I want to get this straight. You went to the FBI on September 30th with your compatriots and reported the elected Attorney General of this state for a crime without any evidence. Yes?
That's right. We took no evidence.
Did you gain any after that? Did you gain any after that?
Well, we weren't collecting evidence.
Did you gain any after that?
Evidence of what, sir? Of
Evidence of a crime committed by the elected Attorney General in this state, elected by over 4 million voters. That guy.
I don't recall if we had collected any evidence.
Don't you think that's something that you should be able to recall, sir?
Well, when we presented ourselves to the FBI, we did so as witnesses, not as investigators to collect evidence.
Did so as complainants, hoping that you would not be named as co-conspirators, true? You made a complaint, yes?
Yes, it was.
Without any evidence, yes?
No.
I'm sorry?
Again, these are our good faith beliefs that a crime had occurred.
Respectfully, sir, we are not here in this historic event for your good faith beliefs. So if you could just tell these senators who are taking up their time and all of Texas's time with this impeachment.
Excuse me. These sidebar testifying comments are an inappropriate form of cross. If you just ask the question, I have no objection.
I will throttle it down. I withdraw it.
Pull that back.
Yes.
Ask a question.
Mr. Vassar, we got a lot of people whose time is invested in this impeachment proceeding. Did you gain any evidence after you went to the FBI?
I'm not sure what evidence that I can recall.
You had a good faith belief. We've heard those words a lot in this trial, a good faith belief, but without any evidence, correct?
The evidence that we provided.
Why didn't you talk to Ken Paxton? I'm sorry.
Please let him finish his answer.
Overruled, he was finished.
Mr. Vassar, when you worked for Ken Paxton, was he gentle?
As far as I knew, yes, sir.
Be kind?
Yes, sir.
Ever yell at you, scream at you?
No, sir.
Don't you think you owed him the courtesy of at least a phone call before you reported a man to the FBI without a shred of evidence?
Well, that's not how the reporting structure worked.
Oh, please tell these senators how it works.
Well, all of my interactions were directly with Jeff Mateer and Ryan Bangert. General Paxton would call me with questions like the open records issue or the foreclosure letter, or I'm sorry, not the foreclosure letter, that was through Ryan Bangert, outside counsel. So every other instance was my weekly meetings with Jeff Mateer and Ryan Bangert. And I never called the Attorney General. He always called me.
I appreciate your answer, but that was not really what I asked. So let me try again. Don't you think you owed the Attorney General of the state of Texas at least a phone call before you reported him to the FBI without any evidence? Yes or no? That's not the way it worked? Yes or no?
But would you like me to answer?
Yes, I would.
Based on our conversations with Mr. Mateer and Mr. Bangert, they were having conversations directly with General Paxton. I was not part of those conversations. So any concerns that they had raised with him would have been in their conversations. I had no reason to call him directly.
Object non-responsive.
Sustain.
Let me try this again, Mr. Vassar. Don't you think you personally, Ryan Vassar, don't you think you owed the Attorney General of the state of Texas, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence, sir?
I was appalled at the time. So
Object non-responsive.
Sustain. Yes.
I object to the contingent interruption of the answer. If he doesn't like the answers he's getting, he can then object to it being non-responsive. But jumping in the middle of this, man, is totally unfair, and I object.
I will listen more closely, Counselor. I have not heard him interrupt him. I will listen more closely so the witness can finish his answer and you can do a follow-up question.
Vassar, my question was, don't you think you personally owed Attorney General Ken Paxton, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence? Yes or no? No, I don't? Yes, I do.
well, I would disagree that we didn't have any evidence just based on our beliefs, but I don't think I owed General Paxton anything.
Don't? You worked for him for 5 years.
That's right, and I believed in him.
He gave you a job, correct?
He did. And promotion.
And a promotion, huh? Not enough to warrant a phone call before you report him to the FBI, though. True?
Like I said,
Do you wish you could go back and call him?
I'm sorry,
Do you wish you could go back in time and call Ken Paxton and talk to him before you reported him to the FBI without any evidence?
I wouldn't do anything else differently.
Interesting. Okay. You don't know anything about Ken Paxton's campaign donations from 2018, do you?
No, sir, I don't.
You didn't work on the Mitty Foundation case, did you?
No, sir.
When you went to the FBI, did you have Ken Paxton's phone number, at least? Could you call him on his cell phone? Did you have the number?
I believe I had his phone number in my phone. Yes, sir.
How'd you get it?
I think he gave it to me,
Why?
just based on working with him and questions that he would call me with.
So you could call him if you needed something, so he could call you if you needed something, right?
That could be an option, just based on a cell phone use.
You even had his secret email address, didn't you?
I'm not sure which one is.
Well, there is an email that's already entered into evidence in this case. It's ag.wkp@protonmail.com. Have you seen it?
Yes.
He gave it to you, right?
Yes.
Did you email him on his secret email address? Tell him that you were going to go and report him to the FBI without any evidence?
No, sir.
Why not?
It didn't occur to me.
Didn't occur to you. At some point since then, has it occurred to you that maybe you should have done that?
No, sir.
How secret could this email address have really been, Mr. Vassar, if you had it?
I don't know exactly.
Do you consider yourself a close confidant of the Attorney General?
No, sir.
Do you think you're the only person that had that email address?
I have no reason to believe that I was the only one.
So this gentle, kind man, was he attentive to your concerns when you talked to him in the office? Talked to him on the phone?
Sure.
Gentle, he's kind, he's attentive. And at what point in time did the weight of what you were doing in reporting this gentle, kind, attentive man to the FBI become apparent to you?
On September 29th.
When you walked in there?
Walked in where?
To the FBI.
No, that was September 30th.
Okay. So what happened on September 29th when the great weight of having to report this gentle, kind, attentive boss struck you? What was going on?
September 29th, I was in a meeting, just a division meeting with Lacey Mays, and she received a text message on her phone from an individual that I did not recognize, and the individual asked if a Brandon Kamek was working for our office.
And you knew exactly who that was, didn't you?
Yes, I recognized the name.
And what happened in your mind was you realized this contract didn't work its way all the way through the executive action memorandum process. True?
Among other things, yes. That's a thought that went through my mind.
Yes, and the rest of that thought is if that process has not been completed, he has no authority to work on behalf of the Office of the Attorney General, correct?
Yes.
And that was alarming to you, true?
In addition to the fact that he was acting in a capacity that he didn't have, even if a contract had existed at the time.
And in that moment, did you call General Paxton and say, Brandon Kamak's working, what's going on?
No, sir.
Do you think it's possible? Is there room in your mind for the possibility that if you had called Ken Paxton and told him that information, Ken Paxton would have said, yeah, Ryan, I signed the contract with my own hand, with my own pen. Is there room in your mind for the possibility that that would have happened?
Well, it is possible that he was out of the state at that time. So I wouldn't have been connected to him or had a reason to call him.
You had his phone number. So what if he was out of the state? Cell phone works out of the state, surely, right?
Yes, sir.
You didn't think to call him?
Well, as I explained, because he was out of state, Jeff Mateer was running the office.
That's another thing we're going to get to, okay? My understanding is your belief was that while Ken Paxton was in Ohio working on the Google case, the biggest case that the Office of the Attorney General had, Jeff Mateer was the acting Attorney General, right?
That's correct, although my understanding, in addition to
I'm object is non-responsive to the remainder of this answer.
Sustain.
Mr. Vassar, can it possibly be in a state with as many millions of people as Texas has, that it is the belief of the upper echelon of the Attorney General's office that anytime the Attorney General gets on the plane, Jeff Mateer is the real Attorney General?
only to the extent the government code is triggered. That's what deputizes the first assistant to act under the authority of the Attorney General.
And your belief was that on September 29th and 30th, when Ken Paxton was in Ohio doing business on behalf of the people of the great state of Texas, litigation business, very important litigation business, that someone else was the Attorney General, and that's what the government code says. Is that right?
Well, it was my understanding it was a political event. It was a campaign event. I had no knowledge that he was working on the Google case.
He was doing a campaign event in Ohio?
That was my understanding at the time.
Where on earth did you get that?
Just conversations at the time with Mr. Mateer.
So if he was on, let's say he was in Ohio on a campaign event, Jeff Mateer's the Attorney General while he's there?
I was just clarifying my understanding based on your question. Your next question of whether Jeff Mateer is the acting Attorney General, again, that would depend on the statute. The statute provides if the Attorney General is absent or unable to act, the first assistant shall perform the duties.
Tell the senators what absent means.
The statute doesn't define it.
Tell me what you think it means.
Well,
out of the state?
It would mean the ordinary meaning of the word under a statutory interpretation approach.
Tell these senators, many of whom are very accomplished attorneys, what the word absent means to your understanding, please.
I am not advised of what the dictionary definition would be. That would be an interpretive guide. Absent could mean out of state. Absent or unable to act could mean incapacitated.
Like if Ken Paxton was on life support in a hospital somewhere, for example.
I presume so.
But he wasn't. He was in Ohio, which I guess is debatable one way or the other.
I'm not aware if that statute has ever been interpreted by a court. So I could not be able to
But
say.
in any event, it provides the perfect cover for someone in your office to remove Ken Paxton's name for the letterhead and begin sending out letters on behalf of the Attorney General of the state of Texas. True?
No, nobody removed his name from letterhead.
You don't think so?
No, sir.
Have you ever seen Attorney General's office letterhead without Ken Paxton's name on it?
All the time.
All the time.
Yes, sir.
How did correspondence in September of 2020 come to be sent to parties outside of the Attorney General's office without Ken Paxton's name on it? Tell us.
Well, the agency has different letterhead. There probably even today, letterhead that's available on the Attorney General's website that does not have his name on it.
So,
Letterhead that he signed.
I see. So when the Attorney General is absent in Ohio, someone at the office goes, grab me the letterhead without Ken Paxton's name on it. He's in Ohio today. Is that right?
I don't recall any decision about using this letterhead or who instructed the use of the letterhead.
No one decided, it just happened, right?
Like I said, I don't recall any decision about it. The agency has different letterhead that exists today.
You're familiar with the Mitty Foundation now, right?
I've heard of it, yes, but
You've been an attorney how long?
I was licensed in 2012, so 11 years.
You said your family goes to a Baptist church, right?
Yes, sir.
Okay, that Baptist church is organized as a nonprofit, right?
Yes, sir.
And at some point in time, I'm sure you've given money to a charity, correct?
Yes, sir.
I got to ask you something that's just been really bothering me. I know I'm not the only one. What in the heck is a charity doing making a multi-million-dollar private equity investment with Nate Paul with charitable funds? Any thoughts on that?
I'm not sure. I don't know.
You ever ask anybody?
No, I was not involved in the Mitty case, was never consulted on it or provided any advice for it.
Do you know, maybe you do you know of any charities that make multi-million-dollar private equity real estate deals with charitable funds?
I have no personal knowledge.
Okay. Do you recall giving testimony to the House Board of Managers and being questioned on video by Aaron Epley, Brian Benkin, and Therese Buse?
Yes, sir, I remember.
But they never put you under oath, did they?
Not that I recall.
Did that kind of surprise you?
I didn't think anything of it.
Did you ask why not?
I don't know. I don't think I did.
Well, just because you weren't, well, you are an attorney, obviously. Just because you weren't under oath doesn't mean that you didn't tell them the truth, the whole truth, and nothing but the truth. So help you.
Finally, we get to some of the meat of this.
Did you review your statement in preparation for this historic trial?
No, I consulted with my attorneys and
Give you a copy of it.
Somehow, this guy's even more of a doofus than the last two witnesses.
no, sir.
So anything that you said in that testimony, I guess we can call it testimony, anything you said in that testimony that's recorded, we can take as the gospel truth, right? Yes?
Just based on my telling the truth, is that what you're asking?
Yes.
Yes, sir.
Oh my gosh, the act.
Have you ever, before today,
It's
have you
the
ever in your life
acting
been
for me.
asked to give testimony as a witness without being sworn?
I don't recall. I've been a resource witness to many Senate and committee.
Again, it's the acting for me.
If
They're not good actors.
Administered to a resource witness, so I apologize.
Have you ever given sworn testimony anywhere
I
before?
want more questions about the Mitty Foundation case. I want to know what's going on with this charitable organization, don't y'all?
Mr. Arroyo, if you would, Article 1 of impeachment, please. Can you see Article 1 on your screen, sir?
Yes, sir.
You don't know anything about this, do you?
No, this would be the MIDI Foundation matter.
And just to be clear, have you looked at Chapter 123 of the Property Code to determine what the Office of the Attorney General's obligations are with regard to charities in this state?
No, sir.
Don't know anything about that, do you?
No, sir.
All right. Mr. Arroyo.
Wow, so he has no idea what's going on. Noted.
Now, Mr. Vassar, you've given some testimony about what we'll call the foreclosure opinion, right? It was issued August 1,
Yes, sir.
issued August 1 of 2020. Yes?
Yes, I believe that's right. It was a Sunday.
That opinion was not a legal opinion under Subchapter C, Chapter 402 of the Government Code, was it?
Yes, it was a legal opinion under Subchapter 402.
It was?
Yes, sir.
That's not what you told the House Board of Managers. What did you tell them?
I don't recall.
We'll get to that later, but that's not what you told them, is it?
I don't recall. I may have misstated.
You may have misstated.
If you're saying that's
Yeah,
not
you
what I
may
said,
have, buddy.
and my
You may
testimony
have.
today is that there's no other statutory authority except for Chapter 418 of the Disaster Act to issue a legal authority, to issue a legal opinion by the Office of the Attorney General. So it either has to be Chapter 402 or it has to be Chapter 418.
But we know this is not 402 because it says on the face of the foreclosure opinion that it is not under 402, correct?
It does say that it's not, but that doesn't mean it doesn't fall under the authority of that chapter. It just means it wasn't written in accordance with the typical legal opinion process.
I was hoping that we would be able to have a chance to discuss this. Mr. Arroyo, please bring up Section 402.042 of the Texas Government Code. No, we're looking for 042. That's .212. We'll get to that later. Thank you. While Mr. Arroyo is bringing this up, I've got a couple questions for you about that. In order for the foreclosure opinion to have been authorized under Chapter 402 of the Government Code, Mr. Vassar, certain criteria need to be met. Is that correct?
I believe so.
There first needs to be an authorized requester, correct?
That's correct.
Who are the types of persons who are authorized to make that request?
The governor, the lieutenant governor, the speaker, chairman and chair people of committees of the House and of the Senate, executive heads of agencies, and county and district attorneys.
Did any of those people request the foreclosure opinion?
Yes, sir.
Okay. What is the next criteria to satisfy for Chapter 402 of the Government Code?
You're going to have to refresh my recollection.
All right, Mr. Arroyo, if you would move to the second page of that PDF that you just had up.
Free to leave comments and like and share this out, okay?
At the top, that
Thank you.
big chunk of text there. A little bit lower. Thank you so much, and just blow that up for us. Let's look at item C, okay? You're a lawyer. We can read this together, right? Right?
Yes, sir.
It says a request for an opinion must be in writing and sent by certified or registered mail with return receipt requested, addressed to the Office of the Attorney General in Austin, or electronically to an email address designated by the Attorney General for the purpose of receiving requests for opinions under this section. Did I read that correctly?
Yes, sir.
That didn't happen with the foreclosure opinion, did it?
I'm not advised if it did.
You were in charge of the section.
Oh,
Is there anybody who has more knowledge about this than you, perhaps?
yeah.
Um, I don't have access to the email box that it would have been received at. So I'm not aware of how it was delivered, if it was delivered by electronic mail.
Can you tell the senators whether the criteria of section 402.042C were satisfied? Yes or no?
I'm not sure. I don't recall.
And that you were in charge, right?
Yes, sir. Subsection D allows.
Seems kind of, I'm not talking about subsection D. We're not there yet. Seems kind of important to know whether this satisfies the criteria for the Attorney General to provide formal legal advice. Yes?
Yes, sir.
But you told the House Board of Managers this foreclosure opinion was not formal legal advice, correct?
That's correct.
It was not formal legal advice. It was informal guidance. True?
I believe so.
And during COVID, the Office of the Attorney General was dispensing informal legal advice related to COVID almost every day. Was it not?
It was very frequently. I don't know if it was every day, but
Were you writing the opinions?
some of them, yes.
People who are working for you were writing the opinions as well. Yes?
Yes.
And there were all kinds of COVID opinions coming out almost every day, informal legal guidance from the Office of the Attorney General that did not satisfy the criteria of Chapter 402 of the Government Code. True?
I'm not sure about that. A lot of the things that you're referring to about the daily stuff would have come through Chapter 418, which is the Disaster Council legal function. Those would have come from county mayors or city mayors, county judges, and emergency management directors. Those were coming more frequently than the other ones.
Well, let's build two boxes. In this box, we have Chapter 402, formal legal advice, correct? Okay, so in this box, we place formal legal opinions from the Office of the Attorney General that satisfy the criteria of 402.042. Yes?
Sure.
And it's assigned a KP number, correct?
That's right.
And it's published in the formal opinions section of the office's website, correct?
That's right.
And to be clear, for the ladies and gentlemen of this jury, the foreclosure opinion did not satisfy anything in that box, correct?
No, that's why it was flagged as not a formal legal opinion.
It's in the 418 box. Because at that point in time, the governor of this state had decided to empower the Attorney General to give the people of Texas guidance more freely about what's going on during COVID. True?
That's not true.
It's not true?
That's correct. It is not true.
How did the Attorney General get the ability to give people informal legal advice under Chapter 418 of the Government Code?
It wasn't from the governor. The legislature enacted a statute that the governor signed, giving the Attorney General the power to advise three categories of people: county judges, city mayors, and emergency management directors.
I apologize for my imprecision. So at this point in time, these people, the legislature, at least in part, had empowered the Attorney General to give informal legal guidance more freely. True?
To select people, yes, that's true.
Yes. How select were they?
It's the three categories of people: county judges, city mayors, and emergency management directors under the Disaster Act.
There were people on the House Board of Managers who were requesting informal legal guidance relative to COVID, weren't there?
But that wouldn't have triggered Chapter 418. The only other express statutory authority for a legal opinion is 402.
But if it doesn't have a KP number and it doesn't satisfy the criteria of 402.042, it's not formal legal advice, correct?
That's correct. It's not a formal piece of advice. It's an informal piece of advice under Chapter 402.
One of the things that had to do with your termination, I believe, is you're voluntarily sending secret grand jury subpoenas outside of the Office of the Attorney General to someone who is not authorized to receive them. Do you understand that?
That's never been stated to me, but that's my understanding based on the OAG's whistleblower report.
Well, you don't have to wait for the OAG to tell you that. You know you did it, right?
I only sent copies of records to my private lawyer. I did not send them to any member of the public or disclose them to the public outside of the agency.
Was Johnny Sutton authorized to receive secret grand jury subpoenas from Travis County? Yes or no?
Well, on their face, they weren't valid. Brandon Kamek had no contract. He was not a special prosecutor. He had no authority to request them or to
He
obtain
did
them.
have a contract that was signed
They
by
were valid enough to quash.
the Attorney
He did get a
General.
judge to sign an order to quash them, didn't he?
Well, because they were issued.
They were issued. And when they were issued, they were secret. True? True?
I guess unless they were invalidly obtained under false pretenses.
Are you aware of some type of exception that allows you to send secret grand jury subpoenas to your lawyer?
Well, I thought sending it to my lawyer for purposes of legal advice would be permissible. I'm not a.
Did you
No, no,
check
no,
and ask
no,
Mr. Sutton
no.
whether he represented any of the subpoena recipients before you sent them to him?
Yes, in our conversation for him to represent us, we discussed whether he was able to do so.
And after you sent those grand jury subpoenas to your lawyer, copying the rest of the so-called whistleblowers, you deleted that email from your inbox. True?
That's right.
Wow. He's like,
You
yep.
probably
Like that's
recall at some
something that's
point in
okay.
your 5 years of employment at the Office of the Attorney General receiving some type of training in document preservation. Yes?
Yes.
And what types of training did you receive? Please tell the ladies and gentlemen of this jury.
I believe it's an annual information security training. There's annual sexual harassment training. So there's a variety of required annual training.
Okay, he was
that
very
employees of the
specific about
office are
document
required to take.
preservation.
In a second, I'm going to ask you, well, let me ask you now. You are not allowed to delete official records of the Attorney General's office. True?
Official records, no. That's right. Unless
in a second, I'm going to ask you whether you deleted emails from your computer that should have been preserved as official records. Do you want to consult with your criminal attorney first?
Oh my gosh. Oh my gosh.
Did you delete official email records of the Office of the Attorney General, sir?
I deleted emails to my personal attorney under the agency's own information security policy that's provided to every employee, that personal messages of a de minimis nature are allowed on agency devices, provided that those messages are deleted to prevent archival. Because I made a determination.
This is very Hillary Clinton. This is very.
With copies of
Who else
records,
is getting Hillary vibes?
not records that had to be maintained on an agency device, but copies of records that existed in the office.
Let me guess. They were all about your daughter's wedding and nothing about Benghazi.
That one of the things you are accusing Ken Paxton of doing is by allowing people outside of the Office of the Attorney General to see secret things they should not see. Do I have that correct?
Oh my gosh.
No, sir. Mr. Sutton was my personal lawyer.
No, that wasn't my question. Let me try again. Listen.
Look at him answering questions no one's asked him.
What you're accusing Ken Paxton of doing is forwarding secret information of the Office of the Attorney General to people who should not have it. Yes?
That is a suspicion.
You don't even have enough to make an accusation.
They don't even have any evidence.
Right?
Yes, sir.
But that's what you did, isn't it?
No, I forwarded it to my personal lawyer.
Secret grand jury subpoenas.
You think that protects you somehow?
Well, if any ordinary person gets a subpoena, I imagine their first call is to their lawyer who reviews the subpoena.
In preparing the foreclosure opinion, Ken Paxton didn't direct you. Ryan Bangert did. Yes?
Yes, sir.
And Ken Paxton didn't direct Austin Kinghorn. You did.
That's
correct?
Right.
If you would, Mr. Arroyo, please bring up Article 2. This allegation is not true, is it?
Is there a specific part that you'd like me to review, or?
Read it all.
Um,
Ken Paxton is innocent of this allegation, isn't he?
So the first provision of the second sentence, this is Article 2 of the Articles of Impeachment. Paxton caused employees of his office to prepare an opinion.
Hold on a second. I don't want you to read it out loud.
Okay.
We don't need to waste the jury's time doing that.
Sure.
They can read. Many of them are skilled attorneys themselves. This article is not true, is it?
Well, it is true that he caused employees of his office to prepare an opinion in an attempt to avoid the impending foreclosure of properties.
Again, that was statewide. That wasn't for Nate Paul.
Nate Paul or business entities controlled by Nate Paul, do you? You don't know that?
Nothing other than what's been reported in the media.
You don't know that what's been reported in the media? Have you ever heard the phrase self-licking ice cream cone before?
No, sir.
Let me explain to you what a self-licking ice cream cone is, Mr. Vassar. A self-licking ice cream cone is when a bunch of employees at the Attorney General's office begin to suspect their boss. They read it in the media. They believe what the media says. They report it to the FBI. And then the media reports that you went to the FBI. That's a self-licking ice cream cone. Are you familiar with the expression now?
Based on your description, yes, sir.
Yeah, because that's what y'all did.
This article is true or false, do you?
No, sir, I didn't write this.
Wow.
Article 3, if you will.
It's just drafted based on your
Article 3.
testimony. He gave to the House not under oath. Now he can say that he didn't write it.
You weren't directed to act in contravention or contrary to the law, were you?
No, sir. General Paxton.
Object non-responsive to anything after no, sir, Mr. President.
Sustained.
You think that your decision with regard to any open records request that was made by anyone was improper?
No, sir.
It wasn't, was it?
No. Everything that we did in a way that we could find a way to make it lawful, because we wouldn't have participated otherwise.
You did it by the book, correct?
Yes, sir.
You wouldn't do it any other way, would you?
That's right.
Mr. Arroyo, Article 4, if you will. Can you see Article 4, Mr. Vassar?
Yes, sir.
Ken Paxton didn't improperly access anything in his office that you're aware of, did he?
No, not that I'm aware of.
And if he wanted to ask for a file, he could do that anytime he pleased, couldn't he?
Sure.
Because that's what 4.2 million voters elected him to do. True?
Yes.
To access whatever file the heck he wants. Yes?
True.
Article 5, please. We know that Ken Paxton's innocent of this article, right? Right?
I'm not even, I don't recall the distinction about an attorney pro tem. I used to know it, but.
You don't even know what an attorney pro tem is, do you?
Oh my gosh.
There's two categories. One is court appointed and one is recusal based, but I don't recall the nomenclature.
And Brandon Kamak wasn't either one of them, was he?
He said he was on the subpoenas.
Stop there. Brandon Kamak wasn't either one of them, was he?
No, he had no authority.
Wasn't an attorney pro tem, was he?
Honor, he keeps interrupting the witness. He should be entitled to finish
No,
his
it's a yes
answer.
or no
You're
question.
right, Mr. Harden. I apologize, Mr. President. May I try again?
You may try again.
Mr. Kamak was not an attorney pro tem ever, to your knowledge. True?
Like I said, I don't recall the distinction between the two categories of prosecutors, but he was not hired to be a prosecutor.
He wasn't hired to be any type of prosecutor, true?
Yes, sir.
He was hired as outside counsel because that's how you drafted the contract personally, yes?
Yes, sir.
So when it says Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem, Brandon Kamak wasn't a prosecuting attorney pro tem, was he?
Not based on my understanding of what that.
I didn't think
So
so
Article
either.
5 is bunk.
Article 6, if you would, Mr. Arroyo.
This is excellent. He's going one by one.
You're familiar with this allegation dealing with whistleblowing, correct?
Yes, sir.
Don't you kind of think Ken Paxton had a right to be upset with you reporting him to the FBI without any evidence?
They're not whistleblowers. It was a fucking mutiny.
To whatever feelings he may have felt at the time.
Yeah, he probably felt a certain way.
Article 10, if you would, Mr. Arroyo. This says the Paxtons, and it says Ken Paxton, but you understand he's married to Angela Paxton, right?
Yes, sir.
So when somebody's spouse gets accused of bribery, and the form of the bribery is improvements to a home that are owned by both of them, really you're accusing both of them of being corrupt, right?
That's right. This was an attempt to take them both down and humiliate them both.
The elements of bribery, I'm not a criminal lawyer, so I'm not sure what the implication could be.
There's a lot this guy doesn't know.
Darn well that the Paxtons paid for the renovations and repairs to their home, don't you?
No, I don't know that, actually.
You don't know who paid for them?
No.
Maybe it'll come out in this trial.
Maybe it already has.
Mr. Vassar, would you expect to be placed on investigative leave or sending a set of secret grand jury subpoenas to your outside counsel and then deleting that email?
No, sir. I mean,
you wouldn't expect anybody to investigate that?
For sending an email to my personal lawyer relating to my report to law enforcement.
Yeah.
And to be retaliated against by being placed on investigative leave. Is that?
No, my question was a little bit different, so let me be clear about what the question is. Wouldn't you expect the Office of the Attorney General to investigate your use of your office email to send secret grand jury subpoenas to that man, Johnny Sutton, and then delete the email? Wouldn't you expect to be investigated for that? Yes or no?
No, not necessarily.
Okay. Wouldn't you expect to be fired for that?
No.
Wouldn't you expect to be fired for reporting your boss to the FBI without any evidence?
No, I would expect an opportunity to answer questions based on answers that I was provided when I asked, what documents are you alleging that I disclosed? And when no response was given, I couldn't give any further information about who the messages may have gone to or for what purpose.
Mr. President, I'm conscious of the indulgence of the hour, and I want to make sure that I'm not running up against any type of deadline or keeping?
We were prepared to go to 7 if needed.
Would you like me to continue?
You may continue.
I will be happy to. You are the chief of the General Counsel Division at the Office of the Attorney General, correct?
At one point, yes, sir.
Yeah, so for the ladies and gentlemen of the jury who are here and may not be lawyers, and for the people of Texas who may be watching, you were really a lawyer to lawyers, correct?
That you could describe it like that. Yes,
that's
sir.
how I would describe it. General counsel is really a lawyer's lawyer, yes?
Yes, sir.
And so what happens in the Office of the Attorney General when you are in the General Counsel's office, actual lawyers come to you and ask you for legal advice, yes?
Yes, sir.
And that happened regularly, true?
Yes.
You were first chief of the General Counsel Division, and then you were Deputy Attorney General for Legal Counsel.
Imagine asking this guy for advice.
And your first involvement with anything related to this impeachment was being approached in the fall of 2019 with a question about an open records request made to the Texas State Securities Board, true?
That's true.
And Ryan Bangert approached you with a question. Remember, you're the lawyer's lawyer. He approached you with a question about whether the State Securities Board's involvement in a joint task force could harm the law enforcement or investigative privilege, true?
That's my recollection, yes, sir.
And you answered his question, yes?
Yes, sir.
And then you were not involved in anything else related to this impeachment matter until March 2020, true?
That's not true. I think it was May of 2020, which was the DPS request.
You're wrong about that, but
okay.
I just want to make sure I understand what your understanding of the timeline is, okay? So when was the period of time when you believe you first got a request or an open records request related to this impeachment matter?
Well, to back up just a little bit, if I may, I was not promoted to deputy for legal counsel until April 1st of 2020. So I wouldn't have been overseeing the open records division until after April. So I don't know when the DPS request was submitted to our office. That could have been the date that we received it in March, but I wouldn't have been tasked with anything related to it until after I was promoted on April 1st. And then the conversations that I had in May of 2020.
Tell the ladies and gentlemen of the jury who Joe Larson is.
I believe he's an attorney representing Nate Paul.
And what type of work does he do, to the best of your understanding?
I'm not sure. He was a requester in 2 of the open records requests.
Yes.
I don't know if that's his practice.
In fact, Joe Larson works at, he's pretty well known in the state of Texas for being a Public Information Act lawyer, yes?
I'm not sure.
Had you ever encountered him before?
No, sir.
Okay. So I'm going to tell you, my understanding is on March 3 of 2020, Joe Larson sent what I call the big request to DPS. Okay, so the one that happened in 2019 was a request for public information was made to the Texas State Securities Board. Yes?
Yes.
Ken Paxton asked you about the law enforcement privilege. You answered his question. Oh, I'm sorry. Ryan Bangert asked you about the law enforcement privilege. You answered his question. And that went away. Poof. Yes?
Yeah, I never heard anything else. Yes, that's right.
Then March 3 of 2020, Joe Larson made a Public Information Act request to DPS, what I call the big request. He's asking for a whole lot of information related to the search warrant execution on Nate Paul. Yes?
Yeah, I don't know about the dates. Again, I don't know when he submitted it to DPS, but yes, if that's how you want to categorize the big request, then yes, that is accurate.
Well, this is probably beneath many of the people on the jury who very well understand this, but for people who are watching at home, when someone makes a Public Information Act request of an agency in the state, the agency comes to the Office of Attorney General for representation, says, help us decide. Yes?
It's not representation, but it's a request for a ruling.
Yeah, they want a ruling.
Right.
And so in this situation, DPS wanted a ruling. Yes?
Correct. If they want to withhold anything under the Public Information Act, they must request a ruling.
But Joe Larson didn't wait for your ruling, did he?
I don't think I follow.
On April 10th of 2020, Joe Larson sent a demand to DPS saying, I asked for this stuff, give it to me now. Are you familiar with that request or demand?
No, sir.
And on April 16th, he filed a lawsuit to get it. Are you aware of that, sir?
I recall the lawsuit.
I'm going to show you what's been marked as Exhibit 5. And maybe light one copy. Your Honor, may I approach the witness? Thank you.
Thanks.
This is absolutely incredible. This attorney is good too. Every single attorney on Paxton's team is badass. They're just debunking these articles one after another.
We move for admission of AG Exhibit 5.
Mr. Harden?
No objection, Your Honor.
Mr.
AG
Arroyo.
Exhibit
Oh, I'm sorry.
050 should be admitted to evidence.
Thank you, Mr. Arroyo. Exhibit 5, if you would. This is good. What is this, Mr. Vassar?
This appears to be a petition for mandamus filed by Joseph Larson, as a plaintiff against the Department of Public Safety, April 16th of 2020.
Who did he sue?
He sued the department, it appears.
What did he sue to get?
I'm not sure.
Take a moment and look through it. Maybe you can figure it out.
Sure.
Again, it's the acting for me. Acting as though he doesn't know.
To count one. Joseph.
You don't need to read it out loud.
I'm not.
Okay.
I'm summarizing.
I'm sorry. Go ahead.
He's suing DPS because of his claimed refusal to produce the information that he requested.
Mr. Arroyo, can you find count 1 for the ladies and gentlemen of the jury so that they're not listening to this blind?
Do you want me to continue?
Not quite. There you go. Thank you. Can you just pull up count 1? Mr. Larson is suing DPS based on his big request for all the documents that DPS has related to the Nate Paul search warrant. True?
I don't know. It looks like, yes. Page 1 references the March 4th, 2020 DPS request.
I don't know. I don't know. Well, that's what it looks like.
Call that one the big,
you know.
the big one, if that's the big request.
I call it the big request.
Okay.
Okay, so in the big request, Mr. Larson is suing to get all the raid information. Yes?
Yes, I mean,
Probable cause affidavit. Yes?
it says all communications in this document, but I would assume it would have said all records.
He wants the full Monty.
Right.
Everything DPS has related to the Nate Paul search warrant. Yes?
I'd presume
And
so.
he's suing to get it. Yes?
Yes, it appears so.
And the OAG was aware of this litigation. True?
Yes, we became aware of it. I don't recall when, but
It would be pretty stupid for Nate Paul to sue to get something that he already had, wouldn't it?
well, this predated any conversation. This lawsuit could have even predated a request for ruling to our office. So
let me press pause there for a second. To be clear, this big request is the request to which OAG responded and said, we take no position on it. True?
yes, the big request.
Yeah, the big request. So this thing, by the time OAG even decides anything, Joe Larson's already sued DPS to get it. True?
Correct. If I'm following, so this was filed, it appears to be April 16th. The OAG's non-decision in the big request was June 2nd. So this lawsuit, and I apologize if I'm not following you, but
You are following.
Okay.
Mr. Vasher, you are following me. What happened is Joe Larson says, I'm not going to wait to see what the OAG decides on this. I'm suing. Right?
Sure. I don't know what he was thinking at the time, but
And the OAG's no decision on the big request did not lead to the production of any documents to Nate Paul, did it?
Not, not under the Public Information Act. No, sir.
No. But Joe Larson didn't stop there, did he?
If you're talking about the public information request to the Office of the Attorney General for the FBI brief, then you are correct. He did not stop there.
All right, press pause there. This third request from Joe Larson was for an unredacted copy of the FBI's brief. Let's go back a step. This is very confusing and arcane, so I want to go slowly, all right? When Joe Larson made the original big request of DPS for the search warrant, etc., DPS had to give notice to the FBI, yes?
Yes, sir.
Because they were holding the FBI's own documents, yes?
That's right.
Said, hey, we're holding some stuff that probably by right belongs to you. Do you want to object? And the FBI has a period of time to object, yes?
That's right.
And what the FBI did in response to that was they sent a legal brief, yes?
Yes, sir.
And that legal brief is a bunch of legal arguments from a lawyer at the FBI, yes?
That's right. The brief identifies the content of the information that the agency wants to withhold.
And the brief that the FBI generated and gave to Mr. Larson was almost completely redacted, like something you might get from the CIA, right?
I don't recall exactly, but based on what I recall, it was redacted.
It was just basically a bunch of pieces of paper with big black blocks on them, right?
I don't recall, but it was redacted. I do remember that.
And Joe Larson says, this is no good. He makes a demand for the unredacted FBI brief. He made a third request, so request number 3 under the Public Information Act, for an unredacted version of that brief. And he made it directly to the OAG's office, yes?
Yes, sir.
He didn't make it to DPS. He didn't make it to FBI. He made it to your office, yes?
Yes, sir.
And what happened is the OAG sent notice to the FBI, the same notice DPS had sent earlier, and said, hey, this guy wants a copy of the unredacted brief. You guys need to show up and object if you don't want him to get it. True?
Yes, that would have been the third party notice.
And the FBI blew it, right?
I don't recall. I was not involved in those conversations. I don't recall what happened.
The FBI didn't respond in time. True?
True? I believe that could be true. I don't recall. I'm happy to refresh my recollection if you have.
Joe Larson got the unredacted FBI brief, yes?
Yes, I believe so.
And he got it because your office decided the FBI blew the deadline, yes?
That's functionally correct.
Functional? What do you mean? What does that mean?
Well, after we had advised General Paxton about the issue.
What did you need to advise him about? Ken Paxton, hold on a second. Ken Paxton.
Excuse me. He asked him, what do you mean? He's in the middle of answering and he cuts him off because he doesn't want the answer. Excuse me.
Slow down.
You're very right. My apologies.
Did you want me to?
Did you need Ken Paxton to tell you that the FBI blew the deadline?
I'm sorry, did I need Ken Paxton to tell me that the FBI missed the deadline?
Yes.
No, sir. No. I brought it to General Paxton.
Not responsive to everything after no, sir.
Sustained.
So after the FBI blew the deadline, Joe Larson got the unredacted FBI brief fair and square. Yes? Yes?
I assume so. I did not provide it to him, but I assume a copy was provided in response to the decision to let the brief go out.
Okay. Just make it like, tell the ladies and gentlemen of the jury like you would a 7th grader. Did Joe Larson get the unredacted FBI brief because the FBI blew the deadline?
It was mainly because General Paxton told us to release the FBI brief.
And he told you to do that because the FBI blew the deadline, right?
I don't know if that's why he told us that.
But they did blow the deadline, yes?
I don't recall. I was not involved in contacting them directly. I don't know what any responses we would have received or when.
Sorry. You're in charge of this, yes?
That's right.
You can't remember, right?
No, I didn't have direct contact with the FBI about a brief or a notice. Those are all handled by the opinions division.
Are you satisfied in your own mind that the proper notice was provided to the FBI and the deadline was not satisfied?
Based on my knowledge, yes. I didn't see it, but
Nate Paul's lawyer got that fair and square, didn't he?
Maybe under the Public Information Act.
The law, you mean?
Correct. Just under an interpretation of whether sufficient notice was provided or whether a third party submitted briefs that it wanted to submit.
It's just a brief. It's just a bunch of legal arguments, isn't it?
It is.
You told Rusty Hardin when he asked you on direct that this item contained all types of information that would subject law enforcement to potential retaliation, that somebody might come and shoot them at their home or something like that. That's not true.
Well, that's not exactly what I said.
This unredacted FBI brief is just a bunch of legal arguments from some Fed lawyer, isn't it? Isn't it?
The act requires the brief to identify information to which exceptions might apply.
That's all he asked for, right? The brief.
Correct.
So the insinuation that Ken Paxton somehow got the file and sneaky, delivered it to Nate Paul, you don't have any evidence to substantiate any of that, do you?
I have no direct knowledge of what he did with the file when it was in his possession.
You want to make an accusation while you're here on the stand? You want to accuse the elected Attorney General of this state of delivering something to Nate Paul that he shouldn't have? Do you want to do that now?
I don't know what he did.
So when Ken Paxton asked for the file, you gave him the file, right?
Yes, sir.
He had every right to ask for that, yes?
Yes,
If he just felt like looking at it, he could ask for it, yes?
that's right.
And irregardless of his feelings about Nate Paul and whether he was unjustly being railroaded or the feds are mistreating him, he had every right to look at it, didn't he?
Yes, sir.
And you don't know that Ken Paxton did anything illicit with that file, do you?
No, sir, I don't.
You're not here to testify about any of that, are you?
No.
In fact, when Ken Paxton had this meeting with you about the file, he told you that he had spoken to Nate Paul. He didn't hide that, did he?
No, sir.
He told you he would believe that Nate Paul was being railroaded just like he has been, yes?
Yes, sir.
He told you he didn't trust DPS or the feds, didn't he?
Yes, sir.
And he didn't hide that, did he?
Not in that meeting.
Do you, by the way? Do you trust the feds? Trust the FBI?
Yes, I have no reason not to. I trust law enforcement and our peace officers.
You can't think of one reason in the last 3 or 4 years not to trust the FBI?
I'm speaking mainly personally.
Ken Paxton told you he didn't want to use his office to help the feds in any way, didn't he?
Yes, sir.
He didn't hide that from you, did he?
No, sir.
And when you were discussing the ruling, what I'll call the no decision ruling on the big request, you reached an impasse where each side made its case, and he's the boss, right? Yes?
Yes, sir.
And he didn't overwhelm you. He didn't tell you to do anything against your conscience, did he?
No, sir.
He told you to be a lawyer and make a decision, right?
No, sir.
You made a no decision, yeah?
Well, to clarify, it wasn't my decision to make. It was his decision for the ruling to be a non-decision. There was a couple of decisions in there that maybe confused me.
Have you ever seen the probable cause affidavit in connection with Nate Paul's search warrant? Have you seen it personally?
Yes, sir.
Earlier, you said that you delivered a file to, you gave a file to Drew Wicker. And just show the ladies and gentlemen of the jury with your fingers how thick that manila envelope was. Like that?
I'd say less than a quarter of an inch, just not very thick.
Probable cause search warrant affidavit is 224 pages, isn't it?
I don't know.
You don't know? You said you saw it.
Well, I saw the body of the affidavit. I don't know if there was anything else attached to it. When DPS submitted its request to us, it was a request based on representative samples of information. So we would have received a representative sample of whatever DPS provided. And I don't recall seeing a document of that size.
Counselor, we'll go maybe 10 more minutes. You can stop anywhere you'd like in between.
You're very kind. Thank you. I want to talk about the foreclosure guidance for a few minutes before we retire for the evening. The legal question from Ryan Bangert was, are foreclosure sales gatherings, quote unquote, since the governor and the local county judges and mayors had prevented gatherings of 10 or more people, right?
Yes, that's what I remember his question to be.
That's really the simple legal question. And you, as a lawyer at the OAG's office, you do your research and then you take a position. Yes?
That's right.
Okay. And we agree that what you were doing was not a formal attorney general opinion. True?
It was not formal. That's right.
These are what you call informal letters or announcements. Yes?
Yes. Informal opinions. I mean,
let's save us a little bit of time. I have a transcript of what you told the House Board of Managers. And what you told them was this AG foreclosure guidance was an informal letter or announcement. Yes? True?
if that's what you're saying,
Is that what you said?
I don't recall. Again, based on my recollection of 402 and 418, those are the only two statutes that give the Office of the Attorney General express statutory authority to issue legal opinions.
And after you and Austin Kinghorn did the research and he explained to you his position on it, you talked to Ryan Bangert, true?
Yes.
And Ryan Bangert called you and said, well, that's not the right answer. True?
We prepared a draft and then provided that to Ryan Bangert. And then, yes, he called me and said that's not the right answer.
And Ryan Bangert told you General Paxton wants to stop these foreclosure sales, right?
Yes, he said we reached the wrong answer.
Yes. And so what you know secondhand is Ken Paxton disagreed with the result that you and Austin came up with, didn't he?
Yes, that's what.
And he has the right to do that, doesn't he?
Yes.
And he was elected to make those decisions, wasn't he?
Yes.
Did Ryan Bangert tell you, you know what, Ryan Vassar? There's two Ryans. I'll sign this so you don't have to ruin your career, Ryan. Did he tell you that?
No, sir. I don't recall.
Did he intimate that?
No.
Did he imply it?
No, it was basically a timing.
What do you mean it was basically a timing? Tell me what you mean.
We prepared the first draft. By the time Ryan had finalized the second draft, it was 11 o'clock at night or midnight, and he was talking with General Paxton, is my understanding. So I had gone to bed and wasn't available to sign it.
Were you happy to sign it?
I would have signed it.
You didn't avoid signing it, right?
No.
You didn't say, Ryan, I don't feel comfortable. Would you sign this instead of me?
No, sir. I didn't say that.
So Ryan Bangert didn't jump on the grenade, so to speak, and say, you know what, this is really dangerous, Ryan Vassar. I'm going to sign it. Did he?
Not that I remember.
Did Ryan Bangert tell you, Ryan, I totally disagree with what we're doing here, but I'm going to do it over my own strenuous objections?
I don't remember him saying that.
You worked on this opinion on Saturday night, right?
It was all day Saturday. Yes, sir.
But that wasn't even the only COVID opinion that went out that day, that Saturday, was it?
I'm not sure. I would have to go back and look.
Well, I'll put it in front of you here in a little bit. You do not have the first clue whether this informal foreclosure guidance stopped a single property foreclosure, do you?
I have no direct knowledge.
And you heard it secondhand from some Austin Business Journal article, right?
That's right.
Did you believe it? Did you believe it?
I had no reason to disbelieve it just based on the timing.
Did you do any research yourself?
No, sir.
Any investigation at all?
No, sir.
Just one problem. It's 100% false. Never happened. It's not true. It's pure fiction. Did you know that?
And no, I wouldn't have had any reason to know that.
Your Honor, I believe this is a good time to stop for tomorrow if Your Honor is willing to conclude for the day.
Yes, court will adjourn for the day, 9 a.m. tomorrow morning.
All right, let's go ahead and get the jury. All right, thank you. See. All right, your next question, Mr. Ruttenberg.
Thank you, Your Honor. Afternoon. Michelle, can you please pull up Exhibit 175, please? Defendant's Exhibit. Mr. Depp, is this an email exchange you had with Bruce Witkin on June 6th, June 7th, 2013?
It's June 7th, 2013.
Okay. And if you scroll down to the bottom, I'm not going to read it aloud, but that email address is your email address. Is that right?
I don't. Oh, yes, sir.
Yeah, okay. Thank you. So this email is an email that you sent to Mr. Witkin on June 6th, 2013 at 7:05 a.m., the one that starts with "seriously be woozy." Is that right?
That's correct.
Okay. And Bruce Witkin was a longtime friend of yours, right?
Yes, sir. Quite a long time.
You met in Florida many years ago, right?
Yes.
And then he lived in Los Angeles, and you all were very close friends until a few years ago, correct?
That's correct.
Your Honor, permission to publish or I'd move for admission of this and permission to publish with the email addresses redacted. And if they want me to redact Mr. Witkin's responses, that's fine.
We have no objection to that, Your Honor, and I don't think we need to have Mr. Witkin's response redacted.
All right, so you just want to have just the identifiers redacted and that's all?
That's correct, Your Honor.
Okay, if we could do that. All right.
Okay, now I know this is a few years before Australia in 2015, which we stopped with right before lunch. But I want to just, if you can scroll down, Michelle, please, to the paragraph that starts "brain is on full tilt." Maybe just blow up the first couple sentences there. Okay, yeah, perfect. So in this email to Mr. Witkin in June of 2013, you write to him, "Brain is on full tilt. The circus never stops. Feel physically fucked constantly. I'm wired up so tight that I'm barely able to deal with people on any level that is remotely enjoyable." See that? Did I read that right?
Yes, I see. Yeah.
Now, Michelle, can you please pull up Exhibit 350, Defendant's Exhibit 350? This is a text exchange that you had with Stephen Duders, your personal assistant, on March 6th, 2015. So we fast forwarded a couple years. You see that?
Is that 1628? Is that the third one down?
Yeah, yes, sir. 1628. Third one down. And this is a text that you sent to Mr. Duders on March 6th, 2015.
Sorry, just reading it. Yes.
And by this point, you had been in Australia since about the week after your wedding, right? So for 3 weeks or so. Is that about right?
Seems right, yes.
Okay. And Amber didn't arrive until around this time, correct? Beginning of March?
Yes, I recall that Amber arrived around 6th, 7th.
The 6th or 7th of March, right? Okay. So you'd been outside of her presence for the last 3 or 4 weeks prior to this, right?
I believe so, yes.
Okay. Can you, Your Honor, I would move for admission of Defendant's Exhibit 350 with identifiers redacted.
So sorry about that, guys. I had an issue with the with the traffic stops, so that took a little bit of time. I'm so sorry. I didn't mean to be streaming the Depp and Amber Heard trial. Let me get back over to the actual Senate hearing.
Any evidence?
Don't you think that's something that you should be able to recall, sir?
Well, when we presented ourselves to the FBI, we did so as witnesses, not as investigators to collect evidence.
Did so as complainants, hoping that you would not be named as co-conspirators, true? You made a complaint, yes?
Yes, it was.
Without any evidence, yes?
No.
I'm sorry?
Again, these are our good faith beliefs that a crime had occurred.
Respectfully, sir, we are not here in this historic event for your good faith beliefs. So if you could just tell these senators who are taking up their time and all of Texas's time with this impeachment.
Excuse me, these sidebar testifying comments are an inappropriate form of cross. If you just asked a question, I have no objection.
I will throttle it down. I withdraw it.
Pull that back.
Yes.
Ask a question.
Mr. Vassar, we got a lot of people whose time is invested in this impeachment proceeding. Did you gain any evidence after you went to the FBI?
I'm not sure what evidence that we would have, that I can recall.
You had a good faith belief. We've heard those words a lot in this trial, a good faith belief, but without any evidence, correct?
The evidence that we provided.
Why didn't you talk to Ken Paxton? I'm sorry.
Please let him finish his answer.
Overruled. He was finished.
Mr. Vassar, when you worked for Ken Paxton, was he gentle?
As far as I knew, yes, sir.
Be kind?
Yes, sir.
Ever yell at you, scream at you?
No, sir.
Don't you think you owed him the courtesy of at least a phone call before you reported a man to the FBI without a shred of evidence?
Well, that's not how the reporting structure worked.
Oh, please tell these senators how it works.
Well, all of my interactions were directly with Jeff Mateer and Ryan Bangert. General Paxton would call me with questions like the open records issue or the foreclosure letter, or I'm sorry, not the foreclosure letter, that was through Ryan Bangert, outside counsel. So every other instance was my weekly meetings with Jeff Mateer and Ryan Bangert. And I never called the Attorney General. He always called me.
I appreciate your answer, but that was not really what I asked. So let me try again. Don't you think you owed the Attorney General of the state of Texas at least a phone call before you reported him to the FBI without any evidence? Yes or no? That's not the way it worked? Yes or no?
Would you like me to answer?
Yes, I would.
Based on our conversations with Mr. Mateer and Mr. Bangert, they were having conversations directly with General Paxton. I was not part of those conversations. So any concerns that they had raised with him would have been in their conversations. I had no reason to call him directly.
Object not responsive.
Sustain.
Let me try this again, Mr. Vassar. Don't you think you personally, Ryan Vassar, don't you think you owed the Attorney General of the state of Texas, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence, sir?
I was appalled at the time, so.
Object non-responsive.
Sustain.
I object to the continued interruption of the answer. If he doesn't like the answers he's getting, he can then object to it being non-responsive. But jumping in the middle of this, man, is totally unfair, and I object.
I will listen more closely, Counselor. I have not heard him interrupt him. I will listen more closely so the witness can finish his answer and you can do a follow-up question.
Vassar, my question was, don't you think you personally owed Attorney General Ken Paxton, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence? Yes or no? No, I don't. Yes, I do.
Well, I would disagree that we didn't have any evidence just based on our beliefs, but I don't think I owed General Paxton anything.
Don't? You worked for him for 5 years.
That's right, and I believed in him.
He gave you a job, correct?
He did. And promotion.
And a promotion, huh? Not enough to warrant a phone call before you report him to the FBI, though. True?
Like I said,
Do you wish you could go back and call him?
I'm sorry,
Do you wish you could go back in time and call Ken Paxton and talk to him before you reported him to the FBI without any evidence?
I wouldn't do anything else differently.
Interesting. Okay. You don't know anything about Ken Paxton's campaign donations from 2018, do you?
No, sir, I don't.
You didn't work on the Mitty Foundation case, did you?
No, sir.
When you went to the FBI, did you have Ken Paxton's phone number, at least? Could you call him on his cell phone? Did you have the number?
I believe I had his phone number in my phone. Yes, sir.
How'd you get it?
I think he gave it to me.
Why?
Just based on working with him and questions that he would call me with.
So you could call him if you needed something, so he could call you if you needed something, right?
That could be an option, just based on a cell phone use.
You even had his secret email address, didn't you?
I'm not sure which one is.
Well, there is an email that's already entered into evidence in this case. It's ag.wkp@protonmail.com. Have you seen it?
Yes.
He gave it to you, right?
Yes.
Did you email him on his secret email address? Tell him that you were going to go and report him to the FBI without any evidence?
No, sir.
Why not?
It didn't occur to me.
Didn't occur to you. At some point since then, has it occurred to you that maybe you should have done that?
No, sir.
How secret could this email address have really been, Mr. Vassar, if you had it?
I don't know exactly.
Do you consider yourself a close confidant of the Attorney General?
No, sir.
Do you think you're the only person that had that email address?
I have no reason to believe that I was the only one.
So this gentle, kind man, was he attentive to your concerns when you talked to him in the office? Talked to him on the phone?
Sure.
Gentle, he's kind, he's attentive. And at what point in time did the weight of what you were doing in reporting this gentle, kind, attentive man to the FBI become apparent to you?
On September 29th.
When you walked in there?
Walked in where?
To the FBI.
No, that was September 30th.
Okay. So what happened on September 29th when the great weight of having to report this gentle, kind, attentive boss struck you? What was going on?
September 29th, I was in a meeting, just a division meeting with Lacey Mays, and she received a text message on her phone from an individual that I did not recognize, and the individual asked if a Brandon Kamek was working for our office.
And you knew exactly who that was, didn't you?
Yes, I recognized the name.
And what happened in your mind was you realized this contract didn't work its way all the way through the executive action memorandum process. True?
Among other things, yes. That's a thought that went through my mind.
Yes, and the rest of that thought is, if that process has not been completed, he has no authority to work on behalf of the Office of the Attorney General, correct?
Yes.
And that was alarming to you, true?
In addition to the fact that he was acting in a capacity that he didn't have, even if a contract had existed at the time.
And in that moment, did you call General Paxton and say, Brandon Kamak's working, what's going on?
No, sir.
Do you think it's possible? Is there room in your mind for the possibility that if you had called Ken Paxton and told him that information, Ken Paxton would have said, yeah, Ryan, I signed the contract. with my own hand, with my own pen. Is there room in your mind for the possibility that that would have happened?
Well, it is possible, but he was out of the state at that time. So I wouldn't have been connected to him or had a reason to call him.
You had his phone number. So what if he was out of the state? Cell phone works out of the state, surely, right?
Yes, sir.
You didn't think to call him?
Well, as I explained, because he was out of state, Jeff Mateer was running the office.
That's another thing we're going to get to, okay? My understanding is your belief was that while Ken Paxton was in Ohio working on the Google case, the biggest case that the Office of the Attorney General had, Jeff Mateer was the acting Attorney General, right?
That's correct, although my understanding, in addition to
I'm going to object as non-responsive to the remainder of this answer.
Sustained.
Mr. Vassar, can it possibly be in a state with as many millions of people as Texas has, that it is the belief of the upper echelon of the Attorney General's office that anytime the Attorney General gets on the plane, Jeff Mateer is the real Attorney General?
only to the extent the government code is triggered. That's what deputizes the first assistant to act under the authority of the Attorney General.
And your belief was that on September 29th and 30th, when Ken Paxton was in Ohio doing business on behalf of the people of the great state of Texas, litigation business, very important litigation business, that someone else was the Attorney General, and that's what the government code says. Is that right?
Well, it was my understanding it was a political event. It was a campaign event. I had no knowledge that he was working on the Google case.
He was doing a campaign event in Ohio?
That was my understanding at the time.
Where on earth did you get that?
Just conversations at the time with Mr. Mateer.
So if he was on, let's say he was in Ohio on a campaign event, Jeff Mateer's the Attorney General while he's there?
I was just clarifying my understanding based on your question. Your next question of whether Jeff Mateer is the acting Attorney General, again, that would depend on the statute. The statute provides if the Attorney General is absent or unable to act, the first assistant shall perform the duties.
Tell the senators what absent means.
The statute doesn't define it.
Tell me what you think it means.
Well,
out of the state?
It would mean the ordinary meaning of the word under a statutory interpretation approach.
Tell these senators, many of whom are very accomplished attorneys, what the word absent means to your understanding, please.
I am not advised of what the dictionary definition would be. That would be an interpretive guide. Absent could mean out of state. Absent or unable to act could mean incapacitated.
Like if Ken Paxton was on life support in a hospital somewhere, for example.
I presume so.
But he wasn't. He was in Ohio, which I guess is debatable one way or the other.
I'm not aware if that statute has ever been interpreted by a court. So I could not be able to say.
But in any event, it provides the perfect cover for someone in your office to remove Ken Paxton's name for the letterhead and begin sending out letters on behalf of the Attorney General of the state of Texas. True?
No, nobody removed his name from letterhead.
You don't think so?
No, sir.
Have you ever seen Attorney General's office letterhead without Ken Paxton's name on it?
All the time.
All the time?
Yes, sir.
How did correspondence in September of 2020 come to be sent to parties outside of the Attorney General's office without Ken Paxton's name on it? Tell us.
Well, the agency has different letterhead. There probably even today, letterhead that's available on the Attorney General's website that does not have his name on it. So, letterhead that he signed.
I see. So when the Attorney General is absent in Ohio, someone at the office goes, grab me the letterhead without Ken Paxton's name on it. He's in Ohio today. Is that right?
I don't recall any decision about using this letterhead or who instructed the use of the letterhead.
No one decided, it just happened, right?
Like I said, I don't recall any decision about it. The agency has different letterhead that exists today.
You're familiar with the Mitty Foundation now, right?
I've heard of it, yes, but
You've been an attorney how long?
I was licensed in 2012, so 11 years.
You said your family goes to a Baptist church, right?
Yes, sir.
Okay, that Baptist church is organized as a nonprofit, right?
Yes, sir.
And at some point in time, I'm sure you've given money to a charity, correct?
Yes, sir.
I got to ask you something that's just been really bothering me, and I know I'm not the only one. What in the heck is a charity doing making a multi-million-dollar private equity investment with Nate Paul with charitable funds? Any thoughts on that?
I'm not sure. I don't know.
You ever ask anybody?
No, I was not involved in the Mitty case, was never consulted on it or provided any advice for it.
Do you know, maybe you do you know of any charities that make multi-million-dollar private equity real estate deals with charitable funds?
I have no personal knowledge.
Okay. Do you recall giving testimony to the House Board of Managers and being questioned on video by Aaron Epley, Brian Benkin, and Therese Buse?
Yes, sir, I remember.
But they never put you under oath, did they?
Not that I recall.
Did that kind of surprise you?
I didn't think anything of it.
Did you ask why not?
I don't know. I don't think I did.
Well, just because you weren't, well, you are an attorney, obviously. Just because you weren't under oath doesn't mean that you didn't tell them the truth, the whole truth, and nothing but the truth, so help you God. True?
That's right.
Did you review your statement in preparation for this historic trial?
No, I consulted with my attorneys, and that was it.
Did anyone give you a copy of it?
A copy of my statement?
Yes.
No, sir.
So anything that you said in that testimony, I guess we can call it testimony, anything you said in that testimony that's recorded, we can take as the gospel truth, right? Yes?
Just based on my telling the truth, is that what you're asking?
Yes.
Yes, sir.
We can take it as being true, yes?
Yes, sir.
Okay. Have you ever, before today, have you ever in your life been asked to give testimony as a witness without being sworn?
I don't recall. I've been a resource witness to many Senate and committee hearings, but I don't recall if there's an oath administered to a resource witness. So I apologize.
Have you ever given sworn testimony anywhere before today?
No, I don't think so.
It's a tough first outing, isn't it? Mr. Arroyo, if you would, Article 1 of impeachment, please. Can you see Article 1 on your screen, sir?
Yes, sir.
You don't know anything about this, do you?
No, this would be the Mitty Foundation matter.
And just to be clear, have you looked at Chapter 123 of the Property Code to determine what the Office of the Attorney General's obligations are with regard to charities in the state?
No, sir.
Don't know anything about that, do you?
No, sir.
All right. Mr. Arroyo, Article 2, if you would. Now, Mr. Vassar, you've given some testimony about what we'll call the foreclosure opinion, right? It was issued August 1.
Yes, sir.
Issued August 1 of 2020. Yes?
Yes, I believe that's right. It was a Sunday.
That opinion was not a legal opinion under Subchapter C, Chapter 402 of the Government Code, was it?
Yes, it was A legal opinion under subchapter 402.
It was?
Yes, sir.
That's not what you told the House Board of Managers. What did you tell them?
I don't recall.
We'll get to that later, but that's not what you told them, is it?
I don't recall. I may have misstated.
You may have misstated.
If you're saying that's not what I said, and my testimony today is that there's no other statutory authority except for Chapter 418 of the Disaster Act to issue a legal authority, to issue a legal opinion by the Office of the Attorney General. So it either has to be Chapter 402 or it has to be Chapter 418.
But we know this is not 402 because it says on the face of the foreclosure opinion that it is not under 402, correct?
It does say that it's not, but that doesn't mean it doesn't fall under the authority of that chapter. It just means it wasn't written in accordance with the typical legal opinion process.
I was hoping that we would be able to have a chance to discuss this. Mr. Arroyo, please bring up chapter or section 402.042 of the Texas Government Code. No, we're looking for 042. That's 0.212. We'll get to that later. Thank you. While Mr. Arroyo is bringing this up, I've got a couple questions for you about that. In order for the foreclosure opinion to have been authorized under Chapter 402 of the Government Code, Mr. Vassar, certain criteria need to be met. Is that correct?
I believe so.
There first needs to be an authorized requester, correct?
That's correct.
Who are the types of persons who are authorized to make that request?
The governor, the lieutenant governor, the speaker, chairman, and chair people of committees of the House and of the Senate, executive heads of agencies, and county and district attorneys.
Did any of those people request the foreclosure opinion?
Yes, sir.
Okay. What is the next criteria to satisfy for Chapter 402 of the Government Code?
You're going to have to refresh my recollection.
All right, Mr. Arroyo, if you would move to the second page of that PDF that you just had up. There you go. If you could just highlight the text at the top, that big chunk of text there. A little bit lower. Thank you so much, and just blow that up for us. Let's look at item C, okay? You're a lawyer. We can read this together, right? Right?
Yes, sir.
Okay, guys.
It says a request for an opinion must be in writing.
Get started with what they're doing. I'm not sure.
4th, 2020 was the first Tuesday
All right,
of the
guys.
month. Would you believe me?
Now we are live.
That sounds
This is not
right.
a recap. Let me take this recap thing off. We are live. This is happening.
Let's go
as
back to
we
Exhibit
speak.
AG 170, which is this text thread here, if you would. Let's continue on.
This
Blake
is
Brickman
live
responds
coverage.
to you. Mr. Arroyo, can you bring that back up for me? We're at page Brickman 198 for the ladies and gentlemen.
Now,
of the jury.
I will very likely switch over because I have to go to work here for a couple of hours. So I will very likely switch over to RSBN's live stream so as to not so as to avoid any interruptions, because every time they take a break, they actually
And
stop
if
the
you
feed.
look, Mr. Arroyo, if you can zoom in on the blue text at the very bottom.
RSBN will allow me to continue streaming without any stops to the feed.
Blake
but
Brickman responds, obviously just a coincidence, right? LOL. And then he had the audacity to thank the office publicly at deputies meeting later that week for stopping foreclosure on individual homes. The man is a pathological liar. Do you see that?
Yes, sir. I see
Okay.
that.
Next page.
So thank
Mr.
you guys for
McCarty
being here.
responds, all about the people. And David Maxwell responds, all about himself. Then there are a series of additional articles that are being posted to this group chat. Why are you on a group chat in October of 2020?
Because
anyway?
they're gossip queens.
We were all friends. We were all colleagues.
Bunch of mean girls.
We all enjoyed working together, so this was just a group thread where we talked.
Are mutinies fun? Tell us.
If you would, Mr. Arroyo, would you bring it forward to page Brickman 200? In the middle of the page.
Counselor, hold on one second. You're a little ahead of the.
Oh, I am.
Okay, it's up now. I want to be sure it's up for the jurors to read when you're quoting it.
Thank you, Mr. President. Mr. Arroyo, if you could zoom in on Ryan Vassar's text at the middle of that page. Yes, Mr. Vassar, thank you. Not quite so close, Eric, if you would. Just capture those two texts from
Eric,
Ryan Vassar in the middle of the page,
much.
the one above that too. Thank you, Mr. Arroyo. Now, Mr. Vassar, you linked to a tweet from Lauren McGaughy on, it looks like October 25. Is that right?
I don't. Yes, it's a link to a tweet. I don't see anything about an October date, but oh, you're talking about the date that it was sent.
Yeah, it may be October 26 because
Yeah,
we're on that same thread.
yeah. If it's chronologically just with the pages, the page before Brickman 199 ends on 1026, so it could have been 1026 earlier in the day.
And you write hashtag Soul Survivor. What does that mean?
I'm not sure if it was referring to the tweet that I was referencing. It could have been an indication that I was the last remaining whistleblower who was still employed by the office.
I see. And if we can continue on in that thread, Mr. Arroyo, zoom in on the next three texts in that thread, please. Not Mr. Arroyo, just right under the date stamp, if you would, please. Good man, thank you. All right. On October 26th at about 5:55 p.m., Ryan Bangert writes, yep. And Ryan Bangert writes, BW, that's Brent Webster, right?
Yes, sir.
BW just dropped by my, and just to be clear for ladies and gentlemen of the jury, hopefully everyone knows, but Brent Webster is the then current First Assistant Attorney General, true?
Yes, sir.
It says, Brent Webster just dropped by my office to inform me of an org chart change. I will no longer be overseeing special litigation because it will now report directly to him. And you respond, what a joke, right?
Yes, sir.
And David Maxwell responds, that's a train wreck waiting to happen. Ryan Bangert says, let him have it. And Blake Brickman writes, he is a joke. Yes?
Yes, sir.
Let's continue to the next page. If you can give me, Mr. Arroyo, maybe the gray text at the top, we'll go piece by piece. No, maybe the first 6 gray texts so we can just all see them together, if you could. Thank you. Ryan Bangert says, it will run itself. My fear is that he will force them to do crazy expletive. Is that typically how Ryan Bangert would talk?
No, sir.
Lacey Mace says, I find that absolutely hilarious. Darren McCarty says, perfect. I've been trying to figure out how to get Patrick and Disher to join my new law firm. Is Darren McCarty one of the so-called whistleblowers?
Yes, sir.
Has he filed a lawsuit with you?
No, sir.
Hello, everybody on Pilled,
He
Truett,
just got out of the
Victoria.
OAG's
Thank you for the
office and
can,
hung out a
Victoria.
shingle, it sounds like,
Stacks
right?
Osru.
That's my understanding.
Okay.
Good morning.
Ryan Bangert says,
Lord
maybe Aaron
Tay.
can help. I'm
How
sure
are you?
Patrick and Dish
Uncensored
will love
A.
being managed by a failed prosecutor and a third-year lawyer.
Whoa.
That's what Ryan Bangert wrote about his coworkers. Yes?
Whoa.
I'm sorry, say that again. Ryan Bangert.
That's what Ryan Bangert wrote about his coworkers. Yes? His colleagues. Yes?
Yes.
Good morning,
And there's a
Vicky.
like
Good morning,
from
Hunter
Ryan
Sabo
Bangert,
over on
and you
Rumble.
write, Patrick and Dish will need to start using smaller words in their pleadings. That's what you wrote, right?
Yes, sir.
Wow.
You're
These
insulting
people-
your colleagues on this familiar group chat. Yes? Among friends. Yes?
It was a very
Object non-responsive.
Witness shall answer yes or no.
You are, I'm sorry, I'll ask it again. You are insulting your colleagues on this group chat among friends, true?
I wouldn't describe it as insulting.
Well, I would.
Witness will answer yes or no.
The way that you phrased it, no, sir.
Okay, he's lying. It very obviously.
What did you
like,
mean?
Seriously, guys?
First of all, just tell the ladies and gentlemen of the jury, who are Patrick and Dish?
Patrick Sweeten was in the Special Litigation Division, and Todd Disher was also in the Special Litigation Division.
And so I want to make sure the jury understands the implication of what you're saying. The implication is that Patrick and, is it Todd?
Yes, sir.
Patrick and Todd are going to need to use smaller words because their new colleagues at the Attorney General's office wouldn't understand it if they use big words, right?
That's the implication.
That is, as they say, the joke, right?
Yes, sir.
You were being funny, right?
Yes, sir.
At their expense.
If we could move down to the remainder of the page,
Insulting
Mr. Arroyo.
and belittling them. But no, he wasn't insulting them. No, not the way you say it. Why
Blake
would you
Brickman
say it like
says
that?
the agency is going to fall apart, and that is one person's fault and one person only, KP, right?
Yes, I see that.
In point of fact, the agency did not fall apart.
I see they were scapegoating Paxton,
I haven't followed it.
the duly elected Attorney
wouldn't
General,
know.
their boss.
Lacey Mace laughs and says, or she laughs at your joke. And she says, I would love to be a fly in the wall during the special lit meetings. Can you even imagine? 4 laughing emojis, right?
Yes, sir.
And you deleted all these texts, I guess, by just a policy on your personal phone, true?
Sure.
The way that you phrased it, no, sir, I did not delete them.
What?
Well, you had a setting on your phone that deleted them, yes?
That's right.
You didn't think they might be necessary or needed later, right?
That's not true.
Wait,
You post a link to Amazon below that. And what is that link to?
The title is a coloring book, it looks like.
Oh my gosh, is it mine?
And the text below that says, from you, they might need some activities to keep the kids entertained, right?
Yes, sir.
You are suggesting, are you not, Mr. Vassar, that your colleagues, professional lawyers at the Office of Attorney General, might need a coloring book to stay entertained? That's what you're suggesting?
I would describe them as colleagues. I had no professional experience with them other than just the knowledge that they were new lawyers.
You didn't have any experience with the people that you are saying that might need coloring books to keep themselves entertained at the Office of Attorney General. Is that true?
That's correct. It was a joke.
I believe you when
It
you
was a
say
joke.
that. I believe when he says he has no experience with them, but he still ran his mouth
I
about
believe
him.
earlier your testimony was that being called a rogue employee was very upsetting to you, right?
Yes, sir.
But this is how you talk about your coworkers.
It's true. It's true.
Again, it was lighthearted. It was among friends.
That was not
made
lighthearted.
public to millions of people.
No one was ever supposed
You
to
never
see
thought it would,
and
did you?
certainly not the people of Texas who are watching this impeachment proceeding, right? No one was ever supposed to see this.
No one was hiding
private.
it. I'm sorry.
It was private, right?
Well, it was a conversation among friends, but I wouldn't say that any of us are concerned that it's being discussed here today.
Really?
Are you proud of this?
No, sir. That's not what I said.
No, I'm asking you now. Are you proud of this?
No. No, sir.
Let's turn the page.
Because there's more.
You could give me all the gray ones at the top, Mr. Arroyo, or just the first 6 texts so we can see it in context.
Destruction of records.
Lacey Mace says, ha 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 ha, in response to your text, and David Maxwell posts a laughing emoji, right? This is,
We're all
everyone's joking,
laughing
having
here.
a good time on this text thread.
We're all having
right?
a good time now.
Sure.
Nobody's appreciating the somber moment of being FBI whistleblowers at least at this time on October 26th, right?
Well, we had all been through a lot by that point, and I suppose people process things in different ways.
Gallows humor, perhaps, right?
Yes, sir.
Okay. David Maxwell says, my phone conference with Margaret Moore and her team went well
Brian,
today.
yes, this
They
is
are
live.
excited about pursuing this
Earlier was a
investigation
recap. This is
and will
live.
coordinate their efforts with the U.S. Attorney's Office so that both pursuits complement each other. Who's Margaret Moore?
She was the previous Travis County District Attorney.
So David Maxwell is calling the Travis County District Attorney at the time and the U.S. Attorney's Office, and everybody is getting fired up. They're getting excited about prosecuting Ken Paxton, right?
That appears to be what he is saying.
Next sentence says, they obviously want to move quickly as they have time constraints. They are not going to wait on the feds. What does that mean?
Wow.
You have to ask Director Maxwell.
Oh
I'm
my
not sure what that
gosh.
means.
What do you
No.
think it means?
Objection to him being asked to speculate what it means, Your
Good
Honor. He
objection.
doesn't know. He doesn't know. and he didn't
Sustained.
know.
Thank you. I withdraw it. Now, if you look down in the rest of the thread, it says, so you know, this is Ryan Banger, so you know I tender my resignation today, effective November 4th. Darren McCarty says, thanks for letting us know. David Maxwell says, no, I didn't. Just got done at FBI. Went great. I'm staying until he fires me. We'll keep y'all posted on progress, right?
Wow.
Yes, sir. I see that.
At this time, are you hoping to retain your job?
Yes, sir. I was still on investigative leave at the time.
Yes. And you're hoping to retain your job?
Yes, sir.
And ultimately, you came back to the office and talked to Brent Webster, yes?
That's right.
And you said to Brent Webster in that meeting that you still trusted the Attorney General, correct?
I believe so. I don't recall exactly what I said to Mr. Webster about trusting the Attorney General. I think what Mr. Webster asked.
Can you hold one moment? We'll stand at ease for 30 minutes.
Yes, Your Honor.
Okay, you guys. So they're going to take a break real quick. So let's go and see what's going on in the chats. Pilled and Foxhole chats are lit up. Is it low? Is the volume low? Let me turn the volume up if I can. Hang on. Let me see if I can. Volume's as high as it's going here. Y'all give me a 5x5. If the volume's low, I'll try to fix that. I'm not sure if I can. Yes, he does look like he's about to cry. Over on Rumble, Brian says he's gonna cry. He does look like he's gonna cry. RSBN is not live in my town. Thanks for broadcasting, Mexico Audit Force. Yeah, absolutely. So I'm gonna pull up RSBN because I've got to go to work soon, and like I said, RSBN, to my knowledge, is the only other one streaming this. Well, there's KHOU 11, but they're not Patriot run. Let's see if they're going to be doing this. Day 3. I mean, if KHOU 11 is the only one streaming it, then I'll do that. I'll watch that, but let me see. Oh, so okay, so RSBN is going to be streaming a Trump rally, or no, it's a football game, a college football game, and they're going to be streaming that. So I think what I will do is actually have to go with the KHOU 11, which is a Houston-based thing. Let me see if this is going to work. All right, guys. Thank you guys for being here. If you'll please like and share this out and leave comments if you have any questions. Also, you can check out our website, takingbacktexas.org. We've been live streaming the Paxton impeachment with some commentary. In the evenings, I've had to go, so I've been recapping the last hour to 2 hours in the mornings the past 2 days. So I did that again today, and I will have to go to work, so I'm going to be broadcasting. I'm going to be connecting another live stream of this to mine, so y'all don't have to go everywhere to try to find it. You can still watch it here, even though I won't be able to give commentary for a couple of hours, probably from about 10:30 until about 2:30. It's a few hours. I won't be able to give commentary, but I'll be able to watch and listen a little bit. So y'all feel free to light up the chat over on Rumble and over on Pilled and Foxhole. Okay. Thank you so much for the 5x5. Okay, good. Now, I can't adjust the volume on the Senate broadcast. I can adjust it on this KHOU 11 broadcast. So as soon as they're done with, as soon as they come back, now it's a 30-minute break at this point. So what we can do is we can say, we can go over all of the articles that have been debunked so far. So we can do that. So these are all of the articles, and we went over a few of these yesterday as they were debunking them. Paxton's team is badass. I've rarely been actually impressed by attorneys, but good Lord, Busby was devastating to the first witness. The young man that they had questioning the second witness yesterday, very dashing. I loved his suit. We all thought he was very handsome. And he was good. He was much younger than Busby, and I don't mean that by any offense. I think Busby's like amazing. He was younger, and I actually kind of underestimate young attorneys. I tend to, which I shouldn't do, but he was amazing. Like, he did great. This attorney, at the end of the day yesterday, this attorney is doing a really good job too. They're all good. So Article 1, can y'all see this? Y'all can see. Oh wait, maybe if I put it on screen, y'all can see it. Sorry, I'm not as good. Diddy is the one that learned how to do all of this, and I'm still catching up on this. My priority is securing Texas, is taking Texas back. All right, so that's why we're taking back Texas, takingbacktexas.org. That's why we trained so many poll watchers in so many counties. That's why we have so many reports. Actually, I have to call somebody back here. Just a moment ago, I missed a call from a very important patriot. And if you're watching, I will call you right back. I just had to get this going because I had not the best series of events this morning. So I got pulled away from the live stream. So just trying to maintain this. Anywho, Article 1, which by my account and by honestly, like the accounts of most people watching, Article 1's been debunked because the whole concept was that they say, oh, disregard of official duty, protection of charitable organization. They say specifically Paxton caused employees of his office to intervene in a lawsuit brought by the Roy F. and Joanne Cole Mitty Foundation against, can y'all see that? Go away, y'all. Do y'all mind stop not showing my emails to everybody? Can y'all see that as it's popping up? Oh, good. Okay, never mind. Y'all can't see my pop-ups. I'm still learning how computers work. This is why we can't have computers running our election. The average American should be able to explain to their child how our ballots are cast, counted, tabulated, and stored and reported. We should be able to understand all of that. All right. I can't even figure StreamYard out half the time. So they say that Paxton caused employees of his office to intervene in a lawsuit. The intervention was signed off on and approved by the very whistleblowers who helped draft these articles of impeachment. Everybody signed off on this. This was not something that Paxton did rogue, and this was not something that Paxton forced upon any of his employees. It's just something that they did. So the truth is that the deep state's been going against this man, Nate Paul. And as we learned yesterday, Nate Paul is a young real estate tycoon who's snagged up a bunch of very valuable properties down in Austin. Now, there's some sort of, and a high quality question was asked earlier, there's some sort of involvement between this charitable organization, and I'm using air quotes, the Mitty Foundation, and Nate Paul's multi-billion dollar investment, real estate investments. There's a really high quality question asked earlier. What is the connection there? What is this charitable organization that y'all are alleging Ken Paxton failed to protect? What is their interest in this, in these multi-billion dollar real estate investments with Nate Paul? Why is there even a lawsuit going on here? Okay, let's look into that. Maybe we should look into what they've been doing to Nate Paul, because they're very obviously trying to build a connection between Paxton and Nate Paul and use this to bring them both down. Anyways, Article 1 was debunked because everyone in the office signed off on the intervention, including the whistleblowers. Very funny. Article 2, abuse of the opinion process. Specifically, Paxton caused employees of his office to prepare an opinion in an attempt to avoid the impending foreclosure sales of properties belonging to Nate Paul or businesses controlled by Paul. Again, we reviewed this, as did the Young attorney yesterday, in detail, and he did a very good job pointing out that this was a statewide and nationwide issue. Governor Abbott was involved in halting foreclosure sales. Trump was talking about halting foreclosure sales. Everybody halted foreclosure sales because so many people lost our jobs and our money. So many people were unable to pay their rent. I can't even imagine how difficult it was. Because if I was in the financial position that I'm in right now during COVID, I would have been on the street. I would have been so screwed. I would have had to have left the apartment and moved in with somebody that would have let me stay there for almost nothing. Me and my child. So it was extremely important for them to protect people that lost their money due to a government mandate, right? But they're trying to make this connection that Paxton issued an opinion which was congruent with Abbott's opinion, which was congruent with Trump's opinion, which was congruent with policies that were being enacted by the executive branch in both state and federal governments. Everybody was talking about this. So this was not something that he did for Nate Paul. Absolutely ridiculous that they would put that into an article of impeachment. Absolutely not. They benefited, I'll tell you, more people than Nate Paul were benefited by this foreclosure sales halt. Everyday blue-collar Americans benefited from this. Okay? Bastards that they put this in there. Article 3. They say specifically, Paxton directed employees of his office to act contrary to law by refusing to render a proper decision relating to a public information request for records held by the Department of Public Safety and by issuing a decision involving another public information request that was contrary to law and applicable legal precedent. It's not contrary to law. None of this was contrary to law, what he did. When someone asks for open records, the Attorney General usually will give them to them. They have to make a ruling. If the county or whoever the entity that the citizen has requested records from thinks that these records are not covered by the Public Information Act, they're not allowed to deny you. They can't tell you, no, I'm not giving you those records until they talk to the Attorney General. And the Attorney General has to back them up and say, yeah, those records are not covered by the Public Information Act. Those are protected from disclosure. If, however, the Attorney General says, those are public records, you better give them to him, then the entity has a certain time frame in which to produce the records and make them available to the requester. So this is just them being mad at the way that Paxton handled some of these open records requests that his underlings wanted to deny people. Paxton's the duly elected Attorney General, not these little rats underneath him organizing a fucking mutiny. Article 4 says specifically Paxton improperly obtained access to information held by his office that had not been publicly disclosed for the purpose of providing the information to the benefit of Nate Paul. Again, not a crime. Nate Paul asked for public records. Paxton grabbed the records and provided them to him. Now they're saying he shouldn't have given him that because there's sensitive information in those records. Okay, a probable cause warrant, which is what Paxton was asking for, which is what Paul was asking for. The warrant, which he should have been presented at the initially, right? Article 5. So Article 4 has been debunked. Article 5. Specifically, Paxton engaged Brandon Kamick, a licensed attorney, to conduct an investigation into a baseless complaint during which Kamick issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. Okay, as we see, these attorneys are big mad that Paxton hired Brandon Kamick to investigate what they are now saying is a baseless complaint, but which they initially signed off on the intervention. So that the baseless complaint is part of the intervention. They're looking into stuff that's going on. They're saying that he engaged Brandon Kamick and that he didn't have the authority to do that. He absolutely has the authority to do that. He's the Attorney General. He's the duly elected Attorney General. There's no statute that says that he doesn't have the ability to do that. This is actually inherently in his power. They're just mad because once they approved to look into this baseless complaint, he didn't assign them to do it. These people that are already calling this complaint baseless, can you imagine why? Paxton didn't want to assign them to look into it because they'd already made up their minds. It's no question at all. If you've been watching the past few days impeachment with these whistleblowers, I'm using air quotes, because these are not Assange whistleblowers. These are like Vindman whistleblowers. Real pieces of shit, right? They were mad because they wanted to be assigned to investigate this. They're very mad that Brandon Kamek was there because I don't know. I can only assume that they wanted to run the investigation their way to come to their conclusion, which they'd reached before the investigation. It's no mystery to anybody why Paxton decided to hire outside counsel to conduct this investigation into this complaint. Was not the complaint dealing with how the lawsuit was being handled by the OAG? I bet it was. But Article 6. Specifically, Paxton terminated employees of his office who made good faith reports on his unlawful actions to law enforcement authorities. Good faith reports. Paxton terminated the employees without good cause or due process. In Texas, you don't need a reason to fire somebody. I can fire you because I don't like how you look. I don't like how you smell. I don't like how you tap your pencil on the desk. Get out of my business. You don't need a reason in Texas to fire somebody. But let me tell you, organizing a mutiny is going to get you fired even at the Costco. Look, try this at Costco and see if you keep your job there. Paxton terminated the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. Let's talk about a good faith report, because they say employees of his office who made a good faith report were fired. How can you make a good faith report with no evidence and without talking to the Attorney General? I think if they know that if they spoke to the Attorney General, they wouldn't be able to say that they weren't aware of this exculpatory information. So it's better for them that they just don't talk to the AG at all, play stupid, and they can all take care of everything in post-production. You know what I'm saying? So Article 7. So anyways, this has been debunked because it also says Paxton engaged in a public and private campaign to impugn the employees' professional reputations or prejudice their future employment. None of them have had any jobs finding employment. None of them. They're all employed, and so this whole thing has been debunked yesterday. Paxton did not engage in a public or private campaign. And he did not terminate any of them. It says Paxton terminated employees. Absolutely not. We proved yesterday these fools all resigned. They all admitted to it. And this one idiot on the stand, the second witness, y'all all saw that yesterday, was saying that, yeah, he resigned, but he was also fired. It's like, no. Did you resign or were you fired? I was constructively dismissed, is what he was saying, because he said that Paxton took away some of his responsibilities. So he chose to resign. Paxton did not tell him you're going to be fired, did not say good luck getting another job. Paxton didn't say anything. He just took some responsibilities away from that guy, some things that he was handling. And I don't blame Paxton one bit. Right? I don't think anybody blames Paxton for taking that away from him. So they weren't fired. None of them were. None of them were fired. But they put this into the articles of impeachment. They also lied on stage. They would say in one breath, they would say, yeah, I resigned. And in the very next breath, I resigned because he fired me. That's not how any of this works. Okay? I unfriend you. All right? So Article 7 says specifically Paxton directed employees of his office to conduct a sham investigation into whistleblower complaints. So the investigation was a sham? Made by employees whom Paxton had terminated, and to create and publish a lengthy written report containing false or misleading statements in Paxton's defense. No, he looked into the mutiny, all right, and he wrote a report about it. That's not an impeachable offense either. Sham investigation into whistleblower complaints? No. A real investigation into an actual mutiny against the duly elected Attorney General. Article 8. Specifically, Paxton entered into a settlement agreement with the whistleblowers that provides for payment of the settlement from public funds. Settlement agreement stayed the wrongful termination suit, conspicuously delayed the discovery of facts, blah, 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 which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. I don't know. We'll see about all of this. We'll see about all this. How many mutinies were actually happening in his office? How many times has the deep state come in and tried to screw stuff up? I wonder. I wonder how many times. So they entered into a settlement, which the whistleblowers accepted. What was he supposed to do? They're mad because he what? They're mad because they entered into a settlement agreement, which delayed what they really wanted, which was a conviction, but they couldn't get that since the whistleblowers settled. They accepted the settlement agreement. Ken Paxton asks for it to be funded through public funds because it was, what is he supposed to pay it himself? That's not what it was. It was the office of the OAG settled with the whistleblowers. The office of the OAG is funded with tax dollars. Ken Paxton's not propping that whole thing up on his own. That's absolutely nuts. He's money mover, but he's not propping that whole office up with his own bank account. There's money allocated to them. So, oh my gosh, he asked for it to be for public funds to be allocated for the payment that they agreed to. So, anyways, Article 9. So all of these, we're going to debunk all of these one by one. But basically, I would say everything between, I would say Articles 1 through 6. I would say at least 1 through 5 definitely have been solidly debunked. Also is the young attorney's name. Right. So I would say so far, five articles, in my opinion, have been thoroughly debunked. I think they're going to continue to debunk them with every single witness. So that's good. C-SPAN was covering it, but they probably, I mean, so here's the issue with the Senate. It's really annoying because when they cut the feed, when the Senate goes on break, they're like cutting the feed. And every time they come back, we have to start the feed up again, which is a pain in the butt, which is why I'm going to just be streaming like KHOU. Because I'm just hoping that they won't have the break and it'll just be continuous. You know what I mean? So we'll see. Right now, they're still out at break right now. So they said 30 minutes. Looks like right before I have to go to work, they'll come back on. So we'll see what we can do. Anyways, what do y'all think? You think the deep state, you think they're going to be successful? Anyway, so C-SPAN probably just stopped covering it because the feed might have been cut or they're just on break. But if C-SPAN is covering it, that'd be great. I just don't want to deal with all of the cuts, Yes, Anthony also is excellent attorney. And what's this attorney's name? I don't have this current attorney's name, but he's doing excellent as well. Yeah, they just started. Now a 30-minute break. Yeah, it was pretty early for a 30-minute break. I agree. Pretty early for that. All right, guys. If you'll look right over here, this is our website. Okay? And I'm still updating it. I'm going to revamp the website, but it's not ready yet. Okay? But if you'll go over here, you can scroll all the way down to this drop-down menu, Public Information Act, right here. Okay? It's on the drop-down menu. This is supposed to say more, but for some reason, half my website is in Spanish, and I do not know why. I've done so many things trying to figure it out. I don't know why half my website's in Spanish. And I'm from Texas, so like it took me a minute to notice that. We're kind of used to like everything being half in Spanish. But I mean, I guess it's fine. It's it's whatever. Click on Public Information Act. This is a concise 17-point review. All right, and a little note up here that in Texas, you should not be charged more than $50 per request, per the Texas Election Code 1.012E, and always include that in your request. So there, you can download this PDF, but so the second page is just blank. Everything's on the first page. Let me see if I can zoom in. Can y'all see this? And this, you know, this has to do with some of the articles of impeachment, is that he's kind of screwed up the Public Information Act. But you can read through here, read these 17 points, right? So I've sorted them into little areas. So there's drafting your request, right? There's timeline for agencies to respond, and then there's what to expect. Like after, once you get a response, these are the varying responses you might get. And then I have little sidebars over here. Information is presumed open for the most part. When drafting a request, understand that all information is presumed open, so you should be confident in requesting copies. Be clear and reasonable and expect to pay a small fee for physical copies. However, if you can use digital files, and be sure to request the information be sent digitally. Sometimes they have like if you want a contract, for example, they'll have that scanned. So instead of paying for them to print like 50 pages of a contract, and they're going to charge you for that, right? They're capped at $50 if it's an election record, but other records they can charge you more. So that's an example of something that I would say, you can send me that digitally. I'll read the contract. You can send me the contract digitally, right? For free, most of the time for free. Then we want to time your request accordingly. If you're operating under a time constraint, be sure to file your open records request as soon as possible. Expect the process to take a minimum of 60 days. And expect local government to resist providing the information if it's related to sensitive or sensationalized topics. And you do have recourse, and this is just something that I recommend, to be prepared to file a civil suit or a writ of mandamus to obtain a favorable opinion related to the release of information you believe you should have access to under the law. Read this, because the Public Information Act in Texas is binding, meaning if people don't adhere to it, they're looking at potentially 6 months in county and $10,000 fine, maybe lose their position as well. So the Public Information Act is binding, and for this reason, we take it very seriously, the release of information that the public may have access to. And when the fact that it states in the Public Information Act that information is presumed open, that means that you should kind of default to, yeah, you should have access to this, unless somebody's rights might be violated. Then, or there's an ongoing investigation, stuff like that. Depending on the severity of the investigation, some parts of the investigation can be reported on. Some parts they'll want to keep under wraps. Okay, so there's some limitations, but for the most part, Texas is very serious about the Public Information Act stuff. So let's see, what are y'all talking about on Pilled? Appeals court. Yeah, this particular thing, what's happening right here is, hey, Truett. I'm having people watch my stream for the commentary and more stuff. Yeah, I mean, you can watch it at the Senate website. Of course you can. You won't get any of our commentary, and that the volume's actually the same. That's what I've been streaming it from. So the volume's actually the same. So yeah, you can watch it. You can watch it on the Senate, but again, you're gonna have to keep refreshing it every time they cut, because every time they go to on break, they're cutting. They haven't cut this one yet, but I bet they will. That's been a pain in the butt for me, trying to keep this stream going, especially when I'm trying to do other things as well. Yeah, they don't want anyone to see how bad they are. Absolutely. So let's see. They might be back sometime. They might be back soon, within like 5 minutes. But while that's happening, I can just play this little. I can play like the little 15-minute recap of stuff that that we covered in our 2-hour special a couple weeks ago. We went over a lot of details that they haven't really been reported on yet. But let me see if I can pull this up, see if you guys have seen this. All right, I'm going to share this tab right here. Investigation Committee. Whoopsies. All right, I'm going to play this and give you a little bit more insight as to some of the stuff that's been going on.
Anybody who's offended can get it. We throwing hands. Anybody not trying to make America great again. You a punk, you a clown. Better know where I stand. I'm a white.
And by the way, thank you everybody on Rumble for being here. If y'all please don't mind hitting the thumbs up button, it would help us out greatly, and much appreciated. But thank you everybody for being here. A lot of familiar faces, and glad that y'all are here.
In both of the other two impeachments that we're comparing to, 1917 impeachment of Governor Paul Ferguson and 1975 impeachment of District Judge Carrillo, all of the witnesses were put under oath. In Paxton's impeachment, they were not. In fact, the man who chairs the General Investigation Committee, Andrew Murr, the person talking, my name is Aubrey. I run takingbacktexas.org. I've written every single report on that website. I've trained a lot of poll watchers across Texas and multiple counties. And I've been investigating Tarrant County elections since early 2021. And my name is Aubrey. Nice to meet you. Alleged Republican says that the police would not put a victim under oath. So this guy says, no, there's no reason to put anybody under oath. So none of the witnesses. I am not Tori. My name is Aubrey, and I run takingbacktexas.org. So, Beverly, to let you know who I am, my name is Aubrey, and I run takingbacktexas.org. I am not Tori. I am not part of Tori's group. Tori is not doing the work that I'm doing. This is my website, takingbacktexas.org. Okay, I am based out of Tarrant County, and I've been training poll watchers since 2021. I was trained by Dr. Laura Presley. I've been training poll watchers and documenting everything that we've been learning across Texas in over 30 investigative reports. My name is Aubrey. I am not Tori. I don't work with Tori. I don't know Tori. I know who she is. But this is not Tori's work. This is my work at takingbacktexas.org. I'm glad you're here. Thank you for being here. Welcome to Taking Back Texas. This is not a Tory group. Witnesses in Paxton's impeachment have sworn to what they're saying. So that means they're not under penalty, paying a penalty of the perjury. There was no public debate like for the actual House. Total disenfranchisement of pretty much most of the people in Texas.
Everybody.
Yeah. In both the 1917 and the 1975 impeachments, the attorney was allowed to question the speaker on this stuff. Not in Paxton's impeachment. He was not allowed. He was there. He had questions. He was not allowed to question. That's what I was informed of. House.texas.gov. Right up here in this top thing is the committees. Click on that. Thank you to Representative John Smithy, because he got the entire thing transcribed. And if it wasn't for him, we wouldn't have any actual record of what they said in this short impeachment hearing. So now it was the General Investigating Committee that was doing all the talking. So when you go to committees, scroll down. Okay, so you're hitting committees. This is what it looks like, House committees. Scroll down, they're alphabetical. General Investigating, you'll see that right here. Now, these are the fools on the General Investigating Committee. Ann Johnson, Charlie Guerin, Rhino, and Shill. Andrew Murr, he thinks he's Wyatt Earp, but he's actually a dork. All right, click right here, transcript in R.E. Paxton evidence hearing. More like Wyatt over there on the right side under quick links. Ann Johnson.
Yep.
This is the vice chair of the General Investigations Committee. And this is her website. She's the vice chair of the committee that pushed the Paxton impeachment through the House so unlawfully. And yes, those are men in wigs and women with psychological problems. Those are that's the trans flag. I think I'm not sure that's the trans flag or the MAP flag. I don't know. But that's Ann Johnson, who's the vice chair of the House General Investigations Committee that pushed Ken Paxton's unlawful impeachment through the House in record time. I mean, these people just should get an award for that, because there's a record time. 4 hours. 20 articles, 4 hours. All right, is that lawful? Does that sound like Does that sound like due process to anybody here? These are the people that rammed it through. But we've got another list of all of the rhinos who voted for impeachment of Ken Paxton with no due process at all, based on 20 articles that were drafted when. And they had four hours to decide. Here's some interesting things. So in this
transcript right here. I'm going to show you. So you'll see somebody named Miss Epley, a witness that, mind you, is not sworn in at this time. Chair calls Chief Committee Counsel Erin Epley. So she is the counsel to this committee, the General Investigating Committee. Erin Epley, okay? And counsels to the committee, Therese Bush, all this. I only care about Erin Epley right now, okay? Let's see. Let's look into Erin Epley. Pull up her LinkedIn. Oh, it won't let me do LinkedIn, so let's do Justia. All right, guys, this is it right here. Erin Michelle Epley, 14 years of experience. Okay. Department of Justice. Oh, did she come to Harris County from Merrick Garland's office? State Bar of Texas, right here. Jurisdictions admitted to practice. State Bar of Texas. Here's her ID number since 08. Professional experience, Department of Justice. The Department of Justice, Erin Epley? Is that this Erin Epley, who is the advisor to the committee that's trying to take down Ken Paxton?
Mm-hmm.
Department of Justice, Erin Epley. Same Erin Epley? Because, yeah, it is. And so, the very interesting that Erin Epley, who is a witness, chief counsel to the committee, worked for the DOJ.
That one that you found that was behind a paywall, send the link to it in the private chat to me real quick, and I'll pull it up.
Because, yeah, I want to make sure that's the same Erin Epley from the DOJ that's advising the Texas House General Investigating Committee on how to impeach our Texas Attorney General. I'm just wondering if that's the same Erin Epley from the DOJ. I sure would hate to be wrong about that. How embarrassing, right? But let me show you something else about Ann Johnson. She was with the Harris County District Attorney's Office, Ann Johnson. Soros has been targeting the Harris County District Attorneys for a minute. See, if you'll look, this was in 2016. You see, that was the last time this one has been updated. And this one right here worked in the DA's office. Ann Johnson's also now the vice chair of the General Investigating Committee, being advised by DOJ's Erin Epley on how to prosecute Ken Paxton. Okay.
Here we go. I got Erin Epley. There you go.
Here she is. Can you read? Oh, there you go, right there. Can you see that?
Small Center, Board Certified Law, Top Secret, CSI. Let's see.
She has a federal law license. There you go. Good. There you go. There you go.
Show all
Right
licenses. Oh,
We don't have access. We don't have clearance.
no shit. Give me long enough I could get in there, but this is plenty right here.
Yeah.
And look, these are all people that she's either viewed or whatnot. These are all bad actors, guys. Let's see, but yeah, that's definitely the same Erin Epley.
So she's one of the main witnesses in the impeachment against Ken Paxton. So when Ken Paxton says stuff like he thinks his office has been infiltrated, yeah, it has, because it does appear that the DOJ sent people down to investigate him through the Harris County District Attorney's Office. That's what they've been doing. Okay, so isn't that interesting? So there's an immediate uproar after he's impeached. The immediate effects were that he's been suspended.
Forgot I was still on there.
Yeah, don't worry about it. So yeah, that's what's happening. These are the people that are coming after the Attorney General's devil, stupid deep state.
It just tried to poison me.
So that was weird. That was so weird, y'all. He got like poisoned. Abbott likes John Scott a lot, so he appointed John B. Scott, former acting Secretary of State. And then Jay Nelson got sworn in. He was just acting. He was never sworn in as Secretary of State. Jay Nelson got sworn in. Now this guy, John Scott, is our acting Attorney General. But he's kind of just like a figurehead. The immediate effect of the impeachment was he's suspended, pending the Senate hearings. Senate's got to vote. Both chambers have to vote to impeach him for him to be actually impeached. I don't actually think the Senate's going to impeach him. But like I said, due process is what we've asked to be afforded here. They have to hear these articles. They have to hear this case. Either September 5th or not September 5th, another day. And we're going to be live streaming it. I think it's really very important for people to
understand how we got here, why they're doing this. He's been doing so much on so many fronts. So, and it's not lightweight stuff, okay? So basically, John Scott is our acting attorney general right now. Paxton's attorneys have sought to have 19 of the 20 articles dismissed because most of them are bogus anyways, right? So we'll see if they can get most of them even dismissed and only actually consider the ones. Because like we said, if he's guilty of a crime, let's talk about it. If he's actually committed a crime, let's actually have that out at the, at the Senate hearing. If he's guilty, he'll be guilty. Whatever. You do the crime, you do the time. It's not something that Diddy and I are foreign to. It's okay. It doesn't make you an evil person. I don't even think we need to wait for the Senate hearing. I think that we should go ahead and just start primarying everybody that voted to impeach him because they did it without due process. And I think that alone is grounds for impeachment, for being primary. If you're willing to do this with 4 hours, no witnesses under oath, very, very shaky grounds, and to an attorney general who's fighting as hard as he is, that's nuts. That's freaking nuts to me. Would y'all watch the Senate hearings for Ken Paxton? Because I think we're going to stream them live. That's it, guys. I mean, stay tuned. We're going to live stream them on all platforms. Donations are not required, but they are accepted. Merchandise is available if you go to takingbacktexas.org.
Somebody was saying that we would like to share this on CloutHub with our permission.
On CloutHub?
Yeah. RCD2, yeah. If you want to share this out on CloutHub, please. To us, the most important thing is getting this out to the people so they understand it, so that they can start holding these people to speak to the fire. So, by all means, share it out there. All I would say is just, throw a hat tip to ICs and the incredible work that she does. So.
Thank you. I hope it made sense. I hope you see what Ken Paxton was doing, what the media tries to spin it, what they did, how the media is sort of reinforcing this unlawful action, how it looks like the DOJ is sending people in to actually facilitate this impeachment and removal of America's best attorney general. Okay, and why we need to give him all of our support. We need to stand by Ken Paxton. We need to ask everybody to stand by Ken Paxton, and every single House representative that voted to impeach Ken Paxton should be primaried. Okay, so this right now is unscripted, unscheduled. Diddy and I didn't talk about this, but if you're in Texas, okay, and these people are your representatives, and this bothers you, consider running against them. You don't need to have money, but if you have money, it's a bonus. But we can raise money. We can try to help. We can try to run a grassroots campaign. And that trucker out of New Jersey, that one trucker that spent like $140 on his campaign that won, that shows that it is possible to win on little money. It's very unlikely in Texas. We will need to make sure to market you. You're going to need to come out strong. If you're ready to come out strong, check the list of people, and we're gonna put it up on all of our platforms here in a minute. The list of House Republicans that voted to impeach Ken Paxton with no due process. Okay, and if those are your Republicans, please consider filing against them or finding somebody to file against them.
But she is as I always said, she's about 100-pound pit bull straight up. So, but yeah, Trump.
Oh my God, that really his mugshot.
Yeah, that's his mugshot. That he just posted it. Election interference never surrender. Donald J. Trump.
It is looks just like him. I love it. Okay, guys, keep an eye out. We're gonna have merch. We're gonna have our updated merch. We're gonna have hoodies, crop hoodies for the ladies. Okay, we're gonna have low cut hoodies for the ladies. We're gonna have regular hoodies for the guys with this mug on it, because that is gangster right there. On questions that I don't always, I can't anticipate. Also, some people might have seen some cool stuff. Might want to tell us about it. Guys, all right. So, one second. Y'all can find me at Telegram, Taking Back Texas. TakingBackTexas.org is our website. You can sign up to our email list, and we send out emails with some of the stuff that we're doing. Definitely all of our events that we have. We've had speaking events before. We've had training events that we've hosted. We train poll watchers. We've got other partner groups that will train
Miles will be here.
poll workers and BDRs. They'll get you all set up to be trained up
that way, if you want to get involved that way. So feel free to go to takingbacktexas.org and reach out. We're going to set up an auto email that will automatically reply to you with all of our socials. Now, I'm not big on social because I've lost a lot of social media accounts. But we are on Telegram, and I've got a YouTube. I don't expect to be able to keep the YouTube for much longer, but I do have one. So y'all enjoy, okay? And I'm going to switch
Little,
over to this
if you want to be seated for just a moment,
KHOU
because I know he's in the
stream
building.
to try to get this going. All right, this way here. This is what I'm actually going to do. I'm actually going to have it streaming from this one because I'm about to leave for work, and I'll be back in just a few hours. So you guys enjoy. If I notice that the live stream has gone off on some weird tangent and it goes to the Johnny Depp trial, I will end it and I'll restart it. But I think this should be fine. Let me make sure that it's turned up well, and it was not. So, okay, now it's turned up.
Bailiff, will you bring in the witness, please?
Give me a 5 by 5 if you can hear that. Truett, give me a 5 by 5 if that's louder, because I'm thinking this might be louder for y'all. A boneless chicken. And Matt 1776. I still don't know what is the deal with the stickers. They don't work for me. They don't work for me. Now, I had a weird account when I first made my Foxhole account. My account somehow.
Mr. Vassar, you're still under oath. Please be seated.
And I think it ruined my sticker.
Mr. Little, you may continue.
Give me a 5 by 5. Y'all can hear me.
Thank you,
okay?
Mr. Vassar. We're going to go back to Exhibit AG 170. Mr. Arroyo, if you could bring up page Brickman 201 again. We're going to go back one step. And if, Mr. Arroyo, if you could highlight or zoom in on the two texts at the bottom again.
Don't destroy Truett with stickers.
Mr. Vassar, my apologies. My colleague Amy Hilton informs me that I did not, in fact, get the joke. The joke here is this is a coloring book. It says, and I encourage anyone to look it up, it's the Going Rouge Sarah Palin Rogue Coloring and Activity Book, right?
That sounds right.
Does that look like it?
I don't recall exactly, but that could be accurate.
And the joke is that Sarah Palin is so dumb that she can't spell rogue, right?
That wasn't my understanding of the joke. I believe my recollection is that when I found a coloring book about going rogue, that was why I sent it to this group chat. I don't recall any specific reference to Sarah Palin.
That's the context of the joke, but the joke of the coloring book here is it's supposed to say going rogue, and it says going rouge, and it's Sarah Palin can't spell rogue, LOL, right?
I can't really see your phone, but I'll take your point.
Would you like me to approach so you can see it?
That's up to the president. I see it.
That's the one, right?
I can't recall specifically if that is the one that's linked in this text message.
But the context of the joke within the text chain is it's about you going rogue. And the reference is an oblique reference to Ken Paxton calling you rogue employees, right?
Yes, sir.
And so the same information that got you very upset yesterday about being called a rogue employee, looks like 3 weeks or so after it happened, you're joking on a text chat with your friends about it and showing them the Going Rouge coloring book, right?
That's
Do I have it?
what happened. Yes, sir.
There's nothing less funny than someone who explains the joke, but I think I have it now, right?
I'm sorry, say that again.
I think I have it now, right? That was the context of the joke. I explained it. True?
Yes, at the time, circulating an Amazon link to a coloring book about going rogue was what had happened.
All right, Mr. Arroyo, if you could advance to page Brickman 203.
That was very funny.
If you could start, Mr. Arroyo, with the blue text down and zoom in on that. The text from Blake Brickman says, being fired will make you a cool kid, right?
That's what he says.
David Maxwell gives a thumbs up and sunglasses emoji, right?
Yes, I see that.
Ryan Bangert responds, Brent told me today that he was, quote, completing his investigation. He said it's all based on the documents he reviewed. I told him the cold documents may tell one story, but 10 months of loved experience tell the rest of the story. And then Ryan corrects his typo and says lived. It's his lived experience that tells the story, right?
Yes, I see that.
Darren McCartney says, definitely not loved. Ryan Bangert said, he also asked me how soon it was after RV received the signed CAMAC contract that Jeff and I learned about it. Do you see that?
Yes, sir.
You are RV, right?
Yes.
And what Brent Webster was trying to investigate at the time is what we discussed yesterday, right, Mr. Vassar, that apparently at some point you received the signed contract with Ken Paxton's signature on it with Brandon Kamak, right?
Yes, I did.
And Brent Webster was trying to discover when Jeff Mateer and Ryan Bangert learned about that contract as part of his investigation. True?
Yeah, that's my understanding. He didn't ask me when they learned about it, but he asked me when I received a copy of the contract.
Okay. And Ryan Bangert responds, he said that was one missing piece of his, quote, investigation, close quote. Lacey May says, he's the worst. Let's turn the page if you would. And Brent Webster, he's the new guy at the office, right?
Yes, sir.
He's been working there a little over 3 weeks maybe, or 3 weeks?
I think his first day was October 4th. And if these are on the 26th, then that would be accurate.
Okay. So next page. If you could give me, just zoom in on the text if you can, Mr. Arroyo. No, just all of the text together if you can. Give me the first one at the top too. Very kind. Ryan Bangert posts what looks like, I believe that is the emoji. I don't know how else to refer to it. And then David Maxwell says, I never created any documents. He wanted me to conduct an illegal investigation. Right?
That's right.
Do you know what he meant?
No, sir.
And you posted a meme. And why don't you tell the jury what your meme says?
It says, never interrupt your enemy when he is making a mistake.
Who is your enemy?
I didn't have an enemy at the time. It was a meme just sent in the conversation.
Sure, but there's a context, right?
Well, the context is Brent Webster was investigating us when it was General Paxton who was abusing the powers of the office to benefit Nate Paul.
And so here the context is Brent Webster is the enemy, yes?
No, sir. It's Brent Webster is investigating the wrong person or the wrong people.
Okay. Well, what's the mistake that's being made, that's being referenced in your meme here?
Oh, that would be the fact that he is investigating us, not General Paxton.
Brent Webster's making the mistake?
Yes, sir.
And you don't want to interrupt Brent Webster, right?
That was the joke. I was not in the office, so I couldn't have interrupted him if I wanted to.
You hadn't been in the office in a very long time. You were working from home, right?
No, sir. I was placed on investigative leave during this period and surrendered my official agency phone and laptop and was not permitted to access the building or work.
It seems to suggest, this meme seems to suggest to me in context that you think Brent Webster is the enemy who's making a mistake. Is that true or untrue?
I don't know what it seems to you, but I explained I didn't have an enemy at the time. I was not fighting Brent Webster.
Okay. David Maxwell posts a thumbs up and a laughing emoji. Lacey May says, so another candidate in Wilco came up. Wilco is Williamson County, right?
Yes.
And at this time, Lacey Mace is running for office, true?
I believe so.
What's she running for?
I don't recall.
So another candidate in Wilco came up to me yesterday and said, so I understand you're acquainted with Brent Webster. Let me tell you about Mr. Webster. He's lazy and he's a liar. I'm glad you don't have to work for him. And then she walked away. And you said, that's awesome. right?
Yes, sir.
Why was that awesome?
Because I had never heard anything about Brent Webster, and to have someone approach Lacey and give their personal experience of interacting with Brent Webster, I thought was informative.
Mr. Vassar, I'm going to show you another text thread that you didn't produce, okay? But you're part of. Your Honor, may I approach the witness?
Yes, you may.
I'm marking this exhibit 1006, okay? Are you part of this text thread?
Yes, sir.
Have you seen it before?
Yes, I have seen it before as a participant on the thread. I've not seen these documents or this exhibit before.
Mr. President, we move for admission of AG Exhibit 1006.
Any objection?
And to be clear,
I'm
Mr.
sorry,
I
have
didn't
just a
hear.
moment. I don't believe this is one previously that's been marked, so if I could have just a moment to look at it.
Yes, take a moment.
Your Honor, may I inquire of counsel, is it a series of communications with the different deputy chiefs? It's just a long one. I'm trying to save time if I could.
Mr. Hardin, yes, this is a text thread that was produced by Mark Penley in response to your subpoena.
I have no objection.
Admit exhibit 1006. Is that the correct number, Mr. Little? 1006?
It is, Mr.
Into
President.
evidence?
May I proceed?
Yes.
Thank you. Mr. Vassar, take a look at, and Mr. Arroyo, would you please bring up Exhibit 1006 so the jury can see it with us? Go to the first page of that if you would. You're on the second. There you go. All right, thank you. Mr. Vassar, you post a picture into this text thread, right?
Yes, sir.
And you're posting a picture of an email from Ken Paxton to a group chat, yes?
Yes, sir.
And Ken Paxton telling you, I did sign the outside counsel contract with Camac Law Firm, PLLC, yes?
That's right.
And who is, if you can tell the ladies and gentlemen of the jury, who is on this text thread?
It's myself, David Maxwell, Ryan Bangert, Blake Brickman, and Lacey Mace, just going by their...
And this is hard to tell with iPhones, but this document was produced by Mark Penley. So these are screenshots of Mark Penley's phone. Do you understand he's on the thread too?
Okay, I don't see him. I understand that now. He wasn't listed in the little bubbles at the top, but I understand.
Well, my experience with this, obviously I'm not testifying, but you know how on iPhones, when you're on a group chat, it doesn't necessarily put you in the little circle.
Right.
If it's your phone, right?
Okay.
So Mark is on this thread?
It appears so.
Okay. So Lacey Mace, second text, new group. Do you see that?
Yes, sir.
And the date of this, just to be clear, it begins on October 2 of 2020, right? Right after you went to the FBI?
That's right.
All right. Let's see what you're talking about. Turn to the next page, if you would. The next page is a picture from Ryan Vassar. It says silence unknown callers. And he says, y'all, and you say, I'm sorry, it's a text from you. You say, you show them a picture of the silence unknown callers feature on your phone. You say, y'all should probably turn this feature on, right?
That's right.
And why do you say that?
To avoid receiving a phone call from a blocked number or an unknown number that was unanticipated or unexpected.
You're worried about media calls at this point, right?
It could have been any calls, any unknown or unidentified calls.
And Ryan Bangert says, how did I not know about that until now? And Lacey May says, excellent. The next, and let's turn the page, if you would, Mr. Arroyo, to page Penley 9. You say, we should consider notifying other depths before Monday. Notifying them of what?
The fact that we had gone to report General Paxton to law enforcement about the facts that we had determined.
That's not what you say.
Excuse me, I object to the sidebar and testifying, Your Honor. He can ask questions, but not state
Sustained.
testimony. Thank you.
Lacey Mace responds to you about the new FA, and she means first assistant, right?
Yes, I believe so.
And then she says, I don't feel like that's our announcement to make. And you say, resigning. Resigning.
Right.
So what you said, we should consider notifying other depths before Monday. It's about resigning. Yes?
That was a element of it, but most of it was about going to law enforcement to report General Paxton's activities that we had determined.
That's not what you say in this text thread, is it?
No, what I just explained is that is part of the conversation that we're having at the time.
As of October 2, you were planning to resign as a group, yes?
No, sir. We were discussing what we should do.
And you were saying we should consider notifying the other deputies before Monday about resigning. True?
That's right. In addition to disclosing to them that we had gone to law enforcement to report General Paxton's activities.
Ryan Banger responds, I don't think we tell them until we have a fully vetted plan of action. Next page. Blake Brickman says, has anybody updated Johnny? Who's Johnny?
You have to ask Blake, but I interpreted that as Johnny Sutton.
Is he representing all of you at this point?
Yes, sir.
Who's paying for all that, by the way?
Well, we are.
Did you pay for it out of your savings?
I've not paid Mr. Sutton.
Whoa. Who has?
Nobody has. He's agreed to bill us at a future date.
What future date?
You'd have to ask him.
You're telling me that that an attorney, a very experienced, prominent criminal defense attorney, decided to do this for free, for you, for 3 years. Is that right?
No, sir. It's not for free.
What's the arrangement?
We will pay him for the services that he's rendered to us.
Is he billing you hourly?
He's recording his hours, is my understanding. I have not received a bill from him.
And he hasn't been paid by any of you yet. Is that right?
I have not paid him. I'm not aware of whether any other individuals have paid him.
And so is the plan for you to achieve this settlement through the adoption of the Texas legislature and then pay off your criminal attorney who is trying to help you not be labeled co-conspirators? Is that the plan?
No, that's never been discussed.
When are you going to have the money?
Thing.
Ideally, when I have enough money, I can pay.
Funniest thing you've ever heard.
You've never been sent a bill. You don't even know what to pay him.
That's right.
Is everybody paying equally? Is it
That's
pro
right,
rata?
like, that's logical.
Again, I'm not sure what other people's arrangements have been, but I have not received a bill from Mr. Sutton, and I have not paid him yet.
Actually, he is sure. He just said.
Mr. Sutton?
Yes.
His name had been discussed with Mr. Matier and Mr. Bangert and Mr. McCarty about the best person to call before we had met with law enforcement.
Who suggested him first?
I don't recall exactly.
It's a mutiny.
Did you understand Mr. Sutton to be a former U.S. attorney?
Yes, sir.
In whose administration, if you would? Tell the ladies and gentlemen of the jury.
I believe it was George W. Bush's administration.
Have you ever heard the expression, there are no coincidences in Austin?
I may have. I don't recall it right now.
He said, maybe.
Next text you write, or in response to Blake Brigman, you say, not me, meaning you haven't updated Johnny Sutton yet, right?
That's right.
Ryan Bangert says, not with the latest. He is aware that Jeff resigned, but not the new FAAH or FAAG. Is that supposed to be First Assistant Attorney General?
That's right.
Okay. Next page, if you would. You write, to-do list. 1, update Johnny. That's Johnny Sutton, right?
That's right.
And number 2 is have someone call the new meat, right?
That's right.
Who's the new meat?
I have no idea. I don't recall who I was referring to at that time.
You're talking about new employees at the Attorney General's office, right?
I'm not sure.
Can't tell.
I presume that would have been the people that I was referring to, just based on being in the office and working in the office.
He said,
Number
your
3 is
analysis
discuss with
seems
Luis.
correct.
Tell the ladies and gentlemen of this jury who Luis is.
At the time, Mr. Luis Sines was the chief of staff for Governor Abbott.
What were you going to be discussing with Governor Abbott's chief of staff?
It was not my discussion. It was a to-do list that members of the group had contributed to. So I did not meet, I did not talk to, I did not confer with Mr. Sines.
Guys, this is what a mutiny looks
I
like.
don't know. I believe Mr. Banger and Mr. Mateer met with Luis, but I don't know where or when.
Well, I want to be super clear about the timeline, okay? Without telling you anything that's been testified to in this trial. Are you aware of any type of meeting between Mr. Mateer and Mr. Banger and the governor's office on the day of the FBI report?
I can't say that I recall. I don't know when or where they may have met.
But the discussion that's contemplated in your text message with Luis Sines, that was poor syntax. Let me try again. The discussion with Luis Sines that's contemplated in your text message is not talking about that, because this is on October 2. So this is talking about a new meeting with the governor's chief of staff, right?
Again, I don't know for sure. I wasn't part of that meeting. I don't know when it happened or where it occurred. And I don't recall if this was referring to that specific meeting or a subsequent meeting.
Number 4 on your to-do list, coordinate group office cleanout, right?
Yes, sir.
You are planning as a group to clean out your offices, yes?
Again, that was the conversation that we were having at the time.
But at some point in time, I'm sure you retained an employment lawyer and someone advised you that you need to stick around and make them fire you, right?
I did hire an employment lawyer.
And at some point in time, after meeting the employment lawyer, you decided the best thing to do was stick around and make somebody fire you, yes?
I don't recall if that was the decision that was reached with my employment lawyer.
Your plan on October 2 was to coordinate a group office cleanout, yes?
That was the conversation we were having, again, about options, discussing continuity of the office, and whether it was an option for us to resign.
The next text
Because
is
it was
from,
mutiny.
it appears to me to be Mark Penley, because this is his text thread. It says, Ryan B., did you find the sets of subpoenas in my office? Do you see that?
I see that.
These are the grand jury subpoenas, yes?
I would presume so. You'd have to ask Mark which subpoenas he was referring to.
Okay. Ryan Bangert responds, I have not been down to grab them yet. I likely will get them in the morning. Let's turn, and he says, I know Johnny has, and let's turn to the next page, them. So we can always get a copy from him, worst comes to worst. I'm apparently not locked out yet. And then Ryan posts a tweet from Lauren McGaughy, right?
Yes, I see that.
And who's Lauren McGaughy?
She's a reporter for the Dallas Morning News.
You see her up here? You see her back there?
I don't know. I've never met her, so I'm not sure.
Never met her? Well, she was on top of it this day. She's got a tweet here. It says, I heard First Assistant Attorney General Jeff Mateer announced today he's leaving the agency to return to First Liberty. And then the next text from Ryan B is, Lauren Magahe knows. She's a vigilant reporter, isn't she?
I'm not advised.
That was not public at that point in time, right?
I'm not sure either. I am not sure of the timeline between when this was sent or when it looks like the tweet occurred on October 2nd at 7:15 p.m.
All right, let's turn the page if you would. You write, what she needs now is a statement from First Liberty, right?
That's right.
What Lauren, the Dallas Morning News reporter, needs now is a statement from First Liberty is what you're saying, yes?
That's what I would have suggested, yes, sir.
Yeah, and so, correct me if I'm wrong, Mr. Vassar, it kind of looks like you're trying to shape the media narrative around what's going on. Is that true?
No, sir.
But what you're saying here is we should try to get her a statement from First Liberty, right?
Absolutely not.
That's not what you mean?
No, sir.
What did you mean? Just tell the ladies and gentlemen of the jury.
That was my personal observation of another piece of information that she could obtain was a statement from First Liberty, which is where I understand Mr. Mateer was going to work.
And Ryan Bangert responds, or Alejandro can just give our statement. Who's Alejandro?
He was the communications director at the office at the time.
Okay. And you say, unless KP is holding it or Alejandro is keeping Magahe on the blacklist. What's the blacklist?
It's my understanding at the office that there was a list of certain reporters that were handled differently than other reporters.
Next text. On second thought, let the media feeding frenzy start. Who said that?
That was Ryan Bangert.
The same Ryan Bangert who's testified in this trial? That guy?
Yes, sir.
So on October 2, he's saying, let the media feeding frenzy start. True?
Yes, that's what this says.
And this is, how many days is this after you went to the FBI with no evidence?
Well, to clarify, the absence of evidence that I was referring to is documents. What we went with is our
Not responsive. Object, not responsive, Your Honor.
Sustained. I'm sorry. I did not hear you.
Why did Ryan Bangert want to start a media feeding frenzy on October 2?
You'd have to ask him that. I'm not sure.
I'd like you to, Mr. Roy, if you could go to page Penley 20 at the bottom of, it's hard to read, Bates label at the bottom right. Right, stop there. I want you to look at I want you to zoom in on the last two texts on this thread, if you would. Lacey May says, stand down on that. I'm going to ignore that. It says, Missy told me he was in JM's office, blank, and there's a redacted name. Blank was actually in the office while he was there. Mr. Penley redacted this name. Who is that?
I'm not sure. I don't recall who that would have been. That was a message from, looks like Lacey.
And if you could, Mr. Arroyo, advance to page Penley 25. And you say, we need a statement, right?
That's right.
And you wrote a long one. So look to the bottom of that page. Mr. Arroyo, next page. Next page after that. Next page after that. Next page after that. talk about not tiring in your pursuit for justice. Justice will be served. We refuse to resign and will not be intimidated. You say all that, right?
Among other things, yes, sir.
But you wrote that, yes?
Yes, sir.
Why did you want to do that? Why did you want to release a statement?
Because it was in response to the Attorney General's allegations that we had authorized the activities that he was directing and supervising throughout the year that related to Nate Paul.
And no one on this thread agrees with you, right?
Well, the statement was not issued. I don't know that anyone disagreed with the content, but no one decided to issue it.
Next page, if you would, please. Lacey May says, it's likely that a very talented crisis comms person is working very hard on our behalf.
Counselor, hold on. It's not on the screen yet.
Oh, I'm sorry. If you would, Mr. Arroyo, that middle text.
Up there it is.
Middle text says, it's likely that a very talented crisis comms person is working very hard on our behalf as we speak, right?
Yes, I see that.
Who is that?
I have no idea. You'd have to ask Lacey.
Were you paying for her? Were you paying for a crisis comms person?
No, sir.
Did you ever ask her who she was talking about?
Pardon me, Your Honor. Can I ask the witness to speak a little closer to the microphone? Thank you.
Yes, please.
Did you ever ask her who she was talking about?
No, sir.
Okay. Next, I want to move to the topic of what I'll call the mystery of the altered letterhead. Okay? I've got a new document for you. This is marked as Exhibit AG 1007. May I approach, Mr. President?
Yes, you may.
Please review this email thread, Mr. Vassar.
One moment. Mr. Harden, have you had an opportunity to look at it?
I have no objection.
We move for admission of AG 1007, Mr. President.
It is admitted to evidence.
Mr. Vassar, review this thread, please.
I see it. It's an email that was printed by Brent Webster. It was sent from Lacey Mays to myself on October 1st, 2020.
Mr. Arroyo, if you would, please. Exhibit AG 1007. Zoom in on the text, if you would, please. All right. I want to make sure we have this in perfect context. All right. The earlier email in the thread is from a woman named Brittany Hornsey, yes?
Yes.
And who is that, Mr. Vassar?
At the time, she was executive assistant to Jeff Mateer.
Jeff Mateer only? He's got his own assistant?
I believe she also supported Ryan Bangert, but I'm not sure exactly.
Okay. And she writes an email on September 30th at 6:16 p.m., yes?
Yes.
And to whom did she write it?
To Ms. Mays.
And what is the subject?
It says letter.
All right, put this in proper timeline for the jury. At 6:16 p.m. on September 30th of 2020, you have already made your report to the Federal Bureau of Investigation, yes?
Yes.
And Brittany Hornsey is emailing something to Lacey Mace, yes?
That's what this indicates, yes.
In October 1, the next day, 30 days hath October, yes, the next day, 12:09 p.m., Lacey Mace forwards that item to you, yes?
Yes.
Let's show the ladies and gentlemen of the jury what that item is, Mr. Vassar. Next page.
Do you want me to identify it? Or was there a question?
What is it?
It says a draft 2. It's dated September 29th, 2020. It has the Attorney General seal on the top of it, and it has no body, but it is a draft signature block of the executive deputies.
What else do you notice about it?
There are some signatures and some that are not. I think that's it.
Anything else that you notice about it? Anything missing, perhaps?
Not offhand, no, sir.
The Attorney General's name has been removed from the letterhead, hasn't it?
No, sir. As I explained yesterday, the agency has different letterhead. This is a different letterhead.
You understand that Brittany Hornsey was interviewed by Brent Webster as part of this case?
I'm not advised, but...
Have you heard that Brittany Hornsey was intentionally told by Lacey Mace?
I've not heard that.
Stop. I didn't finish my question.
Sorry.
Hold on a second. Have you heard that Brittany Hornsey was intentionally told by Lacey Mace to bring her the letterhead without Ken Paxton's name on it?
I'm not sure that I have ever heard that Lacey had instructed Brittany to send the letterhead.
Had you ever before written a letter on agency letterhead? Well, skip it. This, of course, letterhead was being used in the letter by the so-called whistleblowers to notify certain parties of certain things, yes?
That's right.
I want to go back in time a little bit. We've been talking a lot about September or October, but I want to go back to the hiring of Brandon Kamak, okay? Ask you a series of questions that I think are going to call for a yes/no answer. Just do your best, okay? You were responsible for overseeing outside counsel contracts, correct?
For the Office of the Attorney General, that was one of the areas, yes, sir.
Yes. And the agency reviews and approves around 900 of them every 2 years, true?
Yes, across the state.
Okay.
Not for the office.
I want to put things in proper context. Brandon Kamak would have been one outside counsel out of about 900 between 2019 and 2020, true?
Yes. On average, yes. There's about 900 outside counsel contracts that the agency processes on behalf of other state agencies. The office itself might have 2 to 5 outside counsel contracts at a time, is my recollection.
So if the suggestion is that Nate Paul had such a chokehold on the Attorney General's office that he had consumed so many resources that the office wasn't really doing much else, that wouldn't be true, would it?
The focus of Nate Paul's related activities were becoming increasingly...
Subject non-responsive, Mr. President.
Sustained.
It is not true, Mr. Vassar, that Nate Paul had such a stranglehold on the Office of Attorney General that nothing else was getting done, right?
I wouldn't characterize it that way.
All right, let me ask a better question then. Yes or no? Did Nate Paul have such a stranglehold on the Office of the Attorney General that other things weren't getting done?
I don't think I can answer a yes or no to that question.
Are you sure?
I am sure.
So you can't say yes, right? It's not true. Can't say yes, right?
The degree to which Nate Paul's relationship with General Paxton and the activities that we were asking...
Objection, Your Honor. He can't put these, object to him being forced to answer yes or no. The rules don't require that from a witness if they can't. And he's trying to testify in these questions. When he doesn't get what he wants, he asks him to just give yes or no. That question, if you look at it, we have no idea what he means by stranglehold, as an example. He should not be required to answer yes or no before he knows what this man means. That's my objection.
First, I think you had an objection first, then you had an objection.
Yes, sir.
I believe so. Okay. The court reporters, I hope you were able to get that. We had objections over each other. So first of all, we will overrule your objection. We will sustain your objection. To the best of your ability, Mr. Vassar, if you can answer yes or no, continue.
Try to ask a better question. How many lawyers are there roughly at the Office of the Attorney General?
Roughly 800 lawyers.
How many of them ever touched anything related to Nate Paul? How many of the 800 ever touched anything related to Nate Paul?
I could speculate there may have been 15 lawyers, maybe 15 to 20.
How many cases does the Attorney General's office have going on at any time?
Generally, I think it's around 900,000 or maybe 50,000 cases.
900,000 or 50,000?
Well,
help me out here.
I was going back to the outside counsel numbers of 900 every 2 years, so I apologize. I was not in the civil litigation division, so I'm not
Thank you guys for
sure
being
how
here.
many
I'm at work right now,
litigation
so I'll
cases
take
are
that
active
answer.
at any general moment.
How many? What's your best understanding of how many civil litigation matters are going at the Office of the Attorney General at any given time?
Possibly, it could be 20,000 active cases at a time.
20,000, right? And how many of those 20,000 cases involve Nate Paul?
I would have no direct knowledge of how many of those cases would.
So I think we've been over this a lot. I don't want to burden us with it too much longer. There's a layering of signatures and approvals as part of the policy for hiring outside counsel. Yes?
Yes, sir.
But of course, you know that the law says that the elected Attorney General appoints outside counsel, right? Just him, right?
No, sir.
All right, Mr. Arroyo, this may be challenging for you to find, but please bring up section 402.0212 of the Texas Government Code. Eric on the spot. All right, give me the title in section A, please. Have you ever read this before?
Yes, sir.
Let's read it together. It says, except as authorized by other law, a contract for legal services between an attorney other than a full-time employee of the agency and a state agency in the executive department other than an agency established by the Texas Constitution must be approved by the Attorney General to be valid, right?
Yes, sir.
That's pretty clear, isn't it?
Yes, sir.
Doesn't have to be approved by you. Doesn't have to be approved by Jeff Mateer. Doesn't have to be approved by Michelle Price. Doesn't have to be approved by Lacey Mace or Ryan Bangert or anybody else but the guy who got 4.2 million votes, right?
It was a standard practice for approvals, but yes.
Tech non-responsive.
Sustained.
Right.
Your initial question was whether the law allows General Paxton to appoint outside or
Tech non-responsive, Mr. President.
Sustained.
You'd like to have the court reporter read the question back to you.
Your first question about whether the law allows.
Object non-responsive.
Sustained.
Yes, please read the question back to me.
We could not hear that. Can you repeat that?
I'll be happy to repeat it. Outside counsel contracts don't have to be approved by you. They don't have to be approved by Jeff Mateer. They don't have to be approved by Michelle Price or Lacey Mace or Ryan Bangert or anyone but the guy who got 4.2 million votes, right?
That's right.
Thank you. Now, with regard to criminal matters, you had a call with General Paxton, true?
Uh, Specific to the outside counsel process, yes, but in general criminal matters, no, I never spoke to General Paxton.
Yes, just about the outside counsel process, yes?
Yes.
Okay. And he said, and I quote, "Tell me about the approval process." And you walked him through it, right?
Yes, sir.
Remember, you're the lawyer to lawyers, right?
That's right.
And he was asking for your advice. Yes?
He was asking me to explain the outside counsel process.
Now, this next question is very important. Ken Paxton asked you, and I quote, "Can the agency retain outside counsel in a criminal matter?" Yes?
That's right.
He asked for your advice, right?
Yes.
He didn't kick down your door and say, "Ryan, this is what we're doing," did he?
Not in that conversation.
He asked you for your advice, and you gave him your advice, true?
Yes.
You called two candidates, Joe Brown and Brandon Kamak, correct?
Yes, sir.
You got each of them to run a conflict check, true?
Yes, sir.
You drafted a contract for Joe Brown, didn't you?
No, sir. I sent Mr. Brown the template, the outside counsel contract template with no scope. There was no scope of work, no rate of pay. And his follow-up email to me was, "Would you like me to draft the scope?"
And you said, "Joe, the malpractice issue may be one that we can resolve. We will draft the scope and we'll send you a draft agreement with the relevant details as soon as possible," right?
That's right.
You got each of them to run a conflicts check, Brown and Kamak, right?
Yes.
Now, in your estimation, the Nate Paul investigative referral from the Travis County District Attorney's Office was, and I quote, "an ordinary criminal referral with ordinary investigative issues." True?
That was my perception, yes, sir.
Your conversations with First Assistant Jeff, actually, let me press pause here. After your testimony yesterday, did you go back and watch the video of yourself giving testimony?
No, sir.
Okay. Your conversations with First Assistant Jeff Mateer were that you could make a legal argument that this outside counsel contract with Kamak was okay because you had a referral and you had separate authority to engage outside counsel. True?
Yes, sir.
And you drafted Kamak's contract, true?
Yes, sir.
Now, tell the ladies and gentlemen of the jury, because I think we all want to understand the executive action memorandum. The whole process or whole idea of using what's called workflow in DocuSign for these outside counsel contracts was your idea, wasn't it?
Yes, sir.
Doesn't date back to John Corden or Greg Abbott, does it?
No, sir.
You're the progenitor of this idea, and we have you to thank for it, I suppose, right?
I suppose so.
And so what happens in workflow DocuSign is one person has to sign and then the next person, and it has to go in order. True?
Yes, sir.
Didn't exist before you. Yes?
It existed in hard copy, but not electronic copy.
Jeff Mateer told you to sign this contract. Yes?
Yes, sir, he did.
Not Ken Paxton. Jeff Mateer told you to sign this contract with Brandon Kamak, right?
In my conversations with Jeff,
No one but Jeff Mateer told you to sign this contract, right? Right?
Jeff Mateer was the only person that I spoke to about signing the contract.
Ken Paxton didn't cause you or compel you to sign it, did he?
No, sir.
Your conversation with Mateer, in fact, was, and I quote, "We need to keep this on as short of a leash as possible because we don't want it running away." True?
No, sir. That's not true.
Well, fortunately, we have your transcript.
I
Mr.
think-
President, may I approach the witness?
You may.
Mr. President, I am not moving for admission of this transcript as I do not think it will be necessary. The purpose of this is impeachment only.
May I inquire, excuse me, go ahead. May I inquire if you intend to introduce the entire document?
I do not. I just said that. I don't intend to introduce it as an exhibit. I intend to use it for impeachment purposes only.
I have nothing. Thank you, Judge.
Continue.
If you would turn to page 105 of your transcript. I'm going to bring it up as well. We're not going to put it on the screen because I don't think we'll need to do that. Can you find page 105?
I am on the transcript page of 105. Yes, sir.
Read for the ladies and gentlemen of the jury what you testified to the House Board
Counselor, hold on one second. My transcript is down. I'm just trying to get it back up. Hold on. Go ahead.
Thank you, Mr. President. Read, if you would, Mr. Vassar, to the ladies and gentlemen of this jury, the testimony that you gave to the House Board of Managers beginning at page 105, line 24, and read until page 106, line 4.
So it says, and my conversations with Mateer, similar to the qualifications, the expertise, the experience between the two potential people, along those same lines was, quote, we need to keep this on as short of a leash as possible because we don't want it running away, close quote.
And you had that conversation with Jeff Mateer, didn't you?
I had several conversations with Mr. Mateer.
That non-responsive.
Sustained.
Had that conversation with Mr. Mateer, didn't you?
Yes, I had a conversation with Mr. Mateer, but at no point did I say...
That non-responsive.
Excuse me, please be allowed to respond to his question.
Overruled.
Can you repeat the question to me?
You had the conversation that you described here in your testimony to the House Board of Managers with Mr. Mateer, yes?
Yes, sir, I had a conversation.
Thank you. And you made an intentional decision to bring Brandon Kamak on as, I believe you put it, a third set of eyes, yes?
No, sir, I didn't make the decision. I provided a recommendation and a legal justification to do so.
If you look at page 106, lines 5 through 11, what you say is, so I drafted the scope of work for the contract. You're talking about Kamak's contract.
Pardon me, Your Honor. May we approach the bench, please?
Yes, you may. I think the two of you have come to agreement of moving forward.
We
in a
have, I
proper way-
think.
In a proper way. Go
Mr.
ahead.
Hardin will let me know if I mess up.
Members of the jury, come to order.
So, Mr. Vassar, the plan was to bring on Mr. Kamak as, I believe you put it, a third set of eyes. True?
That was my understanding.
Well, tell the ladies and gentlemen of the jury, who were the other two sets of eyes?
I didn't have any specifically, other than Director Maxwell and Mark Penley, I presume, as the two individuals.
And you, did I cut you off?
I'm sorry, we're speaking.
Did I cut you off?
No, sir.
Okay. You anticipated Brandon Kamak providing a report to your office, true?
I did.
And you testified that the Brandon Kamak contract never got to the controller, Michelle Price, true?
That's right. At the time, I don't believe it had.
So just to be clear, you testified before the House Board of Managers that Brandon Kamak's contract never got to the controller, Michelle Price, true?
That was my recollection.
But you were wrong about that, weren't you?
I don't know.
Let's bring up Exhibit AG 130. I believe it's already in evidence. If you can find that for me, Mr. Arroyo. Right there, okay. Would you just highlight the signature blocks for me or zoom in on the signature blocks? Michelle Price, the controller, approved it, yes?
I see that.
So this contract had the money.
I'm sorry, had a what?
It had the money allocated if Michelle Price signed it, true?
Yes, it appears she signed it after I did.
But in the rushed impeachment in this case, you told the House Board of Managers that she never signed it, true?
She had not signed it before I signed it. That was my testimony, as I recall.
Yeah, at the time you gave your testimony to the House Board of Managers, you didn't know. And now you know, right?
Well, yes, I see now that she has signed it.
Leslie French, who's that?
At the time, she was general counsel.
She approved the choice of Brandon Kamak as outside counsel, true?
Yes, she initialed this as indicating approval.
I want to talk briefly about grants, okay? You familiar with applying for federal grants?
Yes, sir.
Okay. Just explain to the ladies and gentlemen of the jury who may not understand the inside baseball of that, why on earth would the wonderful state of Texas need to apply for federal grants for OAG funding?
Well, there are a number of programs that the office administers, such as child support, crime victim services, that are supplemented by state funds, state grants, as well as federal funding.
And where does the money come from?
Well, in each instance, it comes from state appropriations and also federal grant programs.
And does your office have to apply for them with the federal government?
I believe so. There might be one or two instances where there are statutory grants under the federal statutes, but I think most of them are application-based.
And you were responsible for applying for those grants, true?
No, sir. The grants division of the office was responsible for applying.
But you were overseeing them?
No, sir. That's a division that reported to Lacey Mays.
Okay. As part of the Office of General Counsel, or by October 2020, what was your title at the agency?
Deputy for Legal Counsel.
Okay. And so you're giving isn't it true that you gave the Office of the Attorney General legal advice about those grants?
Yes.
Okay. I think I'm over the target now, finally. So my understanding is, correct me if I'm wrong, in October 2020, after you had so-called blown the whistle with your friends, you were still providing legal advice to the Office of Attorney General about grant applications to the federal government, yes?
Yes, sir.
And one of the reservations that you expressed was that the Office of the Attorney General might have some problems applying for federal grants because Ken Paxton was under indictment. True?
That was an issue that came to my mind. Yes, sir.
He was under indictment the whole time you worked there, right?
I'm not sure when it occurred, but I believe that's probably true.
In every other year before October of 2020, you didn't provide that advice to the Office of the Attorney General, true?
That's right.
And in fact, if Ken Paxton was not allowed to sign those grant applications, it might have cost the Attorney General's office between $1 and $10 million in federal money. True?
I don't know the specific numbers, but yes, if we were prohibited as an agency from participating in the federal grant program because of an ongoing indictment or conviction for felony that was prohibited under those federal programs, and it could cost the agency.
So after you blew the whistle on September 30th of 2020, your advice about those grants changed, right?
No, sir.
You were advising the Attorney General's office about this all the way on from before that?
No. What you asked is, did my advice change? The answer is no. I didn't provide advice one way or the other that had changed from the previous years.
Okay. Did you advise the Attorney General's office on those grants before October of 2020?
On the specific grants that...
The federal money, that the $1 to $10 million is supposed to be coming to the state of Texas to help the AG's office.
Right.
Did you provide any advice about that before October of 2020?
Not. So just to clarify your question, these grants are typically on a 2-year cycle in most instances. So each time we would consider those a separate grant. So when you ask if I provided advice on these grants, historically, I would have advised on the legal nature of participating in these grant programs at different years.
Did you ever raise your concerns about the Attorney General's being indicted for securities fraud over the last 8 years to anyone before October of 2020?
I don't recall so.
I need to circle back with you and clean something up on the Public Information Act stuff that we talked about yesterday, okay? I want to make sure I have this right, because I think we may have made a mistake, you and I together, or I may have made the mistake and elicited testimony that was not correct. I want to make sure, okay? You remember the 3 requests we talked about yesterday, right?
Yes.
Okay.
The Securities Board, the big request, the FBI brief.
The FBI brief. So on the FBI brief, yesterday, I believe I elicited testimony from you that the FBI blew their response deadline, but that wasn't right, was it?
I think is what I testified yesterday is I don't recall exactly what the circumstances were regarding the response deadline or any response that we had requested.
What actually happened is the FBI responded when that unredacted brief was requested, but their arguments were so nonsensical or non-responsive to the issue that your opinions division, which is under your oversight, made the decision to release the unredacted brief. True?
I don't recall what the brief said, the FBI's response to the request for the FBI brief itself. I don't recall what the FBI's position was or what the division issued. Just to put it in context, my youngest was born May 30th of 2020. Okay. So I was working out of the office, and at that time, if you recall, the DPS request, the big request, was issued June 2nd. So toward May 30th for the month of June, most of those conversations were directly with Ryan Bagert.
Okay, so is it true that you can't tell the ladies and gentlemen of the jury why the unredacted brief was released?
The unredacted FBI brief was released because General Paxton directed us to release it.
And tell me about what that process was.
Well, in a meeting with General Paxton, at which Ryan Bagert was attending, we identified that the agency, the Office of the Attorney General, had received a request for public information for the FBI brief. General Paxton asked us to provide him a copy of the redacted brief and the unredacted brief.
Yes.
A few days later, we met again, and General Paxton had reviewed it, had marked up the copies, and indicated to both of us that he had seen nothing that should be withheld from Nate Paul.
Did you disagree with him?
Yes, just based on the content of the information.
Was there any claim of law enforcement privilege made by the FBI?
I'm not advised. Again, I don't recall what their brief said.
You don't recall any of the content of what the FBI said in their challenge?
Not in the challenge, no, sir. I recall the content of the FBI brief that was submitted as part of the DPS file.
Okay. I'm going to show you a few other documents, okay? We're going to go to stay on the same topic. This is Exhibit AG 185, Your Honor, if I might approach.
You may.
Have you had an opportunity to review Exhibit AG 185?
Yes, sir.
What is it?
It's a letter dated April 13th, 2020 from the Department of Public Safety to Joseph Larson regarding a public information request referenced as 20-0983.
And Mr. Arroyo, if you'd bring up Exhibit AG 185, thank you so much.
Pardon me.
Counselor, are you offering this?
I am. I thought I did. I'm sorry. Exhibit AG 185, we move for admission, Mr. President.
Mr. Harden?
So I have no objection, but I request that we don't put it up on the easel and pass until we get a ruling, please. Thank you so much.
Agreed.
I agree. Now,
And-
Mr. Arroyo, please.
And Mr. Counselor, since we did break for a half hour earlier, that was kind of our 10:30 break, so we'll go to 12, about 40 minutes, and then we'll have lunch from 12 to 1.
Understood, Judge. Thank you. This is a response from DPS to the big request, right?
It appears to be. I don't recall the exact number of the request, but it appears to be.
So Joe Larson is the vehicle through that Nate Paul is using to make these requests, yes?
It was my understanding. That's right.
And then the lawsuit that Joe Larson filed, he filed that on behalf of Nate Paul, true?
Well, that lawsuit that you showed me yesterday, it identified Mr. Larson as the plaintiff. I don't know why he would have filed it or what reasons he had.
Ultimately, the unredacted FBI brief was released from a lawyer at the Attorney General's office to a lawyer, Joe Larson, who is working for Nate Paul. True?
I believe so.
No one at the Attorney General's office tried to stop it from going out, did they?
Except for our conversations with General Paxton, I don't think anybody stopped it after he instructed us to release it.
But you didn't have any good legal reason to keep it, did you?
I'm not sure what you mean by legal reason to keep it.
You're a lawyer. Did you have a good legal reason to keep it?
Well, we had reasons to believe that the information contained in the brief itself involved law enforcement information under the Public Information Act, because as you mentioned yesterday, the FBI redacted it.
But the FBI didn't assert law enforcement privilege over the brief, did it?
Again, I don't recall what their position was in their briefing that they submitted, just because.
You don't know?
That's right.
Okay. Your Honor, I've got another exhibit. May I approach the witness?
Yes, you may.
Have you seen exhibit AG 253 before?
Yes, sir.
What is it?
This is
Are you offering this?
I was going to lay the predicate first, but I will certainly offer it.
Excuse me, Your Honor. Thank you. We have no objections. If I speed it up.
Exhibit 253, admitted to evidence. Continue.
Thank you. Mr. Arroyo, if you would, exhibit AG 253. Mr. Vassar, what is it?
This is a letter involving private schools in the middle of COVID-19. It's dated July 17th of 2020.
And Attorney General Ken Paxton issued this guidance, correct?
Yes, he signed it, and we issued it from the office.
And it is not a formal legal opinion, correct?
No, it's not a formal opinion decided under 402.
Okay. Did you have kids in a religious school at that time?
No, sir.
Okay. The purpose of this guidance was what?
To provide guidance on how religious private schools could operate in the face of local orders that may contradict the governor's executive orders at the time.
Pretty important stuff, isn't it?
Yes, sir.
And orders like this orders similar to this that were giving informal legal guidance about COVID matters were coming out of your office almost every day. True?
I'm not sure if it was daily, but we were providing advice on a regular basis.
All right. You recall the quote unquote midnight opinion. I believe Mr. Hardin referred to it as the midnight opinion, the foreclosure guidance.
I recall it. Yes, sir.
May I approach the witness, Your Honor?
Yes, you may.
That wasn't even the only COVID guidance issued that day, was it?
I don't recall that specifically either.
Thank you.
Mr. President, we move for admission of Exhibit AG 7.
Mr. Hardin?
I'm trying to get my microphone on, I'm sorry. We have no objection, Your Honor.
Admit exhibit number 7 into evidence.
Have you seen, no, that's not AG 7, this is 260. Will you put AG 7, please, Mr. Arroyo? Thank you, Eric. Eric, would you zoom in on the letterhead here? This is the letterhead of the Office of the Attorney General of the State of Texas. True?
I wouldn't state that it's the only letterhead of the Office of the Attorney General, just based on my previous testimony.
Well, we'll see how common it is in a minute. This is the letterhead that went out on formal statements, legal guidance, and formal legal opinions. True?
Yes, it was used in those instances.
All right. This Exhibit AG 7 was sent to a man named Brian Mookie, who's of the city of Headwood Village. Do you know where the city of Headwood Village is?
No, sir.
It's in the Houston area, but let's zoom out a little bit. Give me to the text, Eric, if you would. And capture Austin's signature too. I'm sorry, sir. What's this about?
This is the first time I've seen this letter that I can recall. It is issued under Section 418.193, which is the Disaster Act. It appears to be in response to a question that the mayor had asked about a local health authority's power to close schools.
And Austin Kinghorn works for you, true?
Yes, sir, at the time.
And you knew this was going out, right?
No, sir.
Why not?
Just based on the substance, this seems more like a pro forma response that doesn't need to be raised to the deputy level to make a decision. This seems to be consistent with advice that we had already issued, and it was essentially reiterating that advice and not taking a contrary statement.
Okay, so Austin, this was a minor enough issue that Austin could do this on his own, right?
No. So Austin worked in the general counsel division. That division chief is responsible for that division. I oversaw that division in addition to other divisions. So I did not have a daily oversight of the activities of that division.
He's in your downline. True?
Yes, sir.
What's the date on this?
August 1st of 2020.
That's a Saturday, isn't it?
Possibly. I don't recall what day that would have fallen on.
It's the same Saturday as the foreclosure guidance. True?
If that was a Saturday, then yes, it would have been the same day.
Well, you know the foreclosure guidance is dated August 1, right?
I don't recall if it's dated August 1. It might be August 2nd.
Isn't it true, sir, that there were so many needs in this big state related to guidance about COVID that your office was working on it constantly?
It was a perpetual theme.
Let's see how perpetual it is. May I approach the witness?
Yes, you may.
Thank you.
We move for admission of Exhibit AG 260.
Give Mr. Harden a moment.
I have no objection.
Admit Exhibit 260 into evidence.
Thank you. Mr. Arroyo, if you would. Same letterhead, yes?
Yes, sir. It's the same as the August 1st letter.
July 28, 2020, 3 days earlier, yes?
Yes, sir.
And who's Doug Sveen? Hope I'm saying that right.
This letter indicates he's the mayor of Stephenville, Texas.
He's asking about closure of schools, right?
That's right.
May I approach the witness, Your Honor?
Yes, you may.
I'm going to try to do this in bulk and maybe move this along a little bit. Your Honor, we move for admission of AG Exhibits 259 and 6.
We have no objection, and we have no objection to 289, and we have no objection to Exhibit 6.
Admit Exhibit 6 and 259 into evidence.
Mr. Arroyo, Exhibit 259, please. Who's Craig Morgan?
This letter refers to him as the mayor of Round Rock.
That's on a Thursday before August 1st, right?
Sure.
What's it about?
This is appears to be the city of Round Rock's decision to move its local election from November 3rd of 2020 to May of 2021.
Why do they want to move it?
I think the reason that they had stated was because of COVID.
Who issued the opinion?
It was signed by General Paxton.
Does it have a KP number?
No, sir.
Not a formal legal opinion, true?
No, it was not issued as a formal opinion under 402.
Mr. Arroyo, Exhibit 6, please. AG Exhibit 6. August 3, Monday. Who's the Honorable Vince Ryan?
The Harris County Attorney.
This is a formal legal opinion, yes?
Yes, this is a formal opinion issued under Chapter 402.
Tell the ladies and gentlemen of the jury how they can tell by looking at this document that it's a formal legal opinion.
After the mailing address, there is an opinion number that's referenced. And then in the subject line, there is a request number that's also referenced.
And every formal legal opinion from the Office of the Attorney General under Chapter 402 of the Government Code has both. True?
Yes.
And what's this letter about?
It's regarding the county authority to require masks in courtrooms, courthouses, and county buildings.
Okay, so correct me if I'm wrong. July 28th, July 30th, August 1, August 3. There are opinions coming out almost every day about COVID stuff during this period of time, true?
Well, again, to clarify, a lot of the questions that we would get would follow the governor's executive orders, which were coming out in different points. So if an executive order was issued, the frequency of our requests for advice might increase. I can't testify that we were releasing information daily. I don't know if that's actually true, but I can say it was happening regularly just with the pattern of executive orders or mayoral or county orders.
Isn't it true that the office was constantly adapting to the executive orders of the governor's office, the executive orders of President Donald J. Trump?
This clown
Absolutely.
show.
And that actually increased the amount of informal legal advice and the need for it on a literally day-to-day basis.
Well, again, it was very frequent, just given the number of agencies that were involved on a state level as well as the federal level.
Mr. President, a moment, if I may.
Yes?
Oh, I'm sorry. I apologize. I thought you were passing the witness.
No, you ought to keep coming. Pass the witness.
I apologize.
Mr. Harden, he passed the witness. Just you standing up made it all happen. We'll go to the top of the hour, Mr. Harden.
Good morning, Mr. Bachelor.
Good morning.
I'm going to try to, best I can, to do this pretty quickly. Thank you so much. We've got several areas here. We can just start where we finished up. I thought I would never have to talk about the different numbers of the different portions of the government code that suggested what y'all should and should not do. But I think council's appropriately covered back on the issue, and so I feel compelled to a little bit just try to clear this up just a tad. The two sections of the government code that you folks would have been working over primarily, that you've been testifying to council about on cross, are what numbers in the code?
Chapter 402 of the government code and chapter 418.
All right. Now, let me see if I can do this briefly with you. How do you determine which of those codes apply to a request for an opinion, or the sections of the code, excuse me?
So chapter 402 enables the Attorney General to provide general legal guidance in response to a request from an eligible requester. Chapter 418 is expressly limited to providing advice relating to a disaster declaration, again, to eligible requesters who are different from Chapter 402.
All right. For instance, does which one of those sections apply depend on the identity of the requester that makes the request?
Yes, sir.
And does 418, something that I believe, did you testify earlier, that 418 was amended, the National Disaster Act, before COVID, but when COVID came, was frequently used as the basis as to answer a query from a public official?
That's correct. I believe it was amended in 2019. Obviously, COVID hit in 2020, so that provided an avenue for local officials to request legal advice from our office.
Now, if when General Paxton requested y'all to do this hurry up opinion, if he had come up with a requester that was a mayor, what section of the code would have applied to the opinion that you folks wrote?
Just based on the fact that it was a COVID-related question and that the mayor is an authorized requester, it would have fallen under Chapter 418.
Now, once it was decided that the requester would be a state senator, which section of the code did that mean would cover what you did?
A state senator who is a chair of a legislative committee.
Thank you. Excuse me for interrupting you. That's the caveat. It's not just a state senator, but it has to be a chairman, does it not?
That's right.
All right, resume the answer, please.
A state senator who is a chair of a legislative committee is an authorized requester under Chapter 402.
All right. And is the significance that 402 was applied here is that Section 402 does not distinguish between an informal and a formal opinion, correct?
That's correct. It does not.
Now, if we move forward, that it had gone through if it hadn't been a hurry up and went through your normal process as you testified that would take ordinarily about 6 months, is there a difference in the way the 6 month opinions which are vetted and published in 6 months as opposed to overnight is with what we've called this opinion? What would be the difference in the way those two opinions, heavily researched, vetted opinion, overnight opinion, how are those reported to the public and dealt with as far as publishing to the world?
So under Chapter 402, if it's an eligible request, our agency logs it as a request, publishes that request in the Texas Register, which enables third parties who are just interested in submitting their own briefing and arguments to our office. After a drafting period in the division, it's reviewed internally, and including other divisions who might have subject matter expertise on the issue. After all of the division feedback is received, it's circulated to the deputy level and the executive for review and approval. After it is issued, it's then, again, recorded on our website and then published in the Texas Register for public dissemination. And I believe it's also uploaded to Westlaw.
So is one much more widely distributed and easily published to the world than the other?
Yes, sir.
Finally, you were asked about things I think you said you did not know about in terms of the next day or a hearing that you were not involved about, correct?
The hearing.
Very good question. Let me rephrase it. That's a very good question. Do you recall being questioned about what you knew about how the overnight opinion was used on behalf of Mr. Paul?
Yes, I recall that.
You recall you said you were not aware at the time. Do you recall that?
That's right.
All right. Have you become aware, and did you see a document during your examination that showed a lawyer on behalf of Mr. Paul immediately within 36 hours or 24 hours was using that in a court to try to get what he wanted?
Yes, sir. I believe in one of the exhibits that I reviewed, there was a statement indicating that the foreclosure letter that we had issued was used to stop a foreclosure sale related to Nate Paul.
Do you have any idea how one would have known as early as Monday to be prepared to use that in a hearing on Tuesday when you only completed it at 1 o'clock Sunday morning and sent it to the Attorney General sometime Sunday?
Objection, Mr. President, leading and calls for speculation.
Sustained.
Now, let's go to a couple other areas. You recall you were questioned considerably about first of all, the interview that he asked you about a little bit toward the end. And that is that you were not under oath at that hearing.
I recall that. Yes, sir.
And I said hearing, I don't mean hearing. It was really an interview by investigators, many are here today, that were retained by the House Management Committee, or the House Committee rather, to do an investigation. You recall that series of events?
Yes, sir.
And I believe you were shown some of the testimony, again, not testimony, some of the interview statement that you gave.
Yes, sir.
Now, did you readily agree to have it videotaped?
Yes, I believe when I sat down, there was a recording that was going to be used for my interview.
Do you remember sort of a sort of fumbling around that nobody had a recorder? They had to go get one?
Yes, sir.
All right. But at any rate, ultimately, when that happened, did you have any objection to it being videotaped and audioed?
No, sir.
Now, did anybody at all suggest placing you under oath?
No, sir.
Do you know enough about law enforcement as to whether or not ordinarily, if somebody's trying to gather information as part of a law enforcement information or investigation, where they would swear to people when they're just trying to get people to tell them what happened?
Your Honor, I have to object to this being argumentative and sidebar.
I withdraw.
Sustained.
Thank you, Judge. Thank you. I'll withdraw the question, but I waited too late. All right. So, if I may, at any rate, you gave that interview, correct? And
Right.
I told him. And that interview was totally available as evidenced by questions you got to the other side, correct?
I believe so, yes. I'm not, yes.
And in that one item that came up with, there's no suggestion that you've testified any differently today than you did to these investigators, correct?
Objection, leading and argumentative.
Sustained.
Are you under oath today?
Yes, sir, I am.
Did you testify today the same you did to these House investigators?
Yes, sir.
Can we take that as evidence of the fact nobody's suggesting otherwise?
Object to the argument, Mr. President.
Now,
Sustained.
if I can, you were asked about evidence. Do you recall this? Evidence that you took to the FBI.
Yes, sir, I recall.
And 7 of you went to the FBI, did you not, on the 30th of September 2020?
Yes, sir.
And you took no documents, did you?
That's right. No documents.
Who did you take?
We took ourselves
And you took yourselves to do what?
to provide an explanation of the sequences of events that we had determined
Well, when
revealed information tending to show that General Paxton had abused his office and the powers and responsibility and trust that millions of Texans bestowed upon him to benefit one individual.
And when you went, if you had taken things with you, you would have had to take things that were the property of the Attorney General's office, wouldn't you?
Objection, Your Honor. Calls for speculation and a legal conclusion.
Excuse me.
Sustained.
Would you have had any documents other than things that were circulated and created right there in the AG's office?
Objection, Your Honor. Speculation and argument.
I'm just asking, I'm really asking him if anything they took would have had to, as evidence, would have had to be property of the Attorney General's office.
Overruled, you may
Thank you.
answer the question.
You can answer that.
All of the information would have been information that we had obtained just by virtue of our employment at the agency.
Now, when you answered the question, you recall answering the question is you had no evidence that you took to the FBI in that meeting, correct? Do you recall that answer?
Yes, sir, I do.
Well, tell me what you mean by that answer when you say you took no evidence.
Well, the way that I interpreted opposing counsel's question was documents, documentary evidence of what we took to the meeting with the FBI for law enforcement.
After this position, you might want to say, thank God, but you're not a trial lawyer, are you?
No, sir.
Do you have any idea how evidence is defined in terms of law
I like
enforcement
this
or people
color combination
wanting
from
to
the house.
find out what happened in a situation?
Objection, Your Honor. Calls for speculation. Legal
No,
conclusion.
I'm asking his mind.
argument.
Does he have any idea? That's all I'm asking.
Sustained. Rephrase.
All right. In this particular situation, did you take your body?
Yes, sir.
Did you take your voice?
Yes, sir.
Did you take your brain?
Yes, sir.
Did you take your experience?
Yes, sir.
Did you take your knowledge of the last 9 months?
Yes, sir.
Did you take what things you personally knew of in addition to going with people who may have known other things?
Absolutely.
Did you tell the FBI that?
Every bit of it.
Do you realize in the legal world that is evidence?
Objection leading.
No, that is simply a fact statement. That is not leading, in my
Sustained.
respect. And the court disagrees, which is why we're here. Let me ask you this. If you told all of those people what you knew in your mind and what you were concerned about, what is your opinion now after the primer we just did as to whether you gave the FBI evidence?
Object leading, argumentative. This is closing statement, not a question for the witness.
I've asked him what his opinion, excuse me, Your Honor, I asked him what his opinion is. I didn't
Overruled.
ask him. Thank you.
My opinion was that our experiences were evidence, but we did not conduct our own investigation to provide documentary evidence of what we had come to learn.
Well, what did you provide him?
Just our experiences.
What do you mean?
The situations in which General Paxton asked us to act involving Nick Paul, the cumulative knowledge of the conversations that we had as a group between September 29th and the morning of September 30th, once the grand jury subpoenas for Brandon Kamek started coming to the office.
Whose job then, in your opinion, was it then to conduct the investigation?
Federal law enforcement.
Did you ever view yourself as an investigator in this matter?
No, sir.
What did you think you were when you went to the FBI?
We were witnesses.
Pardon me?
I believe that I was a witness to criminal activity that had occurred by General Paxton.
Do you know of any other occasion in which the Attorney General involved himself in the drafting of an opinion such as what you did in August on the issue of foreclosures?
I can't think of any. No, sir.
Finally, maybe from your age, you don't know this. Are you familiar with the movie Cool Hand Luke?
I've heard of it. I'm not familiar with it.
You ever see the scene in a very, very bad moment in the movie, for at least a bad moment for Paul Newman, in which the bad guy stands over there as he's digging and says, what we have here is a failure. Let me just finish. A failure to communicate. That's just the question.
Overruled, and you were allowed to finish.
Thank you. Have you?
I've not.
All right. Let's talk about these supposed altered documents. All right? You tried several times, did you not, on your cross to explain there were different types of letterhead papers in the AG's office. Do you recall telling him that?
Yes, sir.
You recall he went right by. He didn't want to deal with that, did he?
That's right.
All right. Well, let's deal with it real quickly. For instance, in the Attorney General's office, did y'all periodically use one type of paper that did not have General Paxton's on it and another type of paper that did?
Yes, sir.
Do you have any idea how the circumstances were that dictated which you would use?
No, sir.
All right. On the occasion when the letter that we've been talking about, that they have been complaining was altered and the Attorney General's name was taken off, was that letter complaining about the Attorney General?
Yes, sir, it was.
Well, if you're writing a letter complaining about the Attorney General, what is your opinion as whether you would want to make sure his name wasn't on there for a letter complaining about him?
Objection leading.
Sustained.
Let me ask you this. I'm going to show you a letter that is already in evidence, Exhibit 127. May I have it on the screen, please? Is that an altered letter?
Counselor, excuse me, we don't show that being already entered.
You do not show it's in?
Oh, it's in.
Thank you.
Our apology.
No, not at all. I misled you by making you think which one it was. We were both inadvertent. But I think it is interesting to point. Would you look down to the bottom? Would you cyclize where the exhibit and whose exhibit this is? And let's sort of, if we can, highlight, Stacy, both from whom the production was that produced it to us. OAG stands for what?
The Office of the Attorney General.
And are you familiar enough reluctantly about this process to know what AG exhibit means?
That appears to be a reference to an exhibit that the Attorney General's defense team has offered as evidence.
Yes. Would you expect them to offer an altered document?
No, sir, I would not.
All right. Well, in this offer, is the Attorney General's name on it?
His name is not on the seal at the top of the document.
Is this seal identical to the seal that y'all used for the letter you wrote before you went to the FBI?
Yes, sir, it is.
Or after you came back? I can't remember what. I don't want to misstate what it was.
It was drafted and reported or sent to HR after we returned from meeting with law enforcement.
All right. So it would have been on the 20th when you came back on the 30th.
30th.
When you came back on the 30th. Thank you. All right. Now, let's go to the next to last page, I believe, of this exhibit. Do you see who it's signed by?
It's signed by Jeff Petier.
Now, Stacy, just to test your agility, will you go back to the front page again and isolate the date this was? What's the date?
That date is October 1st of 2020.
All right. Now I'm going to show you some that have not been introduced, and I will first tender. Do we have copies of our exhibit 633? I'm going to move to introduce. I was waiting for you to review it.
Oh, thank you. No objection, Judge.
Admit exhibit 633 into evidence.
Can you put it up on the screen, please? Thank you. Would you give it publish for the jury the date of this letter?
This letter is dated January 28th of 2020.
Yes. And would this have been in connection with any particular event? Have you ever seen this letter, or do you know anything about this?
I don't recall exactly if I was involved in reviewing it. Again, I was appointed Deputy AG for Legal Counsel April 1st of 2020. It's possible I reviewed it, excuse me, in the General Counsel Division, but I have not seen it since.
And the letter is signed by whom?
It's signed by General Paxton.
Now, we
And
can assume, can we not, that General Paxton didn't alter this letter?
I wouldn't presume so.
And is it also similar to the letter y'all sent on paper that has just the seal?
That's the same seal. Yes, sir.
So let's once again make sure there's no misunderstanding. Or do you understand for the last 4 days you folks have been accused of altering a document?
This is a violation of the rule,
Excuse
Mr.
me.
President.
Let me put it another way. I'll put it another way, Your Honor.
Was there an objection?
Objection, violates the rule.
Sustained.
If anybody was to suggest that you guys had, when you wrote your letter, that you had somehow altered it and taken the Attorney General's name off and therefore altered a government document, would that be true or not true?
That's not true.
Would it actually be a lie?
As these documents indicate, there are different seals for different purposes. And in this situation, we used the seal without General Paxton's name on it. That's the seal that was.
You are indeed, are you not, Mr. Vassar, a kind and gentle person? So much so that even after enduring yelling and constant interruption, you still don't like to use the word lie, do you?
Objection to leading an
I
argument.
have no further questions.
Objection sustained. We will hold your, do you intend to recross?
I do, Mr. President, but I could probably resolve it in about 3 minutes.
I'll give you 3 minutes.
Thank you, Judge.
And 5 at the most. There you go.
I will try to yield some back, Mr. President. So it's okay to give your personal lawyer documents from inside the Office of the Attorney General, but not the FBI, right?
I provided documents under a grand jury subpoena that I received to my lawyer, so I don't know what the implication is.
You had internal OAG documents, to wit, a series of grand jury subpoenas that were served by Brandon Kamak that you sent to your personal lawyer, but you didn't bring any documents to the FBI, right?
That's absolutely true.
And you went to the FBI, David Maxwell went to Travis County, they investigated, and they still have done nothing, true?
I don't know what they found. I know it's an ongoing investigation.
Mr. Hardin talked to you about the letter that Nate Paul wrote to the court about the OAG foreclosure guidance. Do you recall that testimony, those questions?
Yes.
All right, Your Honor, Mr. President, I have one copy of AG Exhibit 286. If I may, I will tender it to Mr. Hardin for his review, and then to Your Honor, and then to Mr. Vassar.
You may.
I have no objection.
What is the number on that?
Mr. President, is AG Exhibit 286, and we move for its admission.
The exhibit 286 will be admitted into evidence.
Mr. Arroyo, if you could assist us, please, very briefly. Mr. Vassar, who's Stephen Benish?
I have no idea.
You should know him. He's your state bar president-elect. This is a letter from Stephen Benish, who was opposing counsel to Nate Paul in the WC 4th and Colorado matter. And he wrote a letter. Mr. Arroyo, please blow up the text of his letter. Mr. Benish says in response to Nate Paul's letter, like lawyers often do, I disagree. And he wrote to the judge and he said, the foreclosure sale isn't being stopped by this OAG informal guidance, right?
I've never seen this before, but I see where he says the AG's quote informal guidance does not emphasize state that foreclosure sales may not proceed unless specifically authorized by the mayor in the city of the foreclosure.
And what happens in courts is one side makes an argument and the other side makes an argument and the judge decides, right?
Yes, sir.
Only in this case, Nate Paul put his entity in bankruptcy to stop the foreclosure, right?
I'm not sure.
That will be all, Mr. President.
Thank you, Counselor. We will break until 1 p.m. Could I have one of the House managers come up and one from the defense come up just to clarify if the witness has been excused? I want to be sure there was not a redirect or reread. Okay.
Okay, guys, I want to thank everybody for being here. Thank you guys for watching, and they'll be back soon. Everybody go and get some lunch. All right, and enjoy yourselves. And I will check back in here in a couple more hours. I'm at work right now, so I'm limited on how much I can contribute. But thank all of you guys. Please like and share this out so that people can see this absolute clown show of an impeachment. TakingBackTexas.org is our website. You can go there and see all of our reports. We don't have our poll watchers training publicly available. We've been training poll watchers since early 2021. Our training has grown and evolved into the most comprehensive election security course that I've come across. And that's saying something because I was trained by Dr. Laura Presley, and her poll watchers training is very good, and you'll need to take hers. It's vital. It's very specific, so don't take her course unless you're ready to be serious. Okay, my course is good for beginners, but Dr. Presley's course is very, very, very serious, very strict and technical. Okay, so you got to pay attention. But y'all can come and take my course as well, especially if you're just trying to get into this. We give you the full picture. Okay, we give you as much information as we can. So takingbacktexas.org. We're going to post our next training up on that website. It'll be on our home screen. Okay, all right, well, thank you guys, and we'll be back soon. Go get some lunch.
Bailiff, will you bring in Ranger Maxwell? Council, there's some documents up here left over. I'm not sure whose they are. Okay. Thank you.
Please don't ask me to control the witness.
Mr. Maxwell, did you swear in the other day? You did not? I did not. Okay. Repeat after me. I do solemnly swear and affirm. I do solemnly swear and affirm. And affirm. As a witness in the impeachment proceeding. Shall be admitted. I'm sorry. I read the wrong line. Let me start from the beginning. I do solemnly swear and affirm, you've read that the evidence I give upon this hearing, the Senate of Texas impeachment, charges against Warren Kenneth Paxton Jr. Shall be the truth, the whole truth, and nothing but the truth. So help me God. Please be seated. You may begin.
If you'll move that microphone pretty close, we have a little problem with acoustics in here. Please tell the senators your name. Yep. Yeah.
There we go. My name is David Maxwell.
Mr. Maxwell, your last position with the Attorney General was as Director of Law Enforcement. Is that correct?
That is correct.
I want to ask you some questions about your law enforcement career. Can you tell us where you started and when?
I started in 1972 with the Texas Department of Public Safety. I went through the patrol school, graduated April 6 of 1973. Spent 8 years working highway patrol in Harris County. I promoted to narcotics in 1981 and worked narcotics in Harris County for 5 years. Then promoted to Texas Rangers in 1986.
Let me stop you there just for a second. Those of us who are raised in Texas know a lot about, or think we know a lot about the Texas Rangers. What does it take to become a Texas Ranger?
First of all, you have to have 8 years of experience with DPS to be able to apply for the position. When I applied in 1986, it was a little different than it is now, but we had to take a written examination to qualify to go before the oral interview board. And then they would score the oral interview board and combine the two, and then they took the top 5 people and put them on a list for 1 year. If you didn't get promoted in that 1 year, you went back to the first step and started over.
How long did you serve the state of Texas as a Texas Ranger?
25 years as Texas Ranger.
And when you left the Ranger service, where did you go?
I went to the Texas Attorney General's office.
What was your first position there?
My first position was Deputy Director of Law Enforcement.
And did you promote to the Director of Law Enforcement?
I did.
I want to pull up for, please, the organizational chart. It'll be in front of you. I'll ask you a couple of questions about that.
Okay.
Your name and or yes, your name has been highlighted, and it appears to be on a level with other deputies. So what was your rank in the Attorney General's office as it relates to the Deputy Attorney Generals?
I was the executive deputy over Law Enforcement Division.
Is that an equal rank with the deputies that were deputies over the other divisions of the Attorney General's office?
Yes, and I was the most senior deputy.
Most senior, how?
I had more time as an executive deputy than the others who were working with me at that time.
How many employees, law enforcement officers and support staff, as well as attorneys, did you supervise?
I had about 350 employees. 205 were commissioned officers, and 19 of them were attorneys.
Were those employees spread out across the state, or were they only in Austin?
We had a majority of them in Austin, but we also had offices around the state.
What is and was, when you were director, the authority of the Law Enforcement Division of the Attorney General's office?
The authority was that of other peace officers in the state. We had jurisdiction over any type of crime that would be committed against the state of Texas.
Did you have a criteria for opening a case as an investigator to be investigated by the Attorney General's office criminal division?
I did.
What was that criteria?
This is the criteria that I set up for investigating public officials. So I had certain requirements. And first of all, I reviewed all the requests that came in for investigations on public officials. And we had a lot of requests, and I didn't approve but just a few every year. We already worked as many cases on public corruption as the Texas Rangers have statutory authority. So we worked.
Excuse me, Your Honor, excuse me, non-responsive. The question was, what was your criteria?
What was your criteria for opening an investigation?
The criteria was, at first, I had to have a sworn signed statement from the person who was making the allegation. The second thing was that I had to have a letter from the district attorney who had jurisdiction over the possible cases, saying that they would prosecute those cases if we were able to prove that a case was viable.
Why did you have a criteria such as that, particularly when it comes to investigating public officials?
I set up the criteria in order not to be pulled into situations that are strictly political in nature. I did not want us to be in a position of investigating public officials when there was really no crime being committed.
And did this criteria particularly apply to investigations of public integrity?
Yes.
Do you know who was the district attorney in Travis County in the year 2020?
Margaret Moore.
Did you have a good relationship with Margaret Moore?
I did.
I want to get right to the matters here. Were you asked in some way to meet with a person named Nate Paul?
Yes.
Who asked you to do that?
Jeff Mateer.
Where did Jeff Mateer tell you who had told him to have you meet with Nate Paul?
Objection, hearsay.
That's not hearsay under 803 and 801E2D, Your Honor, with respect.
Mr. Mateer is not alleged to have been a co-conspirator. Objection, hearsay.
It's not.
Hold on one moment. Hold on. And we've been doing a really good job of not using a lot of numbers. I have my whole chart here. It's better for just to say what the answer objection is, but this is why I have legal counsel here.
Yes, it's 801
Yes.
E2D.
Overruled.
All right, you may state your answer. And the question is, did Mr. Mateer tell you who ordered him to order you to meet with Nate Paul?
Yes.
What did he say?
He said General Paxton ordered me to meet with this individual, that he had a story to tell.
At about the same time, did you hear from an employee of the Travis County District Attorney's Office about Nate Paul?
I did.
I'm going to ask you about that in a minute, but when you first were asked to meet with Nate Paul, did you do some research of your own?
I did.
And what did you find?
I found on the internet that...
Excuse me, with all due respect to Ranger Maxwell, if he's going to recite information that he obtained doing his research, that would be hearsay.
It goes to his state of mind in conducting the investigation, Your Honor, and thus is not hearsay.
It is hearsay.
Well,
overruled. Continue.
okay. So what did you find when you made your initial investigation of Nate Paul?
I found that Nate Paul was being investigated by the FBI, that they had run search warrants in August of 2019 on his business and his home and a storage facility. I found articles in business journals that talked about lawsuits.
Excuse me. Objection, hearsay. Articles in business journals, that's definitionally hearsay.
Again, it goes to his state of mind, and it's the same. He's answering the same question that the court allowed.
With all due respect, he can testify to what's in his mind under this exception. He can't testify as what the article said.
Sustained.
Nonetheless, did you form an opinion of your state of mind?
I did.
And what was that?
My opinion that Nate Paul was a criminal and that we should not be associated with Nate Paul.
At about the same time, did you receive communication from the Travis County District Attorney's Office?
I did.
Your Honor, we have an agreement on House Exhibit 615, which we moved to introduce.
Could I see it, Dick, real quick? I'm sure you're right. Yes. No objection.
It's been admitted. Both sides have agreed.
If we could bring up closer, yeah. I'm being told to tell you to get closer to the mic.
Mr. Maxwell, they just asked you to get closer to the mic when you speak.
Closer to the mic?
Yeah.
Is that better?
You can pull that towards you a little bit if you'd like.
Okay.
You can pull the whole outfit closer to you.
Okay.
This is the first page. This is the email, and it references a letter. Let's go to the second page, please.
Yes, it was from Don Clemmer.
All right, here's a letter from Don Clemmer. It's dated June 10th, 2020. It's to you. And let's just read it into the record. I am forwarding to you the attached complaint, which was recently received by my office regarding allegations of misconduct by employees of the State Securities Board, the Federal Bureau of Investigations, the Department of Public Safety, the United States Attorney's Office for the Western District of Texas, and a federal magistrate. My office would typically forward such a complaint to the Public Integrity Unit of the Texas Rangers for review. However, since an employee of the Department of Public Safety is one of the subjects of the complaint, referral to the Rangers would appear inappropriate. I am therefore requesting that your agency conduct the review. My first question, is the word review significant?
Yes.
What is its significance?
In the protocols that we had set forth, we first review the request before we ever make a determination on whether we'd actually open up an investigation.
Now, you're familiar with a district attorney's office excusing or recusing itself from an investigation, aren't you?
Yes.
Is that what this was?
Yes, they were forwarding it to us. They didn't feel like that it was up to them to do this investigation.
Now, we saw the email that Mr. Clemmer sent about the same time, and it mentions that you should call him if you'd like. Did you call him?
Yes, I did.
And did you talk to him?
Yes, I did.
What did he tell you?
Excuse me, objection.
It comes in, I know he's going to object to hearsay. Under Rule 803.3, it's an expression by Mr. Clemmer of his then existing motive, intent, and plan.
Not only do I have to object, I want to object. Hearsay.
Yeah. Sustained.
Maybe I didn't clearly state my citation of the code or of the evidence rules, Your Honor, 803.3.
I've ruled. Continue.
All right. Whatever, and don't go into the words that Mr. Clemmer said, was it consistent with what you had already found or the suspicions that you already had?
Yes.
And what were your suspicions?
That the referral was being requested by General Paxton.
And what about the validity of the referral and the complaint?
Excuse me, objection, conjecture, and speculation.
Oh, this would be his evaluation, which was his job to do.
He hasn't done anything yet. Objection, conjecture, and speculation. You're asking him to testify as to the validity of a complaint which he hasn't investigated yet. That would be conjecture and speculation.
Let me lay a letter.
Overruled.
Okay, go ahead.
I can answer the question?
Yes.
My evaluation of the allegations made by Nate Paul is that they were absolutely ludicrous, without merit, no probable cause, not even reasonable belief that a crime had been committed.
Now let me step aside for just a moment and say, or ask you, what were the nature of the allegations that Mr. Nate Paul was making?
The nature of the allegations that he was making were against the FBI, a investigator with the Texas State Security Board, 2 U.S. attorneys, the senior federal magistrate, Mark Lane, and others who were involved in the chain of the signing and execution of the search warrants on his business, his place of storage, and also his home.
Now, one of your areas to investigate, one of your duties was to investigate public integrity, correct?
Yes.
If there had been credible allegations against the State Securities Board, the DPS, the FBI, federal magistrate, U.S. attorney, would you have any hesitation of going forward?
Objection, excuse me, objection, bolstering, and self-serving.
Overruled. Continue.
You may answer.
No, I would not.
Did you have any hesitation even to meet with Nate Paul?
I did not want to meet with Nate Paul, and I expressed my concerns to Jeff Mateer about that.
And what was the reply?
He said that he was getting a lot of pressure from General Paxton for me to do this.
All right. Let's go to July the 21st of 2020. Did you have a meeting with Nate Paul and his lawyer?
I did.
What was the reason you had that meeting?
I told Jeff Mateer that I would consent to let him tell his story, and that if he made any statements against his interest, I would report it to the FBI.
So on July the 21st, did you have the meeting?
I did.
Where?
It was on the first floor of the Clements building. It was in the office of our security office, where we have a conference room that has the capability of recording video and sound.
Who wanted that to be done? That is, record by video and sound the meeting, but with Nate Paul and his lawyer and yourself?
Me.
Are you familiar with a report that was later put out by the Attorney General's office claiming that General Paxton wanted that meeting recorded?
That is false.
So, have you reviewed the transcript of that meeting?
I have.
Are you aware that the lawyers for General Paxton have been supplied with both the audio and video and transcript of that meeting? What took place?
Okay. Yes, I'm aware of that.
Okay. What took place at that meeting?
Say it again.
What took place at that meeting?
Nate Paul laid out his conspiracy theory about what happened the day of the search warrants were executed. He had complaints about the procedural part that the FBI took when they were securing the scene and conducting the searches. And then he laid out his conspiracy theory that they had originally come to search for not records, but for drugs and guns. And that in the middle of the search, when they didn't find any drugs and guns, they then altered the search warrant to be the search warrant that was executed, where it was for records. And he further stated that the people involved in that was the FBI agent, the agent from the Texas Securities Board, Alan Bowie, who was at AUSA, and Mark Lane, the senior magistrate.
So according to his complaint, a United States federal magistrate was involved in this conspiracy?
That's correct.
As a law enforcement officer of many years, what did you think of that?
It was ludicrous.
Did you ask for any documentation?
Yes, I did.
Are you familiar with the crime of obstruction of justice?
I am.
Are you familiar with the crime of interference of a law enforcement investigation?
Of a federal investigation, yes, I am.
What concerns did you have if you had started an investigation based on these claims by Mr. Paul?
My concerns that we would be interfering with a federal investigation. We could be charged with obstruction of justice, and based on a complaint that has absolutely no merit.
And at this time, even at this meeting, had your criteria for opening an investigation been satisfied?
No.
How so?
It doesn't meet any of my requirements.
After that meeting with Mr. Paul, and his lawyer, by the way, was Michael Wynn?
Michael Wynn was there.
Okay. After that meeting with Mr. Paul, did you have a meeting with the Attorney General, General Paxton?
I did not after that meeting immediately, no.
But no, I don't mean that same day. But did you personally talk to Ken Paxton, the Attorney General, about what had happened in that meeting?
No, I did not.
What did you tell him about the meeting?
I'm sorry. I thought he said he did not meet with Mr. Paxton. And you just asked him what he told Paxton. One of us is confused.
Can we clarify that?
Yeah, could you clarify that? Did you tell him what you thought about that meeting?
I told him before the meeting ever occurred what I thought about us being involved with Nate Paul. That happened before the first meeting.
And what did you tell him?
I told him that he was a
I'm
criminal.
sorry. Excuse me, Granger. Objection, ask and answer. He just got through telling us what he told Paxton.
I don't believe it was asked. I don't believe he answered fully what I'm driving at. What did he tell General Paxton?
I'll sustain the objection and you can try one more time again.
Maybe I'm not clear on it. Did you at some time tell General Paxton what you thought about this idea of Mr. Paul, that there was a vast conspiracy against him?
Yes.
What did you tell him?
I told him that Nate Paul was a criminal. He was running a Ponzi scheme that would rival Billy Saul Estes, and that if he didn't get away from this individual and stop doing what he was doing, he was going to get himself indicted.
Nonetheless, was there a second meeting between you and Nate Paul and Nate Paul's lawyer and Mark Penley?
There was.
Why was there a second meeting if you felt like you did after that first meeting?
Because he had talked to he had talked to Mark Penley and told him he wanted him to conduct another meeting with Nate Paul.
When you say he, are you referring to General Paxton?
General Paxton, that's correct.
So General Paxton had told Mr. Penley to get involved in this?
That is correct.
Excuse me. Objection. I'm sorry, Dick. Objection, ask and answer. Ranger Maxwell will give his testimony and Dick will ask him to repeat the same thing. Ask and answer.
I'm going to overrule that. Continue.
Yeah, I wanted to clarify and make sure that we understand. Mark Penley told you that General Paxton had ordered him to now get involved?
This is the third time. Objection, ask and answer. He literally just got through testifying to that.
I believe that you
Sustain.
allowed me to ask that.
Sustain.
All right. So did you have a second meeting?
We did.
And was Mr. Penley involved in this one?
He was.
And what was Mr. Penley's role in the Attorney General's office? If we could have that organizational chart again.
Mr. Penley was the executive deputy over criminal prosecution.
So in this chart, he's just next to you, and it's now been highlighted for them for the jurors.
That's correct.
Was he your superior or was he an equal of yours?
He was an equal.
And what was Mr. Penley's background, briefly?
He came to us from the U.S. Attorney's Office out of Dallas, where he'd been an assistant U.S. attorney.
So at this second meeting, where did it happen?
In the same place as before, in the Clements Building, ground floor, the security office, conference room.
Was it audio, video recorded?
It was.
And is there a transcript of that?
There is.
Have you reviewed that?
I have.
Are you aware that that has been provided to Attorney General Paxton's lawyers?
Yes.
All right. Who wanted that meeting recorded?
I did.
If there's any suggestion that General Paxton wanted that recorded, is that true or false?
Objection,
false.
asked and answered.
That was the first one. That was the first one that we referred to.
Overruled.
Go ahead.
It's false.
Was there anything new brought up in that meeting as far as you were concerned? You were in both meetings.
He and his lawyer again reiterated the complaints and their conspiracy theory as they had done in the first meeting. I advised them.
Objection. Excuse me.
What did you advise?
Excuse me, Dick. The objection is non-responsive. The question was there anything new? Now,
What was that
now Ranger
caption? Did y'all see
Maxwell is
that
going
just
into
now?
what he told them. That's a
That was
different answer.
inappropriate.
Sustained.
It's correct, and I was trying to meet his objection by going to the next question. So what, go ahead. The next question is, what happened?
What happened? So during the meeting, they continued to lay out their objections about what happened in the search warrants and the conspiracy theory about how all these different individuals came together and falsified a search warrant during the middle of the search. And I told them that if they believe that to be true, then why aren't they in the office of the Inspector General's office for the federal government, which has the authority to look into any of these complaints? And the FBI, the U.S. Attorney's Office, the federal magistrate has to cooperate with them. And I asked them, why aren't you in that office?
Did you get a satisfactory answer to that?
They danced around the answer, but they said they felt like they were in the right place with us.
Did you receive any kind of documents to corroborate or to support that the search warrant had been changed mid-search?
They gave us some documents. They were supposed to give us all the documents, but when we reviewed the documents they gave us, it was not very much. And it certainly wasn't enough for us to really make a determination.
Even still, did you submit those documents to some experts within your office?
I did.
And what's the expertise of the people that you submitted these documents to?
This is my forensics section who does all the forensics on computers and cell phones for criminal cases. And we do that work not only for ourselves, but for the Texas Rangers and others.
All right. By this time, which is, that meeting was August the 5th, by this time, had you become aware yet that General Paxton had ordered Josh Godbee and Mr. McCarty to push a charity to settle in a lawsuit?
Objection.
And by that time...
Excuse me, Dick. Objection, leading and assuming facts not in evidence to this witness.
Just asking if he was aware.
Sustained.
Were you aware that Ken Paxton had asked Ryan Bangert to change the state policy?
No.
Were you aware that General Paxton had asked Ryan Vassar to release details of that very ongoing investigation?
Objection, that's a misstatement of the record, and it's assuming facts not in evidence through this witness.
Overruled.
You may answer.
No.
Did you later become aware of those things?
I did.
We'll get to that. Let's talk just for a moment about the records of a search. What is the general practice in, at least in federal courts, for the sealing, that is, making private the affidavit, the application for a search warrant?
They are sealed to protect people who are involved, may have given information about the crime that's being committed, and also for the purposes of protecting the investigation so it can be ongoing and find the truth.
Are you familiar with orders of federal courts to seal documents such as these?
Yes.
In this second meeting, what was Nate Paul and his lawyer's demeanor toward you and Mr. Penley?
I think that they were maybe not as gracious as they were during the first meeting. I think they understood by this point that.
Excuse me, Ranger. Object to what he thinks they understood. That's conjecture and speculation.
Sustained.
Well, what my answer is, my question is not what you thought they thought, but what was their demeanor. So what was their demeanor?
It was a little more animated than the first meeting.
Did anything happen at that meeting to change your initial assessment of whether this should be elevated to the level of an actual investigation?
No.
To clear that up, when you got this, did you start an investigation, as that term is understood?
Ask your question again.
Yes. Did you start an investigation? Did you initiate an official investigation?
No.
What do you do when you start an investigation?
When you start an investigation, you assign it to an investigator group. That is assigned an investigative number and is put into the record.
And the reason that even after this second meeting, it had not risen to the level of investigation, what's that reason?
The reason was that the allegations had no merit, and we weren't going to do the investigation if I had anything to say about it.
All right. Even though, and did you make that clear to not only now Mr. Paul and his lawyer, but also Mr. Penley?
Yes.
Even though that was your position, did you agree to submit their documents to your experts within the office?
Yes.
Okay. So was there a third meeting?
There was.
When was that third meeting?
It was on August 12th.
Was it clear to you by then what General Paxton wanted done?
Objection, conjecture, and speculation.
Was it, well, let me clear that up. Was it clear to you from what
Conjecture and speculation.
Actually, no, Your Honor, it's under 801E2D.
Counselor, you're going to make me look at these numbers, aren't you?
Yes, yes, Your Honor.
He's just trying to throw you off.
801E2E says that a statement such as this is not hearsay, particularly
with respect.
When it is, excuse me.
I'm sorry, you did go ahead.
Particularly when it was made by the party's agent or employee on a matter within the scope of that relationship. And here it's what General Paxton told to either Mateer or to Penley that was passed to the witness.
With respect,
that is not hearsay.
I'm sorry, Dick. With respect, Your Honor, there's a difference between what General Paxton said and what Ranger Maxwell can opine about General Paxton's state of mind. Those are two different things.
Not asking that.
You just did.
Sustained.
Well, let me ask it again then, if that's how it was understood. What message was passed to you by either Penley or Mateer that General Paxton had ordered done?
General Paxton wanted to have a third meeting.
I'm sorry. Objection. Objection, conjecture, and speculation. I have no problem with Ranger Maxwell testifying as to what General Paxton said, but there's a difference between what he said and what he wanted. I know it's splitting a hair, but objection, non-responsive.
Sustained.
What did he say he wanted?
He wanted us to tell Nate Paul that we were not going to be doing an investigation due to the results of our forensic analysis.
So going into that third meeting, is that what you believed it was going to be about?
Yes.
Was that meeting recorded like the first two?
No.
Who was responsible for it not being recorded?
General Paxton specifically told us that he did not want that meeting recorded.
Okay, so as you're going into a meeting in which you believe it's just for you to tell Nate Paul that you're not going to do his bidding, what happened?
The Nate Paul was there along with his lawyer, Michael Wynn. I had my two forensics experts, Mark Penley, myself, and General Paxton. My forensics people explained to Nate Paul the results of their forensic examination.
And very briefly, what was that result?
That the metadata that he was talking about that had changed could have been changed by the fact that there were documents he received had been electronically redacted and encrypted, which would change the metadata.
Is that a long way of saying there was nothing there?
Yes.
So, your understanding that General Paxton was telling you tell him not that you're not going to have an investigation. What was General Paxton's? What did he say during that meeting?
During the meeting, he was supporting Nate Paul's position, which was that we need to do an investigation. And he was pretty adamant about it.
Was that meeting heated?
It became heated.
Who became heated?
Nate Paul.
Before that meeting started, were you aware of any public statements that Mr. Paul had made about whether there was an investigation?
Yes, I was.
And what were those public statements you're aware of?
He had done an interview with a business journal and told them that the Texas Attorney General was investigating the FBI and their handling of the search warrants again on his property.
Was that true or not?
That is false.
In fact, you had not started an investigation, correct?
We had not, and I specifically told Mr. Paul that we were not doing an investigation at this point, and our meetings were confidential.
And the response?
Oh yeah, he responded.
What was his response?
He was very angry, and he said that he still has a First Amendment right. And I told him that all you're doing is using the power and the prestige of this office for your own purpose, and I'm not going to allow that.
Whose side in that dispute between you and Nate Paul did General Paxton take?
Nate Paul.
So, what was the significance of Nate Paul making a public statement that the Attorney General's office was investigating a federal magistrate and the federal authorities and the state authorities that the Attorney General was investigating? What's the significance of that kind of public statement?
Excuse me. Objection, conjecture, and speculation.
Sustained.
All right. Why did you think, what was your state of mind about why such a public statement when it was not true about the Attorney General investigating these law enforcement people? What was your state of mind about why that was improper?
It was improper because Nate Paul was a criminal, and General Paxton was using the office to try to his benefit.
Can the very start of an investigation into a public figure be damaging to that public figure?
Yes, it can.
I'm sorry.
Is that?
Excuse me, Dick. Pardon me, Ranger. Objection, conjecture, and speculation.
Overruled.
You may answer.
Repeat the question.
Yes. Can the very public start of an investigation against a public figure be damaging, almost like a tattoo to that public figure?
I got to object to leading in the tattoo. I'm sorry. Objection, leading.
Well, I'll reverse it. I'll take
Sustained.
the tattoo out of
Take the
it.
tattoo
Sustained.
out.
If I take the tattoo out of it, may I ask the question again?
I just sustained that. You can try whatever you'd like to and see what he objects
Okay.
to or not.
Is there a danger to a public official's reputation by publicizing an investigation by the Attorney General, and especially when it's not true?
Yes, very much so.
Is that the reason you're very careful about having a criteria for starting an investigation?
Objection, leading.
Sustained.
What is the reason you're careful about that?
We're careful because we don't want to put a stain on anyone's reputation. It has to be an investigation that is viable, has probable cause, and could move forward. This was not that.
All right. So let's talk about what happened after that meeting. Did you ever have any further conversations with Attorney General Paxton?
No, Attorney General Paxton stopped talking to me.
And your assessment at that time of whether General Paxton was angry with you?
Excuse me. Conjecture and speculation.
It's his state of mind.
Sustained. You can ask it differently if you'd like.
All right. Your state of mind after General Paxton and you left that meeting was what? About General Paxton?
Unless he said anything, conjecture and speculation. He's got nothing to base it on.
Overruled.
You may answer.
I know his state of mind because in the meeting he threatened to fire me. So I knew then what his commitment was to Nate Paul, and he was not going to be deterred from continuing to try and do things that benefit Nate Paul.
During this period of time with these 3 meetings, had you called upon any of your subordinates, any of your other investigators to, other than to look at this metadata, had you called on anyone to assist you in this review?
No.
Why not?
I told my people that this was going to get me fired. I was going to take the stand, and I was not going to jeopardize any of their careers by involving them.
Why did you think it was going to get you fired?
Excuse me.
He demonstrated his commitment to Nate Paul.
Witness, hold on a moment. Your
State of mind.
objection?
Objection, conjecture, and speculation.
Overruled.
For his state of mind. Yes, you may answer.
He had already told me that if I conducted my business as the FBI does, that he was going to fire me. So I know that he was angry with me because I was not buying in to the big conspiracy theory that Nate Paul was having him believe.
And at this time, did you know that there was some action within the Attorney General's office to hire an outside counsel to do what you refused to do, and that is conduct an investigation into the federal authorities that were hounding Nate Paul?
I'm sorry.
Take out hounding, that were conducting their investigation on Nate Paul?
Objection vague. When is this time? I'm not sure where
Okay,
we are.
I'll clarify.
Sustain, clarify, please.
At this time, we're now talking about the end after the third meeting. Did you know that there was some movement for General Paxton to demand the hiring of a special counsel or an outside counsel? Did you know about it at that time?
No.
As far as you were concerned, was the Attorney General's office involvement in Nate Paul's complaints about how he'd been treated or mistreated, in his words, by the investigation into his activities? Was the Attorney General's office involvement over?
No, I didn't think it was, because I knew that he was probably going to fire me and hire somebody who would do it.
Excuse me. Objection, non-responsive, and conjecture and speculation. With all due respect to Ranger Maxwell, he's not the amazing Kreskin. He can't see everything in the future.
I'm asking for his state of mind.
Overruled.
You may answer.
Yes, I did not believe that General Paxton was going to stop pursuing this investigation.
Did you at that time, though, know about the hiring or attempted hiring of Brandon Kamak, the young lawyer from Houston?
No.
Did you find out about it later?
I did.
I want to jump ahead now to the very end of September and the beginning of October. Did you go on a vacation toward the end of September?
Yes.
And where'd you go?
We went to Colorado.
Did you learn, don't tell us what was said yet, but did you learn that there was a crisis of sorts among the deputies, your fellow deputies in the Attorney General's office?
I did.
How did you learn it?
They contacted me.
And did you, even being in Colorado, they have phones up there last time I checked. Were you able to communicate with your fellow deputies?
I had to drive down the mountain to do it, but yes, I did communicate with them by phone.
What did you learn?
I learned that all the executive deputies, including Jeff Mateer, were going to stand shoulder to shoulder with me and confront General Paxton with what he has been doing to the agency for the benefit of Nate Paul.
What about
Thank you guys for
a
being
plan
here.
to go to the Federal Bureau of Investigation to report what they believed were, and what you believed, I believe, were crimes being committed?
Objection, leading.
What did you learn?
And again, what time frame are we talking about? Your question was late September.
Time frame is the end of September.
Sustain, re-ask.
Time frame is the end of September. In your conversations with your fellow deputies, what did you learn the plans were?
I learned that they were going to report the activities to the FBI. I learned that they had written a letter to General Paxton. I was not present, so I could not sign it. And I told them that I would also contact Lieutenant Colonel Randy Prince with the Texas Department of Public Safety and also tell him what was going on and that we were going to request an investigation.
So you knew Lieutenant Colonel Prince as a fellow Ranger, didn't you?
Yes, I broke him in.
And so by reporting to the Department of Public Safety, Lieutenant Colonel Prince, where was he in the hierarchy of the Department of Public Safety?
He is number 2, or he was number 2 in the department. He's now retired.
And at the time that you did that, were you making a report to law enforcement about General Paxton?
Yes.
What did you think would happen to you as a result of you reporting General Paxton to authorities?
Conjecture and speculation, Judge.
State of mind.
Judge, everything that doesn't come get to come into evidence as state of mind?
Overruled.
You may answer.
I was going to be fired.
What happened on, I believe it was October 2nd, 2 days after the report? What happened on that date regarding you?
I received notification by text message from Greg Simpson, the division chief over human resources, notifying me that I was placed on investigative leave.
As a result of being placed on investigative leave, what did that do to your responsibilities in the Attorney General's office?
At that time, I had no responsibilities, had no access.
And how long did that situation last?
For 1 month.
What happened then?
On November 2nd, 2020, I met with Brent Webster, and he terminated me.
Stop you. Who was Brent Webster by that time?
Brent Webster was the new first assistant hired by General Paxton.
Would you describe for the Senate and the senators what happened when Brent Webster fired you on, was it, did you say November the 2nd?
Yes.
Go ahead.
I was told to show up at 9 a.m. In the conference room next to Human Resources, and that I would be meeting with Brent Webster.
Were you still a law enforcement officer?
Yes.
Were you told anything about whether to bring a weapon or not?
My division chief over Criminal Investigation Division called me on the telephone when I was en route to the office, and he told me that Brent Webster said that I would not allowed to be in the building if I was armed.
So what happened after you went to this or showed up at the time you were supposed to show up?
I got there at before 9. I'm pretty much always early. And I waited till about 11:30 before Brent Webster showed up.
What happened then?
Brent Webster and Aaron Wrights came together, and they first asked me if I was recording this meeting, and I said no.
And you were not?
I was not.
Did you ask them?
I asked them if they were recording the meeting, and they said they were not.
And then what happened?
Then Brent Webster told me that he was conducting an investigation.
Did you believe that?
No.
In fact, did his actions confirm your non-belief?
Yes.
What happened then?
So he attempted to interview me in a very vague and inept way. And I told him, just ask the question, I'll answer it, or I won't answer it. Just give me a direct question and I'll give you what you want to know. We never got to the point where he asked me any really direct questions.
All right. How did it end?
He left, and he told me to be back at 1 o'clock. And so I went to have some lunch, and I came back to the office at 1 o'clock.
Did he show up?
No.
What happened?
About 4:30, members of Human Resources showed up with my paperwork, and I signed the paperwork, and I was fired.
I want to talk just a moment about what I'll call retaliation. Were you retaliated against for what your actions that you took in this case?
Yes.
Tell the members of the Senate briefly how you were retaliated against.
That he retaliated against me, is what
Yes.
you're asking. Well, in firing me, at the time I was 71 years old, and had risen to a top level of law enforcement. In effect, when he fired me and then berated me in the news, he ended my career.
By that time, your career had taken up how many years?
It was 48 years.
Were you proud of your career?
Absolutely.
What is an F5 form? That's an F as in Frank 5, the number.
It's a TCOL form.
TCOL means what?
Texas Commission on Law Enforcement.
What's the importance of TCOL?
TCOL is the regulatory agency for all peace officers in the state of Texas.
And so what happened at first with regard to your TCOL license and the F5 form?
The F5 form is a form that is required for the agency to fill out anytime they separate from a law enforcement officer. There are three things that you can mark on the F5. It can be an honorable discharge, it can be dishonorable, or it can be a general discharge.
Is a general discharge good or bad?
Bad.
Did you contest that?
I did.
Did you join in the filing of a whistleblower lawsuit? We call it that. Why did you sue?
I sued because he ended my career in a very unjust manner.
Eventually, partly as a result of the lawsuit, was the general discharge reversed and you got an honorable discharge.
Yes.
Is that important?
Yes.
Why?
Because it's important to me to show that I had an honorable discharge and that I did nothing wrong by standing up for right.
Pass the witness.
Mr. Cogdell?
Thank you.
Take as much time as you need.
Thank you. You good, Dick?
Yeah.
Good afternoon, Ranger.
Good afternoon, Counselor.
How are you?
I'm good.
Good.
Mr. Cogdell, I'm sorry, since you're a little taller, you're going to need to get closer to that microphone so we can
Wait, I'm taller
raise
than
that
Dick?
up. There you
Good.
go.
All right. It's been a minute, has it not?
I confess.
Sir?
I confess he is taller. And in fact, well.
It's been a minute since you and I have seen each other.
It has.
Let me go into sort of your preparation for this hearing. And Ranger, I know you as Ranger Dave Maxwell, so I'm going to call you that whether you want it or not, because it's just in my brain.
I'm good with that.
That good. What have you done in preparation for testifying here today, Ranger Maxwell?
I've consulted with the attorneys. I've reviewed the material that has been turned over that I would be speaking about.
And is your lawyer here?
Yes.
Tell me his name.
TJ Turner.
And he's in the room.
He is.
Now, when you say that you have consulted the material, let me make sure I'm on the same page with you.
Okay.
I'm aware, Ranger Maxwell, that there are transcripts of your original meeting with the Board of Managers back in February. You've read that transcript, I assume?
Yes.
There is the July 21st, 2020 interview by you of Mr. Wynn and Mr. Paul, right?
Yes.
I assume you've read that transcript?
I
There is the August 5th, 2020 interview by you and Mark Penley of Mr. Wynn and Mr. Paul, correct?
Yes.
There are also videotapes. I think the first one is about an hour, the July one, and the second one is an hour and a half or so.
Hour and 17 minutes, an hour and 54 minutes.
Your memory is not lacking. I'll give you that, at least so far. But have you seen the videos as well, Ranger?
No.
Okay. Well, I may ask you some specific questions about those meetings. So let me give you copies of the transcript, Ranger, just so if I get down in the weeds and you need them, you'll have them. Okay.
Yeah, it's good.
May I approach, Your Honor?
Yes, you may.
Ranger, the board managers,
Okay.
the July and the August.
Okay. Good.
He was not on mic, but he was simply pointing out to the witness what the different folders were.
Let's go back to, I guess, your first involvement, Ranger, with this particular investigation in terms of your testifying, okay?
Okay.
And by what I mean by that is when you were interviewed back in February, I think, by Therese Buse and Dan McAnulty.
Yes.
You remember that interview?
I do.
You've read it.
I have.
And in reviewing that transcript, Ranger, in your review, did you see anything that was an error or a mistake?
I see some things that may be misconstrued.
What are those things?
About Drew Wicker and what he may or may not be able to testify.
Gotcha. Now let me put you on pause there. You weren't here, obviously, during the opening statements, so you don't know what was said or what wasn't said about Drew Wicker and your statements about Drew Wicker. You weren't here, right?
No, that's correct.
Have you met with Mr. DeGuerin or anybody from the board of managers team in anticipation of your testifying?
Yes.
Who did you meet with?
I met with Mr. DeGuerin, Rusty Harden, met with the other attorneys that are helping prosecute this case.
Okay. And was that topic brought up in the meeting? That is what you said in the February meeting about Drew Wicker?
Yes, they did ask me about that.
Okay. Now, you know Mr. DeGuerin personally?
Yes.
And to jump way back in time, which was one of the first times I met you, Mr. DeGuerin famously walked into the Branch Davidian compound during the siege in 1993.
93.
Were you escorting him in and out? Was that you?
No, I did not.
But the Rangers did have a significant role in the investigation of that incident, that tragedy, whatever we want to call it, right?
Yes, I was one of the lead investigators.
Yes, sir. And if my memory serves me, Ranger, correct me if I'm wrong, but I think you helped a much younger me get access to my client in that ordeal. Did you not?
I did.
Thank you, sir. Now, I mean this sincerely and respectfully, Ranger. You're an icon with the Texas Rangers, right?
I don't see myself that way.
Well, a lot of folks do. You'd agree with me?
I've heard a lot of people say that, yes.
You are in the Texas Ranger Hall of Fame, right?
Well, at some point.
What do you mean at some point? You are now.
I am not an official member of the ones they recognize as being in the Hall of Fame. My picture has been there. There was once an exhibit on me in the Hall of Fame.
Well, let's see. You joined the DPS in 1972.
That's correct.
You became a Ranger in 1986.
Yes.
You left the DPS, and I'm sure 95% of the people in the room know this, but some folks watching on TV may not. All of the Texas Rangers, the genesis of being a Ranger, you hail from the Department of Public Safety. That's the outfit through which you become a Texas Ranger, right?
Yes, because the Rangers are a part of the Texas Department of Public Safety.
Yes, sir. So all told, with the DPS and the Rangers, your career lasted 38 years?
38 years.
Now, You made some statements to Mr. DeGuerin about how ludicrous it was to be investigating judges or assistant United States attorneys in this particular case, right?
Yes, in this particular case.
Yes, sir.
That's correct.
But certainly you would agree with me, Ranger, that in your experience, you have been part of investigations, even prosecutions of assistant United States attorneys or judges, right?
I have investigated and prosecuted public officials. I've never investigated a senior federal magistrate or an AUSA.
Well, let's go back to the Waco incident. One of the fallouts, tragically, for one of the assistant United States attorneys in that case, a fellow who I actually respect a lot, so I'm not going to mention his name, but I think you know who I'm talking about.
I do.
He was charged with a federal offense after that ordeal, was he not?
He was.
Now, you mentioned OIG, which is the Office of Inspector General, right?
Yes.
And they are kind of like, I don't know what you'd call them, OPR or what is it in local law enforcement when you have a complaint against a law enforcement officer? Help me with the verbiage.
I don't think we on the state level have an equal to the Office of Inspector General because they cover all of the federal agencies as far as being able to inspect them. We don't have that in Texas. We don't have oversight of other agencies.
Okay, fair enough. But would you agree with me that in your experience as a Texas Ranger, you've seen, wrongful prosecutions of DPS agents?
Yes.
One of those was a fellow by the name of Sergeant Bob Nestoroff. Remember that?
I do remember Bob, yes.
He was I think, head of DPS narcotics enforcement.
He and I were in the narcotics at the same time.
And he was charged by an AUSA in Florida, if I remember, for perjury and obstruction.
He was.
Came here and went to trial in Houston in front of Lee Rosenthal, right?
Yes.
You remember his lawyer, right?
I don't remember who his lawyer was, no.
Objection for a moment, Your Honor. Relevance.
Well, my point is this. No one.
Relevance.
Overrule. Let him continue.
Well, let's just say his lawyer looked like a 27-year younger version of me, but that's not really the point. The point is even AUSAs can make mistakes, right?
You're talking about one individual.
Yes, sir. Yeah. One individual that charged a compatriot of yours for something he didn't do.
Yes.
Okay. My point is, it is not beyond the realm of possibility for anyone, including an assistant United States attorney, to make an error in judgment or whatever that ends up being criminal. Agree with me? It's rare, but it happens.
It's rare, but it happens.
Now, let's talk about the resources through your 38-year career, Ranger, that you've been exposed to. You would agree with me as a general rule that you have seen the tools and the resources available to law enforcement grow exponentially in your time.
Absolutely.
There are kinds of investigative tools that weren't around when you started with the DPS or when I started practicing law that are around today. You agree with me?
There's no comparison.
Yes, sir. Things like Crime Star.
Yes.
Things like Clear for law enforcement, it's public records database, right?
Yes.
Accurate for law enforcement, again, another public records database, right?
Yes.
TLO by TransUnion, another law enforcement public records database, right?
Yes.
Cellbrite, a cell phone analytics tool, right?
Say that again.
Cellebrite, it's a cell phone analytics tool.
Mm-hmm.
Gray Key, another cell phone analytics tool.
Yes.
PenLink, another phone analysis tool.
Yes.
Obviously, TCIC, NCIC searches, right?
Yes.
Criminal history checks, driver's license checks, right?
Yes.
Access to some utility companies' databases, right?
Yes.
open source data like YouTube, Facebook, Twitter, X, all those sorts of things.
Yes.
And 95% of that just wasn't around when you started your career, right?
Absolutely.
So you would agree with me, I think, Ranger, that if you don't know how to use those tools, you could certainly find somebody that could help you use some of those tools if you wanted to use them. Agree with me?
Agreed.
Now, the DPS and the Rangers have all kinds of teams at their disposal, right?
Yes.
They have a reconnaissance team, agreed?
Yes.
A special response team, agreed?
Yes.
A public corruption unit team, agreed?
Yes.
It is not unusual at all for DPS or the Rangers to participate in internal investigations, right?
That's correct.
DPS from time to time, I am told, triple hearsay, uses hypnosis.
We used to. I think it's been phased out now.
Did you yourself?
No, I didn't want.
You never did?
I didn't want to do that.
Your legend has been diminished by just a bit. I thought you used hypnosis. All right.
No, sir.
Now, you yourself, Ranger, you have taught all kinds of courses, right?
Yes.
You personally taught on how to conduct investigations.
Yes.
Agree? You have taught on interrogation techniques.
Yes.
Agree? You have taught on how to testify in court.
How to what?
Really? You just did that? Come on. You have taught on how to testify in court.
Yes.
And no disrespect to anyone, this is not your first rodeo. You have testified a few times, right?
That's correct.
Can you estimate for us, Ranger, how many times you have testified in courts across this state or across this country?
Hundreds.
Okay. Now, simply put, Ranger David Maxwell knows how to conduct an investigation if he wants to, right?
Yes, that's correct.
And you have literally conducted probably thousands of investigations?
Yes, thousands of investigations.
I guess, Ranger, anything from traffic tickets to capital murders and everything in between you've investigated, right?
Yes.
Now, let's talk for a minute about the good traits of an investigator. See if we can agree on a few good basics. One, they should have the training and the mental tenacity to be a good investigator, right?
I say that again.
They got to be smart enough to know what they're doing.
Yes.
They should have an open and objective mind.
Yes.
They should go into an investigation without bias or predisposition.
Yes.
They should be willing to follow the evidence.
That's correct.
And they shouldn't make assumptions that aren't based on sufficient evidence, right?
Yes.
Now, it is also important, is it not, to follow up on any leads or information given to them by others?
I lost some of that. Say it again.
And I couldn't help but notice you've got a hearing aid.
I do, and so it's a little hard for me.
Yes, sir. And if I don't speak up enough, please let me know.
Thank you.
It's important for a good investigator to follow up on any leads or information that's been given to them, right?
Yes.
Would you agree with me, Ranger, that a good investigator understands that, you know, we're kind of all equal under the eyes of the law in terms of everybody's entitled to have an investigation, if at least if it's warranted by the facts, investigated, right?
Yes.
An inmate or a president or anything in between. Agree with me? An investigation should be thorough.
Yes.
And accurate records and reports should be generated and maintained.
Yes.
And that's important not only for the investigator that's involved in the case, but really for the future of the case, right?
Yes.
I mean, investigators leave, they get fired, they quit, but the case may still be going on, right?
That's correct.
So once again, You have the experience, the training, the assets, the knowledge, and the relationships and the contacts to do a great investigation if you were inclined to do that, right?
Yes, I do.
All right. Let me ask you, and I think Mr. DeGuerin touched on it briefly, but let me do it as well. I think he mentioned a search warrant and a probable cause affidavit, right?
Yes, he did.
Where is just a minute, Your Honor. Affidavit itself. Right. Well, while he's looking for what he should have had, Eric, while he's looking for that, let me cover a couple of things with you, Ranger. First off, the quantum of proof that a search warrant must satisfy before a judge or a magistrate signs off on it is probable cause, right?
Yes.
And the lower standard of proof is scintilla, and then we go into probable cause, then we go into clear and convincing, and then we go proof beyond a reasonable doubt. You're aware of all those things,
Yes.
right? Now, thank you. I'm going to show you, Ranger, I don't know that if you have seen this or not, but I'm going to show you, without offering it for obvious reasons, the underlying affidavit in support of the search warrant for Mr. Paul's properties and the search warrant itself, okay?
Okay.
May I approach, Your Honor?
Yes, you may.
Good for right now. Sure. I'll need some later though.
Yes, let me know.
All right.
So what you have in one hand is a search warrant, which is pretty thick, right, Ranger?
Yes.
You should have it, and if you'll pull forward, Ranger, because we got to have your voice. Pull forward.
sorry.
That's all right.
All right.
You should have two different things. One is a part of the other, but one is the greater search warrant, which is several inches thick, right? The entire search warrant.
Yes.
And then included in that, which we've excerpted out, is the search warrant affidavit or the affidavit in support of the search warrant, right?
Okay.
Now, you have prepared estimate for us, Ranger, how many search warrant affidavits?
I couldn't tell you. I mean, it's a lot.
A lot, like thousands.
Yeah, it's a lot.
Now, you would agree with me that the content that goes into a search warrant affidavit is meant to do really one thing and one thing only. And that content that is to go into a search warrant affidavit is to convince a magistrate judge that there is probable cause for the issuance of a search warrant to search a given premises or a given location at a given time, right?
Yes.
And what's important is not the personalities of the judge or anything to do with the prosecutor or anything to do with anything other than what information would establish probable cause, right?
That's correct.
Now,
Excuse me, objection. And I object to any further reference to this affidavit as it was not part of his review and he's not seen it before.
I'm happy for the Ranger to take a few minutes to look at it, but these are, Dick, I think they're going to be pretty global questions. But if the Ranger needs time to look at it, I'm happy to stand down for a few minutes.
And we also object to relevance.
The relevance is what Mr. Hardin has suggested time and time again about how the search warrant affidavit could endanger the lives of judges and prosecutors and all this. I'm going there. I'll show you the relevance.
I'll overrule the objection, but Ranger, do you need some time? Would you like 5 or 10 minutes to look at it? It's a good time to break. Members, be back at 2:45.
Thanks, sir. Good to see you.
Okay, guys, thank you for being here. I'm just now finishing up with my work, so thank you guys for being patient. Let me go and see what's going on in the chat, and give me a 5x5 if you can still hear me, okay? All right, they'll be back in just a few minutes, I'm sure. Thank you guys so much. All right, so let me say hello to everybody on this chat. Hello, Mean Gene, Rob Maga. He's 71. Y'all don't be ageist. Jesus is calling. Please. Yeah, I believe though. I believe that Jesus is calling. He's not calling him home. He may be old, but he's not calling him home yet, I don't think. So, thank you guys. Satan infiltrated government, media, my church. Yes. I agree with you about that. I wish it wasn't true. Right, I wish we were wrong about that. But they'll be back in just a little bit. So let me, you know what I haven't checked? I haven't checked the Foxhole chat in a moment. Let me pull that up. How much? I do have $3. Hang on one moment. Okay, let me pull this up. Here I am. All right. Okay, guys. Victoria, a boneless chicken. Grain of salt, sub pack bet. Thank all of you guys for being here. Stacks, of course. Crisco. Thank you guys. Oh, and Diddy, what's up, Diddy? I saw you commenting earlier, right whenever I was getting into work. Hello, Patriot Drummer. Victoria says, strange Matlock reference. Was I must have missed that. I wonder if did I miss some good stuff while I was working? Y'all let me know. How many of these witnesses did Paxton's team just bulldoze through? Yeah, 83, 90, 81. Trump's looking good though. Y'all saw Trump? Yeah, you can. Y'all saw Trump's mugshot. Looks very, very impressive. Very handsome. Strapping young lad. And give me a 5x5 if y'all can still hear me. I'm on a different device right now, so it might be a little bit louder or more quiet. So if I'm shouting, I'm sorry. It's not personal. Thank you. I'm just about to start eating my lunch from my work. Y'all let me know if I missed anything good. Did Paxton's attorneys kick some more ass while I was at work? I'm excited to review everything. Thank all of you guys for being here. If you can like and comment and share this out, it would really help us out. And check out our website at takingbacktexas.org. You can read over 30 investigative reports I've written myself. My name is Aubrey. I'm also known as Seven. My business partner and I started Taking Back Texas to investigate what was going on in Tarrant County, Texas elections. And we've got a lot of stuff documented on our website. Trained a lot of poll watchers in multiple counties all across Texas. We will be posting on our homepage an announcement for our next poll watchers training. So keep an eye out for that. And if you're in the DFW Metroplex or if you're in Texas, it'd be great if you could attend our next training. We've actually got a few events that we're about to announce. But the training is kind of what we do. That's kind of what we're known for. And you know what? I'm about to start soliciting reviews for the training because we've actually trained quite a lot of people. So I'm going to start asking for reviews on our training and updates. What have you done after you got trained? Did you have, and if any one of you is watching and you've attended our training courses, feel free to leave a comment in the chat about how valuable you thought the information was. Did we do a decent job? relaying the info, all of that stuff. And anything you guys say, you can also send it in an email if you don't want to say it publicly, you don't want to give away who you are. You can send it in an email and we'll quote you, or you can stay anonymous if you like. But we'd love to have testimonials about our training program. So thank all of you guys for being here. And thank you for caring about Texas and for caring about our Attorney General, who is the only one that's actually been taking any of this stuff seriously. He's the baddest Attorney General in the entire nation, and that's why they're giving him this treatment. But we've watched them debunk article after article. So I don't know about you guys, but after watching Paxton's team work, I feel a lot better about the future. Let me know what y'all think.
Sort of gave you a hint at the break of where I'm going on this document, so let's go there. Back up just a second. We're talking about the search warrant affidavit in the Nate Paul case, but really the questions kind of apply affidavits, generally speaking, not just here, okay?
Right.
Would you agree with me, Mr. Ranger, that in your training in terms of law enforcement, that you are trained that if charges are filed, that ultimately the defendant who is charged will get a copy of the search warrant affidavit?
That's correct.
And the basis for that, to bore us all a little bit, is whether the search warrant affidavit is sufficient or not is often argued by defense lawyers as a basis for trying to suppress the search, an illegal search. That's the typical argument, right?
Yes, correct.
So anybody that fills out a search warrant with any experience is going to know at some point this could well end up in the hands of the defendant or his lawyer. Agree with me?
Yes.
So as a habit, custom, and practice, Ranger, it's true, is it not, that you would not put anything in a search warrant affidavit or really allow anything to be put in a search warrant affidavit that could come back to haunt somebody from a personal safety perspective, right?
That would not be my first choice, but sometimes judges don't give you a choice.
Well, certainly there have to be names, right?
They'd have to be named, yeah.
But they don't have home addresses of the cooperator or where their kids go to school, or that just doesn't happen. Agree with me?
That's correct.
All right, now, this particular search warrant, I'm assuming you've never seen this particular search warrant or the affidavit in support of the search warrant before. This is the first time I think you've seen this.
It is.
And did Nate Paul ever indicate to you in any of your meetings with him that he had a copy of the affidavit of the search warrant?
He told me very directly and positively that he knew who signed the affidavit for the search warrant.
That he what?
He knew who was the officer who signed the search warrant on the probable cause affidavit.
He knew who signed it?
He knew who signed it, yes.
Yeah, okay, all right.
Who the affiant was.
Sir?
Who the affiant was.
And who the affiant was is often discoverable on the search warrant itself, right? Not the affidavit, but sometimes it's on the affidavit and the warrant. Agree with me?
Maybe, but he referred to the probable cause affidavit.
Okay. The affiant is the person who signs off on.
That's correct. Yeah.
So what he told you, if I'm understanding you right, Ranger, is that he knew who the affiant was, right?
That's correct.
He did not say, I have a copy of the search warrant affidavit. Rather, he said, I know who the affiant is.
Right? Yes, he did.
Okay. Now, let's get to the matter at hand a little more directly. You received the referral from the Travis County DA's office on, I think, June 10th of 2020. I think Mr. DeGuerin showed you that in your direct.
Well, it was created on June 10th. It went through regular mail, so I didn't get it on June 10th.
Okay. You got it within a few days.
So I got it through the mail.
Okay. But you had gotten an email from Don Clemmer telling you that the referral is on its way, right?
Yes.
And I think that is the point in time where you did what a Ranger Dave Maxwell would do. You Googled around and figured out, at least in your worldview, this guy is up to no good. I don't want anything to do with him, right?
Yes.
And you really began the investigation believing that Nate Paul was a criminal, right?
Not just because of what you said. I felt he was a criminal because of all that I saw.
Fair enough. But my point is, when you began your review, I'm not going to say investigation because it never got that far, okay? So I don't want to step on your verbiage.
Right.
But when you began your review, you began it with the conclusion that this guy is a, quote, criminal and you want nothing to do with it, right?
When I began the review, my thought process was I wanted to see what it was that he had to say.
We'll get there.
And that was what I told my boss, Jeff Mateer, that I would take a look at it. And when I read it, the allegations of conspiracy among so many professionals.
Let me slow you down just a little bit, Ranger, because we're going to get there. But will you agree with me, at least right here, that you didn't exactly go into those meetings with a positive mindset about Mr. Paul, right?
No.
Okay. Now, if I'm understanding it right, the Travis County DA's office decides it's not the appropriate agency to review or investigate this complaint because the Travis County DA's office deals regularly with DPS and with the Rangers, right?
That's not exactly true.
That's part of it.
That's what was in that email, but that's not exactly the case.
Okay. But that's at least what's in the email. You'll give me that part.
That's correct.
Now, does it strike you as ironic at all, Ranger, that they say, we're not going to investigate this because we're too close to the Rangers or to the DPS, and yet they refer it to a Ranger that's in the Hall of Fame that had a 40 plus or minus year career with the DPS? That doesn't strike you as ironic?
I can explain that answer if you like.
Well, first answer my question and I'll let you explain it. I'll give you that much, Ranger.
No, it doesn't strike me as ironic.
Okay, doesn't sound like Mickey Mantle investigating the Yankees?
Say it again, please.
It doesn't sound like Mickey Mantle investigating the Yankees?
I'm sorry, I still couldn't understand you.
I'm sorry. And I don't know if it's the microphones or what.
All right, really good.
I'm trying to be cute, but I'm really trying to make a point.
Okay.
It's kind of like Mickey Mantle investigating the Yankees.
Okay.
Doesn't exactly jump off the page as an objective review. That's my point.
I would say you talked about my professionalism. I always look at things objectively.
And let me stop you, Ranger. At no time, sir, I may disagree with what you did or didn't do, but at no time am I going to suggest to you that I think you're a liar or you're unprofessional or you're not a man of great character. That ain't where I'm going.
Okay.
We good?
I'm good.
All right. So it was Clemmer that you had the conversation with, Don Clemmer, Ranger?
I did.
And I think you knew him from back in the day at the Harris County DA's office?
Actually, I knew him when he worked for the AG's office because he was the executive deputy
I love the
over
Texas style
prosecution
debate. Very
when I
polite,
was there
but direct.
in the law enforcement division.
Gotcha.
So we were colleagues at that point.
You were also friendly with him, I guess?
Yes.
So there's nothing in your personal history that would be a source of conflict or tension between you two?
No.
So when you called, when was this first call? Was the call between the time you got the email and you got the referral?
No, I called him after I got the referral in the mail.
Okay. And did you express to Don at any time, Ranger, Mr. Clemmer, that is, did you Ranger Maxwell, expressed to Don Clemmer, you know, I'm probably not the right guy to investigate this. I don't like Nate Paul. I don't trust him. I think he's a criminal. I think the world of the Rangers. Did anything like that come up in that conversation?
No, my language was much stronger than that.
Okay, but you communicated those thoughts.
I communicated my thoughts in unequivocal terms.
And 4-letter words were involved, I'm imagining, Ranger?
I probably won't use the same language in the court that I'd used at that day.
I wouldn't ask you to, certainly. There may be some court somewhere, but this is not the one I'll ask you to use the language in.
It's
All
kind
right,
of adorable. They're a little
it
back
is
and forth.
true, is it not, Ranger Maxwell, that typically as the, are you deputy director? Are you director of law enforcement? Give me your title again at the
Director of Law Enforcement.
Okay. Typically as the director of law enforcement, Ranger Maxwell, you didn't often get personally involved in investigations, right?
Yes, I oversee them, and sometimes I actually personally get involved.
But that's my point. The majority of the time you oversee.
Yes, absolutely.
Okay. And you certainly would you typically, Ranger, assign something like this if a player like Nate Paul wasn't involved? Would you typically assign a referral like this to someone lower than you on the food chain?
I would assign it to my major who was over special investigations and have him sign a team to investigate the allegations.
And I think you told us the reason why you didn't assign it anyplace else, but regardless, you kept this one for yourself, right?
I did.
All right. Now, you got the referral in mid-June, right?
Yes.
And you had the first meeting with Nate Paul and Mr. Wynn, Michael Wynn, July 21st.
That's
right?
correct.
Now, let's set the stage in terms of, forget about how your thoughts about Nate Paul, forget about your thoughts about Paxton's involvement with him, and focus, if you can, on just the otherwise oddity of having a conversation with a fella who is under investigation for federal offenses, right?
Yes.
And he comes in to you, a known quantity, shall we say, in the law enforcement community, and he and his lawyer are sitting down with you, opening themselves up to asking them any question you want to, right?
That's correct.
I'm going to go out on a limb here, Ranger, and suggest that despite your storied career, something like this may not have ever happened. Would you agree with me?
Possibly.
Okay. Now, and when I say something like this never happened, let's just say I don't know many defense lawyers that would have taken the same position as Michael Wynn and walked their client into that meeting. Agree with me?
Okay.
Now, before that meeting started, did Ken Paxton ever come up to you, did General Paxton, Ranger, ever come up to you and say, hey, I want you to give him immunity. You can't use those statements against him. He gets a free pass for anything he says. I mean, there was no condition put on your being able to ask Nate Paul questions. Agree with me?
That's correct.
And likewise from Mr. Wynn. He never likewise asked you, hey, everything is off the record here. You're not going to go anywhere. That didn't happen either.
No.
In fact, I think you told, was it Mateer, that, yeah, I'll have this meeting, and what I'm going to do is if they say anything that incriminates them, I'm going to mail it right over to the U.S. Attorney's Office, right?
Well, no, I was going to contact the FBI and give that information to them. I also told General Paxton the same thing.
Okay. So the point is, you went into it with the mindset that if Nate Paul, or I guess even his lawyer, said anything that was incriminating about any criminal activity, that you were going to pass that information on to the appropriate agency.
Yes.
Right? And it's true, is it not, Ranger, that never happened. That is, they never said anything that incriminated them or that you passed on to another agency, right?
Right.
I want to make sure, I don't know, frankly, Mr. President, I want to offer, if it's not in the House Board of Managers Exhibit 149, which is the video of the 721 interview, as well as the Board of Managers 151, which is the transcript of that same interview.
No objection.
Okay. And likewise, while I'm doing that, I want to offer into evidence 156 and 158, which are the video of the August 5th interview that Ranger Maxwell and Mr. Penley had of Mr. Paul and Mr. Wynn, as well as the transcript, which is 158.
Okay, let me.
No objection.
We're looking at those numbers.
I'm looking at.
Yes. Yes, Mr. DeGuerin?
Oh, no objection to the introduction of those, of the
All right.
video, audio, and transcript.
Thank you.
Make sure I have the numbers right. Hold on, Counselor.
Yes, sir.
We're going to enter 151, 149, 156, and 158 into evidence.
Yes, sir.
No objection. Show them being entered into evidence. Go ahead.
All right. Now, Ranger, do you still have the three little?
I do.
And I'm not going to try to give you a pop quiz and ask you if every single word that I'm saying, I hope you'll trust me far enough to say if I say it, it's in there. But if you want to check me, please check me and I'll point you to the citation. Okay. I think early on in your House interview, which is also in front of you, I think that's the orange folder, that you said his main allegation when you were, to back up, when you were being interviewed, I jumped from your interview of him to their interview of you, but in your interview with the Board of Managers, you said his main allegation of why he didn't like the raid that they conducted was he was alleging that the copy of the search warrant had been altered, right?
Right.
And that's true, right?
Right.
That's true in terms of that was what Nate Paul was claiming to you, right?
Right.
And that at some point in the first interview, I think Nate Paul told you, Ranger, that he didn't even think they had a search warrant for at least one of the properties being searched, which was the storage unit. You recall him telling you that?
Yes. Mm-hmm.
And he went way deep. That is, Nate Paul went way deep into metadata, right?
Yes, he did.
Do you know as little about metadata as I do?
Maybe less.
All right. Metadata, at least as far as you and I know, is sort of the fingerprints that any electronically created documents leave.
Yes.
Now, you said that, and I hear you, you said a couple of times to Mr. DeGuerin that his accusations were so ridiculous and so conspiratorial, I'm characterizing, that it was just absurd to you to even hear him, right?
Right.
Would you agree with me, Ranger, that Mr. Wynn, his lawyer, through both of those things, did say words to the effect, Ranger, that he doesn't think they're evil people, maybe they just relied upon poor information and they don't know how to back out? You remember that verbiage that Mr. Wynn?
No.
If you will look, Ranger, on page 63, line 22 of the 712 interview, and for the color-coded challenge, that is going to be in the green.
In the green, he's looking in the orange right now, the green or the...
Yeah, David, Ranger.
Ranger.
Look, the 712, which should be in the green folder.
Yeah, on the green folder.
Yes.
Yes, sir. I'm sorry, 721. If you'll look on page 63.
63, okay.
At the very bottom of 63, you recall Mr. Wynn telling you, I'll wait for you to get there, Ranger.
Okay.
At the bottom of 63, Ranger, Mr. Wynn says, that's the problem. I don't think they're evil people from the core. You see that?
Well, mine doesn't have all the words.
Yours doesn't have all the words?
It says, that's the problem. I don't think they're, and it's blank.
Well, the next line is, I don't think they're evil people from the Corps. You see that?
Right.
And make sure you keep that microphone close to you, Ranger.
Sorry.
No, sir, that's fine. And then the next page, it says at the top of page 64, Ranger, they listened to the wrong people and it got it wrong, and they just can't come forward and say, oops, right?
That's what he said.
Now, again, not suggesting that you should buy that description, but that is certainly what Mr. Wynn is telling you in this first meeting, right?
Yes, that's right.
Okay. Now, you told Ranger this jury in no uncertain terms that you never had any intention of ever investigating this. It was nonsense from the beginning, and you just wanted nothing to do with it. Again, I'm paraphrasing what you told us, right?
That's correct.
Ranger, it's true, though, that you never said that to Mr. Wynn and Mr. Paul.
That's correct.
Okay. Instead, what you told them, and this is probably the sly investigator coming out in you, I don't mean to diminish your skill set, but what you told them was, maybe I can get some answers for you, right?
Right.
And you said, I can look at this and talk to the DA's office and see where we get, right?
Right.
Told them, I'll look at the metadata just to see what our people tell me about it, because I pay a lot of money to those people to get them trained, meaning your metadata people.
That's correct.
Right?
Yes.
And I will sit down with the DA, and if we have something, we do. And if we don't, and they say no, that's as far as I can go, right?
Right.
So, and again, I think I get the reason why, but what you're telling us about your opinions about their story or their position is certainly different than what you were telling them, right?
Say that last part.
Yes, sir. What you're telling us, your opinion of their description of what may have happened, your opinion that you shared with us is a very different opinion than what you shared with them. That is Mr. Collins. Okay.
Absolutely.
Now, did you, though, early on, Ranger, tell them that it was up to the DA's office, ultimately, to accept charges or not?
Yes.
Okay. So when Mr. DeGuerin said, had the DA's office recused themselves, and that's a term of art we'll probably get to, but when he said, have they recused themselves, you said yes, but you certainly never told or suggested that to Mr. Paul or Mr. Wynn, that is, that the Travis County DA's office had recused itself, right?
I go back to the protocol I testified in the first place, which is I require.
Ranger, I can't hear you. And I don't mean to step on you, but I want to hear you.
I go back to my first statement when we talked about the protocols I have in place, that I require a letter from the DA in that jurisdiction that he'll either prosecute or recuse himself and let us prosecute.
Okay. And correct me if I'm wrong, but I don't think you ever got a letter from the DA in this case that they had recused themselves. Margaret Moore never wrote you a letter and said, we are recusing ourselves from this investigation.
There is no investigation at this point.
Okay.
There was not going to be an investigation, and there's nothing for them to review.
Okay. I hear you. But if they didn't recuse themselves from an investigation because there was no investigation, they didn't recuse themselves from anything.
No, not the investigation. They had to recuse, if they wanted to recuse themselves and have us prosecute.
Yes, sir.
They either have to agree to prosecute the case or recuse themselves and allow our people to prosecute.
And neither one of those things happened, if I'm understanding what you're saying right now.
Neither one were going to happen, no.
Gotcha. And that's my point.
Yeah.
That didn't happen. And maybe you know this and maybe you don't, but I'll go out on a limb and ask you, do you know sort of the conditioned precedent for a prosecutor pro tem? Do you know what that term means? And you may not, Ranger.
No, I'm not going to try and define that.
Sir?
I won't try and define that.
Fair enough. Now, what is the web pass system? The web pass system.
I'm not sure.
Well, as I understood it, and I could be wrong, law enforcement division maintains what is called a web pass system, which has an offense report or a case file in it.
I'm still not understanding what that is.
It's
Well,
like
let-
What's the purpose of it?
Let me just put it this way. You never created any memorandum, right?
No,
No memorandum of an interview, right?
no,
No report of an investigation or a review.
that's correct.
No note to the file, right?
Right.
You didn't initiate so much as a post-it note, if I'm understanding you right. I'm sorry if you can't hear me. I think you're the only one in the world that can't hear me right now, Ranger. But you didn't even create a post-it note about this case.
I did not take any notes or even create a post-it note about it. That's correct.
Now, Operation Longhorn. May I have just a minute?
Hey, what do y'all think about this ranger?
Mr. Guerin, I think I showed you this.
Yes, you may.
He seems
I've
like
seen what he's offering, Your Honor. And my objection is that it's not only, if it's offered for the truth of the matter, we think it's false and we don't want it, so we object to it. But I don't know what the offer is.
Well, I thought at the break that he had told me he wasn't going to object to it. Whatever, that's fine.
Go to your mic so we can all hear the conversation.
From my understanding with Mr. Guerin at the break, he told me he wasn't going to object to it. But that's all right. People can change their mind, Dick. I've been married a few times. It's okay.
Mr. Guerin?
Let me clarify that. I told him I didn't object to it, but I don't agree that it should be admitted for the truth of the matters stated. It's something that was prepared by Nate Paul and his lawyers to show to Mr. Maxwell. We think it's hogwash, but it can be admitted.
Is that an objection, Dick?
Yes, that's an objection.
Objection hogwash?
Objection hogwash.
All right. You best not sustain
Wait
that
a
one,
minute.
Your Honor.
Which one of those rules is that one, Mr. Guerin?
That's not a
802 or
real
803?
objection, That's so funny.
Got them all.
803.75.
If it's not, we're writing a new one. Okay.
It is not, Mr. President, being offered for the truth of the matter asserted, but only to show that Ranger Maxwell and I think Mr. Penley actually were presented with a copy of this. We're not suggesting it's true or it's the letter of the law, but only that it was given to them. That's the limited scope of the offer. All right.
That should be agreeable. Is he still objecting, or is that
Overrule.
okay? All right. He's overruled.
Because it's not being offered as truth as the matter asserted.
Mr. Arroyo, are you with me? And it's marked. I don't think I said this for the record, Your Honor. It's AG 1005. So we're offering AG 1005. And Ranger, can you see that screen in front of you?
Yes, we're up on screen.
Thank you.
This is your exhibit?
Yes, sir. It's the electronic copy of what I'm holding in my hand, Judge.
For the same ruling, we'll admit this into evidence.
Yes, sir. All right. Mr. Arroyo, could you go to the first page? Next page. Yep, next page, please, Eric. And if you could highlight the first sentence for me, please, and blow it up.
Can you go back to the microphone, please?
Oh, I'm sorry. It's a big room. If you could blow that up for us, Eric. It says that there were 3 search warrants that were executed simultaneously on Wednesday, August 14th. You see that, Ranger?
I do.
And if we'll go down, Eric, to the second to last paragraph, it says, since the search warrants were sent as PDF files via email, after the searches, we were able to analyze the metadata of the PDF documents that were emailed, right?
I see that.
And finally, Ranger, it says, according to the filings with the court in the Western District of Texas, each of these search warrants was signed and issued by Judge Mark Lane on Monday, 10 a.m., August 12th. But if we look at the first sentence and the last sentence, what they are alleging is that the search warrants were, per the filings, per what you and I could see if we looked at them, the search warrants would have been issued at 10 a.m., but on a Monday the 12th. But in reality, the documents were created on Wednesday the 14th, 2 days later, right? That's their claim.
So
No,
I
what it
assume
says
that
is that the 3 search warrants that were executed simultaneously on 9 a.m. on Wednesday, August 14th.
I got you.
I assume these
And the
are the
filings
warrants
say,
that Nate Paul wanted to see the probable cause for.
you're right, I stand corrected. They were executed on
the 14th.
14th, right? And then
Remember, whatever they've been doing
on
to
the
Nate
next
Paul
page,
is part of what
Eric,
they're
if we'll
trying
go
to
to the
cover
next
up with
page,
this impeachment.
and I think that were there a total of 6 warrants, Ranger?
Well, there were 3 warrants that are executed. They had 3 more warrants that they did not execute.
Gotcha. So you spent a long time listening to Mr. Paul's description and Mr. Wynn's description of this Contigo, this search of a storage facility. You spent probably 30, 45 minutes listening.
Yes.
And the net of their suggestion to you, Ranger, was that the search warrants for that facility were created after the search, right?
That's what they're alleging.
Okay. And according to them, and again, I don't know metadata, but according to them, Ranger, it was through the forensic analysis of a PDF that was sent by Alan Bowie to one of their prior lawyers, Chuck Meadows and Aaron Borden. That's how they say they broke the code on this. You with me?
I am.
And you agree with that summary?
What's that?
You agree with the summary that that's their claim? I'm not asking you to believe it. Fact, that's their claim. If we go to the next page.
Metadata. This is why they're so mad that Paxton hired outside counsel to investigate this.
They are saying that the document metadata reveals information that is inconsistent with looking at the documents on their face. You with me?
Mm-hmm. I am.
Okay. And I'm not going to bore us all, but this is what they gave you back on August 5th, right?
I see it.
And they also gave you a thumb drive, correct?
Dude.
Yes.
Now, I think one of the things that would be a condition precedent was whether or not a condition precedent for involvement by the Attorney General's office of the state of Texas would be a violation of state law, right?
Okay, yes.
I mean, you can't investigate, investigate, or prosecute federal cases, right?
That's correct.
Will you at least agree with me that if what they were saying was true, that these actions by federal prosecutors would be a violation, if they were true, a violation of state law, right?
Oh my God, y'all.
The state law, and this is one of the only reasons why I agreed to hear him out, was falsifying a government document would cover a federal document.
Yes, sir.
Even though we don't have jurisdiction over anything else about it.
Gotcha. And I think we're saying the same things, you probably better than me, but if a federal law enforcement agent or prosecutor or judge or whatever, if they knowingly entered false information into a document with the intent to deceive someone else, not only would that be a federal crime, it would be a state crime. I think it would be tampering with governmental records, right?
That's correct.
And they do have jurisdiction over that. This is crazy.
Would you agree with me, Ranger, that despite your concern or belief or hope that Mr. Wynn or Mr. Paul would say something incriminating or say something that would cause them exposure criminally, neither Mr. Wynn nor Mr. Paul ever asked you to do anything illegal?
Yes, they asked me to interfere with a federal investigation, which is absolutely illegal. It's also obstruction of justice.
Show me, Ranger, in the first hour or the second 2 hours on the investigation or the interview of July 12th,
So this guy's
21st
saying that, yeah,
or
maybe
August 5th.
they're
You've got
alleging
the
that the
transcript
FBI is
there.
doing something wrong,
Both of those.
but that the ranger can't do anything about it.
Counselor,
Would it be
you were
illegal?
showing me the evidence right here. It's a map of how he wanted the investigation to be done and to have the AG's office follow how this was to be investigated, along with targeting 6 individuals.
Okay. Where
Because
does
he
he?
knew what was
Excuse me,
happening
Ranger.
to him. That
Go through
wasn't
it and you'll see
a
it.
demand. That was a, this
Show
is what
me.
happened.
Show
What's
it.
happening to me.
I
I'm
don't have a
telling you,
copy
this
of
is
it.
what's happening.
sorry.
Will you look
I don't
into
have
it?
a copy of it.
You do. You've got a copy of the entire transcript of July 12th,
No,
Ranger?
I'm talking about the document you have up on screen right now.
Show me, Ranger,
I don't.
where they say, you say you reviewed the transcripts of the July 12th interview, and you have reviewed the transcripts of the August 5th interview. Show me the language where in either one of those interviews, Ranger, that they ask you to commit a crime.
Surely
They're
it's
not in the
there.
interviews, Counselor. They are in the document you're looking at right now. He lists 6 people as a person of interest to be targeted in this investigation.
Where does
No,
it ask?
because he knew
It's
that
an
they were the
Operation
ones
Longhorn.
doing this
I'm
to
sorry, I'm
him.
talking over you. I apologize, Ranger. Where in this PowerPoint, show me, Ranger, where in this PowerPoint that Mr. Wynn asked you to commit a crime or Mr. Paul asked you to commit a crime? Where?
Objection, Your Honor. He doesn't have a copy of this in front of him. May I give him my copy so he can answer that question?
Providing a copy now.
No, I don't.
My apologies. I thought you had one.
Your Honor, may we approach about some
Yes, you may.
addresses?
Yes, you may.
Okay, guys, I really want to thank everybody for being here. I want to thank every chat. Illigom. They're back now, are they not? They're back. Where's the nexus between the feds and the whistleblowers? Brymark over on Rumble, this is a very good question. Brymark says, this is what I want to know. Where is the nexus between the feds and the whistleblowers? So it now let me think about how to answer that, because so the whistleblowers they had this coup going, then they took it to the feds. I think that they must have had, you know what, Brian? I think that the whistleblowers must have had a connection with the feds, and they've likely deleted the text messages. I'm not sure if those can be recovered if nobody has them. I doubt the FBI will turn them over. But I bet that those whistleblowers.
Judge, can we get a minute? Can we get a minute so they can do what they need to do with the world famous Eric?
We are going to let Eric go to work here.
Yes, sir.
We'll take a stretch break for 5 minutes. Stand at ease.
God bless Eric, right? God bless Eric. So thank you guys so much for being here. I could turn on my camera, but I just got home from work, so I don't look that cute, I don't think. Let's see. Thank you guys for being here. Let me go and check and see what's over on the Pilled chat and Foxhole. Let's see. All right, I'm going to share. So this is what's going on over on Pilled and Foxhole. Hang on a second. All right. Thank you so much, Diddy. What's up, Diddy? Diddy and I will be going live later. I don't know about tonight. Maybe tonight we might be on with one Abe, Uncensored Abe. We may be on. Truitt says, given the latest actions of our beloved FBI and other cases, I wonder who pressured Paxton's office to turn on him. Yeah,
Well, you know, maybe one Erin Epley, but she's from the DOJ. When did the feds first open an investigation into Paul? Well, we did a short little dig on that, and let's see, because so Nate Paul arrested. Let's see. He's been arrested. We're just gonna look over here, okay? In August 2019, FBI raided the offices of Nate Paul, a young Texas real estate investor who became known for buying up prominent real estate assets in Austin. FBI confirmed the raids but declined to specify the nature of its search at Paul's sprawling 9,175 square foot Austin home. Hey, so Nate Paul's doing very well. So Nate Paul is a real estate tycoon, and the FBI has targeted him for unspecified reasons. So when Nate Paul comes to the Texas Rangers and makes a complaint to the AG that they're pretty sure that the FBI is targeting him for some reason, and he would like to know why. So one of the articles is that Paxton gave Nate Paul access to information that he shouldn't have, right? So let's review again. Article 1, which has been debunked, Paxton caused employees of his office to intervene in a lawsuit. No, they all agreed to intervene in a lawsuit. And they're saying that Paxton harmed the Mitty Foundation in an effort to benefit Nate Paul. The Mitty Foundation, what is the Mitty Foundation's business with Nate Paul, with a real estate tycoon? What was this lawsuit about, right? And is the FBI working on behalf of the Mitty Foundation? They say Paxton caused employees of his office to prepare an opinion in an attempt to avoid the impending foreclosure. Wrong. That's been debunked. They halted foreclosure sales statewide and nationwide during COVID because people lost their jobs and weren't able to pay their rent and were facing eviction, right? And foreclosures, which from a government mandated shutdown. All right. So that's been debunked. Article 3. Paxton directed employees of his office to act contrary to law by refusing to render a proper decision relating to a Public Information Act request for records held by the Department of Public Safety. So they're saying, oh, he wouldn't give a proper decision, and then he gave out information that we didn't want him to give out. This is not a crime right here. This has been debunked. That's not even an issue. Article 4. Paxton improperly obtained access to information held by his office that had not been publicly disclosed for the purpose of providing the info to the benefit of Nate Paul. Nate Paul was making Public Information Act requests, and Paxton defers to giving them, just like the Public Information Act of Texas states. And we have this over here on our website. If you want to go over here to takingbacktexas.org, okay? This is our website here. Now you can come over here, hit Moss. Half our website's in Spanish. I don't know why. I have no idea how that happened, and I've tried to fix it, and it just keeps reverting back, but it's fine. So click Moss. Come over, scroll all the way down to the bottom of the drop-down menu under Moss, and hit the Public Information Act. This will go over, once you read through, this is 17 concise points for you to understand the Texas Public Information Act. There's 2 pages of this PDF, but the second one is blank. That's just my skill set on display right here. So check this out and you'll see information is presumed open. So when Paxton gives people information after a Public Information Act request, that's not a crime. In fact, the Attorney General is the one who has discretion over what's protected by the PIA and what's not. In fact, as a matter of fact. So, Ken Paxton, the AG, duly elected Attorney General. So Article 5 is that Paxton engaged Brandon Kamick. Oh, this made them so angry. Brandon Kamick, a licensed attorney, to conduct an investigation into a baseless complaint during which Kamick issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. When Nate Paul comes to Ken Paxton and the Texas Rangers saying, I'm pretty sure these warrants were created after I got searched, pretty sure I'm being wrongfully targeted by the FBI, right? And Paxton's subordinates, I'll put it that way, the mutineers, are coming at him saying that is a baseless complaint. Why would Ken Paxton assign them to the case when they've already made up their mind without an investigation that the complaint is baseless? So Paxton hired an outside counsel, Brandon Kamick, and boy did that make these mutineers angry because they thought the complaint was baseless, but if they were going to even have the illusion of looking at it, they wanted to be the ones to say, we looked at it and it was nothing.
Well, Paxton was like, okay, well, if you've already made up your mind before you've looked at it, fine. And he just went and hired outside counsel, which he has every right to do as the duly elected Attorney General of the great state of Texas. He has every right to do that. So they're saying, so Article 5 is that he engaged Brandon Kamek to help Nate Paul to investigate potential abuse. And the really, really interesting thing was that it seems as though the Texas Ranger was saying, even if it's a violation of federal law, like, so the FBI is breaking federal law, right? And it's true. He doesn't have jurisdiction over that. He only has jurisdiction over the violation of state laws. So if this Texas Ranger is not going to look into whether the FBI is breaking their own laws because he's not going to have jurisdiction over that, kind of strange. Either way, now we know what the complaint was that Nate Paul was taking to Paxton and to the Texas Rangers, and it was that the FBI's search warrants, some of them were created after the searches were conducted. That's what the metadata on the files suggests, according to Nate Paul and his attorneys and some experts that they've shown that to. So that was what they're calling a baseless complaint, that there weren't lawful search warrants issued by the FBI. Raise your hand, guys, if you're surprised that the FBI has been accused of issuing baseless search warrants. Right? Here's Article 6. Paxton terminated employees of his office. This is debunked so quickly. Yesterday, all of these guys resigned. He hasn't fired anybody. They kept lying under oath. They kept committing perjury, and I'm shocked that they weren't held in contempt of court, because they were saying stuff like, yeah, I did resign, but it was because he effectively fired me. It's like, no, he didn't say you're fired. He did not say, good luck getting another job. He didn't say, he didn't say anything of that. He just took some of these people off some of the items that they were working on, and they took that as being, what do they call it? He basically, like, he constructed is what he said. Okay, so they said that they're looking over exhibit 1005 right now. So I'll go back and talk about this again. He didn't terminate anybody. They all admitted that they resigned. And they resigned because they felt like they were effectively terminated because they were not handling the cases that they wanted to handle. So none of them have been fired. And then it says, furthermore, Paxton engaged in a public and private campaign to impugn the employees' professional reputations or prejudice their future employment. None of them have any evidence of any of that, and they all have well-paying jobs. Not one of these clowns missed a single paycheck during COVID. So you saw the guy being grilled by the young attorney, the young and handsome attorney, Anthony Osco. He was like, do you remember COVID when people were facing foreclosures and eviction because of the government mandated shutdowns, that the Attorney General's office took a position, in support of the people? They say that the foreclosure thing was for Nate Paul. No, that literally, do you know how many more blue collar families benefited from not being foreclosed upon during COVID? Way more than just Nate Paul. Absolutely ridiculous that they would try to say that. These people were not fired, and they never missed a paycheck. They've never gone without, and they currently have well-paying jobs. In fact, they were already looking for better jobs before they resigned. Flat out lie. Article 6, totally debunked. Article 7 says, specifically, Paxton directed employees of his office to conduct a sham investigation into whistleblower complaints made by the employees whom Paxton had terminated. He did not terminate them. Multiple lies, just compounding. And to create and publish a lengthy written report containing false or misleading statements in Paxton's defense. Yeah, he investigated what was a very, very apparent mutiny. Absolutely. I would have too. Debunked. Article 8. Specifically, Paxton entered into a settlement agreement with the whistleblowers that provides for payment of the settlement from public funds. Settlement agreement stayed the wrongful termination suit, conspicuously delayed discovery of facts and testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. So somebody, obviously, was really trying to secure a conviction for Paxton, and because that was delayed by the whistleblowers agreeing to settle, which of course the settlement would be paid from public funds. It was the whistleblowers against the Attorney General's office, and it's not the Attorney General acting autonomously. This is like a civil war in the OAG. Okay.
So, oh no. So the whistleblowers who settled also went and helped the House write impeachment articles based on them settling, and the fact that they agreed to settle delayed delayed a conviction that would have cost him his election. It's like they're telling you their entire game plan. This is hilarious. This is the funniest thing. So that's where we're at right now. Look, let me see. Are they still? They're still milling around, working about AG 1005. I'm not sure which piece of evidence that is again. Let's see. So that was Article 8, debunked and indicative of a larger plan, a larger plot against Ken Paxton. Article 9, specifically, Paxton benefited from Nate Paul's employment of a woman with whom Paxton was having an extramarital affair. This is just total slander. This is just them, and I'm not. Thanks, Stacy. Eric gets all the glory this time. One second. I'm trying to figure out which one of these is. I don't think that they're back yet. One second. This one says it's live. This one says that it's ahead.
Go.
Okay. We have a transcript, do we not, of exactly what they said?
Transcript of?
Exactly what they said when they were meeting with you on August 5th when they gave you this PowerPoint.
Yes.
The comedic timing is just.
And you've reviewed that
Chef's
transcript,
kiss.
you say?
Yes.
And where in the transcript, what words do they use to describe to you that they desire a crime
So wait a second. Hang on a second.
to be committed?
They obviously did not say that they wanted a crime to be committed. What they wanted was an investigation.
Okay. And your position, Ranger, is two private citizens be to investigate the legality. If that's a crime, I'm going to be on death row. I investigate the legality of search warrants all the time. That's what I do. What crime is it, Ranger, for them to ask you to investigate the legality of a search warrant?
Yo, give me a 5x5
The
if you can hear
only
this.
purpose.
No, sir. Objection non-responsive. What crime is committed?
Objection, he didn't allow him to finish, and so we could see whether it's responsive or not. I believe it was going to be responsive. Objection to interrupting the witness.
Overruled, sustained, but.
I'll ask again.
Overruled and sustained.
And I'll calm down.
And you can raise the mic too.
And I'll calm down.
Thank you, Diddy. Diddy says when he wins the lottery, he's going to pay for law school for myself, Crisco, and Victoria.
What crime?
We're going to be Diddy's angels, not Charlie's angels. We're going to be Diddy's angels.
By them asking you to investigate the legality of a search warrant. What crime is that?
In my professional opinion, to create this investigation and follow through it would be obstruction of justice and interfering with a federal investigation.
Okay. In fact, doesn't
so when
Mr.
the
Wynn
FBI
say
screws us over, we have no
over
recourse.
and over in the transcript, he does not want to interfere with the federal investigation. He does not want to obstruct justice. Doesn't he say that?
He does.
Okay. So the fact that he's saying he doesn't want that done.
But you're taking it to be the opposite. That's
Even though he
weird.
says he doesn't want that done, you think it's a crime because?
His actions belie his words.
Okay. Well,
Gee, project
you
much?
are Dave Maxwell, Hall of Fame Ranger. If they would have committed that offense right there, literally on videotape, the Dave Maxwell I know would have stuffed and cuffed him right there. You would have arrested him, right?
Fact, surely you won't.
Okay.
Oh no, surely you won't watch
In
a crime in
fact,
action
Ranger,
and then let them walk out the door. Surely
what
you
did
would.
you tell him?
I told them that what I said in the beginning, that we would have the forensic people look at the metadata, and they promised to give us all the documents they had in order for us to do an examination.
Let me try again, Ranger. Instead of saying, you've committed a crime, I'm going to arrest you, what you say on page 143, line 24, is we're going to look every which way into this, right?
That is exactly right as far as the metadata.
Mr. Penley says, quote, we're going to look into these allegations, right?
He may have said that.
Okay. Mr. Penley says, thank y'all for coming in today. We appreciate it. Thank you for the handout and for the documents. We'll look into this. Are those the Mark Penley's an experienced prosecutor, right?
Yes.
He was with the U.S. Attorney's Office in the Northern District of Dallas Division by my recall 15, 18 years. He's not a newbie.
Something like that, yeah.
Do those words, Ranger, sound like the words of an 18-year experienced federal prosecutor that believes a crime has been committed?
No.
Thank you for the handout and for the documents. We'll look into this.
What is your question about what you just said?
My question is, do the words spoken by Mr. Penley suggest in any shape, form, or fashion, Ranger, that he, Mark Penley, believes that a crime has been committed in his presence by the tendering of the very documents we've just discussed?
Absolutely not.
Do you think Mr. Penley's a pretty straightforward guy most of the time?
I'm sure he is.
Well, you worked with him, didn't you?
Yes.
I assume, Ranger, that if he exhibited any characteristics of deceit or deception, you would have picked up on him.
Who would have picked up on the deceit?
You, Hall of Famer Dave Maxwell.
How I answer that is that he and I both knew that the only thing we were going to do was look at the metadata, period.
Okay. Well, since you know what he knows.
I guess the real question is who got to the Texas Rangers?
Mr. Penley?
Mr. Penley did not believe that a crime had been committed by these officers or the magistrate or the U.S. Attorney's Office.
My question.
What did the metadata say?
Did Mark Penley believe that Mr. Wynn and Mr. Paul, by asking for this investigation, did he think that was a crime by the simple asking of the legality of search warrants to be investigated was a crime?
He believed, as I did, that if we followed through with what they were asking, it would definitely be a crime.
Okay. And that's why he continued to work on this case. That's why he continued to do an investigation. That's why he told Ken Paxton, I've got more work to do. There's more things I need. I need to do some more research. Does that make sense, Ranger?
I didn't tell Paxton that.
No, he did. Are you aware of that?
Who did?
Mark Penley.
Oh, I don't know what he told him.
Ranger, when is it, sir, that you first heard the name Brandon Kamek.
When I was on vacation in Colorado.
And I think Mr. DeGuerin had you in late September.
Late September. I was traveling to Colorado on the 26th of September, 2020.
Okay. And you learned of that name how?
Through Mark Penley.
Okay. So do you have an independent recall, Ranger, of the date of that? Like 25th, 26th, 27th? Just ballpark it for me.
It was on the 26th of September 2020 when Mark Penley told me about what was happening with Kamek.
Okay. So Penley calls you. You're in Colorado at the top, and you got to come down, and that's...
Well, actually, I was driving at that time, so I had him on speakerphone.
Okay. But anyway, you're in Colorado.
Right.
He's here.
Right.
And he's upset and annoyed, whatever, because Brandon Kamek has been hired.
I think at the time he had not been hired, that on that particular date, he had a meeting with Ken Paxton, and Ken Paxton tried to get him to sign the EAM so Kamek could be hired.
Let me slow you down.
Okay.
Stepping on pronouns.
All right.
When you say he tried to get, who is he? You just said that
he tried, Ken Paxton.
Yes, sir.
Tried to get Mark Penley to sign off on our EAM, which is a protocol that various people have to sign in order to hire, spend money, that type of thing.
We've unfortunately heard a little too much about an EAM. But for purposes of this exchange, Ranger, are you aware that the Attorney General has the authority to hire outside counsel himself statutorily?
The way the system works is...
Non-responsive. Objection non-responsive.
Sustained.
Are you aware, Ranger, statutorily, the Attorney General has the authority for he himself to hire outside counsel?
I was told by...
Yes or no? Are you aware?
I do not know that's a fact, no.
Okay. You don't know one way or the other?
It's not my bailiwick.
Yes, sir. All right. Now, when we talked earlier, Ranger, about some potential mistakes that you may have made when you met with the House committee about your recollections, and to be fair to you, Ranger, this was a meeting this year in February, right?
Yes, it was.
And what had happened back at least 2 years ago, maybe 2.5, right?
Yes.
So I'm not carping at your memory. I just want to make sure we're all on the same page now as to what's accurate and what's not. Okay. Do you remember telling I think we've already discussed sort of globally, at one point you told the House committee that Drew Wicker delivered documents in a back alley in the dark of night, right?
I did say that.
And I'm the last person, Ranger, to strike out at another about hyperbole, but that's what that was. That was just an exaggeration on your part, right?
No, it was exactly what I had been told by numerous other people. I had no direct knowledge.
All right. So who was it, Ranger? Who was it, Ranger, that told you that Drew Wicker delivered these documents in the dark of the night in a back alley somewhere? Who told you that? You said you were told that by numerous people, so give me two.
Counselor, in being very honest with you, there's probably 5 or 6 people who told me that in passing, and I couldn't tell you who it was. It's 3 years ago.
Okay, well, if it's 5 or 6 people that told you that, can you give me one of them?
If I testified today who it was that gave me that information, I would not be able to say honestly that person did.
Okay. Well, you certainly told the House committee that, right?
I absolutely did.
And when was it, Ranger, that you decided that statement to the House committee was incorrect?
I didn't know whether it was correct or incorrect. I passed it on to the House. That's their job.
Let me back up, Ranger.
Yeah.
I thought 2 hours ago or whenever it was, when you and I started this dance, sometimes friendly, sometimes not so friendly, I asked you if there was anything in reviewing your statements to the House managers that you believed was inaccurate. And you pointed out this very statement, that is the Drew Wicker dark of night back alley statement. And you had indicated that you had, I think, come to that conclusion after meeting with either Mr. DeGuerin or Mr. Hardin. Is that right?
Yes, it was one of my attorneys asked me, did I make that statement on that date? And I said, yes, that I was passing on information that I received from someone else.
Okay.
But I had no direct knowledge.
Right. So are you relying upon Mr. DeGuerin or Mr. Hardin now for the truth or falsity of something?
Please like and share this out, guys, and thank you
I'm
guys.
not sure I understood your question.
Okay. Well, you told the House back in February that Drew Wicker, dark and night back alley. Now you're saying that's a mistake. When did you determine it was a mistake?
I don't know whether it's a mistake or not. I'm passed on the information. I was asked by our attorneys, did I say that? And I said, yes. And I explained to them that I passed it on to them to investigate it.
Okay.
So I don't know what Drew's testimony would be or would not be. I don't know the truth.
So you don't know if what you were saying to the House managers is true or not?
What I was saying to the House managers was that somebody needed to talk to Drew Wicker. That was my only purpose in bringing it up.
Well, but when you tell the House managers your statement, you would agree with me, Ranger, you don't say, I heard from 5 or 6 people that his travel aide, who was with him at all times outside the office, went with him to have meetings, and also in one instance carried documents and gave them to Nate Paul in a dark alley one night in the middle of the night. You don't say you heard that from 5 or 6 people. You say that as a fact, right?
In my mind, I said it for them to be a lead to go talk to Drew Wicker.
Okay.
I didn't say it as a fact because I have no personal knowledge.
You're saying you didn't suggest you had personal knowledge of that?
I do not have any personal knowledge about what Drew Wicker would or would not testify to. I was relaying what I was told by others so the committee could find Drew Wicker and find out what the truth is. It's part of an investigation.
So how do we know?
Oh, Ranger, he's very smart. He's very slick.
When we look at your statements that have been made to the investigating committee, how do we know that those are statements based on your own personal knowledge or based on something that you've heard?
I will certainly tell you if you ask me.
But you didn't tell them. You didn't say, I heard this from 5 or 6 people. You said it emphatically. First person, in fact. So how can we tell when it's you're relying upon and your memory or unnamed people? How do we know?
Objection to Mr. Cogdell, sorry. Objection to Mr. Cogdell stating
nothing, Dick, nothing.
Well, we've known each other for at least 30 years, but my objection is to Mr. Cogdell making a statement of what the record says, and then asking him a different question about it. It's a statement by counsel rather than proper cross-examination.
Look on page 18, Mr. Maxwell, of your...
I'll sustain the objection. You can rephrase it.
Yeah, thank you. And I'm sorry I call you judge. It's just reflex, Your Honor.
You can call me anything. It's fine. I'm just
Let's
here.
don't get carried away.
I just have this job.
If you will look, Ranger, on page 18, I believe line 3. Okay. Would you read out loud what you tell the House managers on page 18, line 3?
Yes, yeah, his travel aide, who was with him all the time outside the office, went with him to, and there's a hyphen, would have meetings with him, and also in one instance carried some documents and gave them to Nate Paul in a dark alley one night in the middle of the night.
Okay. So you would agree with me, and to satisfy Mr. What's the name?
Touche.
Both of you need your names in the hat right there.
Yeah,
Okay.
to satisfy Mr. Touche, you would agree that you didn't qualify this statement, Ranger, that it was told to you by 5 or 6 people, right?
What are you asking me to agree to?
You would agree to me that when you told the House committee this story about Drew Wicker, you never said you had heard it from someone else.
I did not.
Okay. So my question remains the same. Since you didn't qualify or explain your answers that were based on hearing it from someone else, how do we know, Ranger, when you're telling us something that you know your own personal knowledge as opposed to hearing it from someone else?
There is no comparison between giving an investigative committee a lead to go and investigate. I never said that I had any personal knowledge of that.
Okay. Let's try again. What's the answer to my question, Ranger?
Which is?
Third time. Since you don't qualify your explanations and explain to us whether they are based on first-person knowledge or you heard it from somebody else, how do we know what you are basing your explanations on?
My explanations of what? Now, what are you referring to when you say, what did I base my explanations on?
My objection was asked and answered.
Actually, he hasn't answered.
Overruled.
Now, so that you and I are clear, Ranger.
Okay.
You are a fellow that's taught folks how to testify, right?
Say it again.
Why is it that every time I ask you if you've taught folks to testify, you suddenly can't hear the question?
Actually, my testifying, I learned by experience.
Okay. And is that one of the things you've learned by experience, Ranger, to pause and act like you haven't heard the question?
Maybe.
Fair enough. Well, what did you learn?
I learned that it throws you off.
Does it? Does it? Okay. And that's your intent, Ranger? Rather than testifying to the truth and giving direct answers, your game is to throw people off? Is that where we're going, Ranger? Is that where we're going?
No.
That's what you just said. That's what you just suggested.
I just said that I do sometimes pause.
Ranger, you also told the House committee that Ken Paxton met with the Travis County DA and requested that the Travis County DA's office refer the case to him. You remember telling him that?
And referred the case to who?
To him, Ken Paxton.
Yes.
Okay. Who told you that?
Don Clemmer.
Okay. That's really interesting. Because are you aware, Ranger, that it was Don Clemmer who told Mindy Monfort and Miss Moore, hey, I don't want to deal with this. Let's give it back to the AG's office. It was him that came up with the idea. Are you aware of that?
I know that Don Clemmer, when I made the phone call to him, and I was chewing him out about sending that over to me, that he told me it's not his
Objection.
fault that Ken Paxton
Non-responsive.
requested it be sent to me.
Objection non-responsive.
Sustained.
Excuse me, Your Honor, but
No, he's not answering the question, Mr. Touche. He's
my
not.
objection. My objection is that Mr. Cogdell cut off his answer when the answer was responsive to what Don Clemmer told him.
No, that wasn't the question. The question was.
Overruled, and rephrase the question.
Yes, sir.
Make it clear.
Yes, sir. The question is, Mr. Maxwell, are you aware that it was actually Don Clemmer's idea to refer the case to the Attorney General's office? Not Ken Paxton's. He wasn't even aware that that process could occur. It was Clemmer's idea, not Paxton's. Are you aware of that?
Objection to the form of the question, inserting what Ken Paxton knew.
Sustained.
Are you aware that the idea to refer the case to the AG's office came not from Ken Paxton, but from Don Clemmer? Are you aware of that? Yes or no, Ranger?
Objections. That's a fact, not in evidence.
I'm trying to get it in evidence.
But it's the lawyer testifying.
Overruled.
Fifth time, Ranger. Are you aware that it was the idea of Don Clemmer to refer this matter to the AG's office? Are you aware of that? Yes or no?
No, that's
Thank
not
you.
what he told me.
Okay. You've told the House Committee, Ranger, that actually it was your lawyer, Mr. Turner. Is he here today? Did you say that?
Mr. Turner?
Yes, sir.
Yes.
Where is he?
He's in somewhere. I think he's in the chambers.
Okay. But he was with you while you were being interviewed by the House managers, right? Back in February.
That's correct.
So you were present when your lawyer told the House Committee that Paxton drafted the contract to Kamek and Paxton took Kamek over to the DA's office.
Yes, I was there when he said that.
Yes, sir. So look at page 49, Ranger, of your Board of Managers interview. If you'll look, Ranger, at, I think, line 3 down, your lawyer says what David's talking about is after David and Mark refused to approve hiring of outside counsel, Attorney General Paxton actually drafted and sent the contract to this guy, Kamek. That's what your lawyer tells the Board of Managers, right?
Yes.
Where did he get that from?
I don't know.
Did you hear that from somebody?
Yeah.
Who'd you hear that from?
Say it again. Who's what?
Really?
No, I'm being serious.
We're gonna be here all day. Who did you hear that from, Ranger? Who did you hear that Paxton drafted and sent the contract from?
I don't know who has that information. I wasn't involved with Kamek.
Objection, non-responsive.
Okay.
Sustained.
Ranger, I'm asking you, who told you that Ken Paxton drafted and sent the contract to Brandon Kamek? What is the name of the human that told you that?
I don't know that.
I'm not asking you if you know that. I'm asking you who told you that. Those are two different things.
I think the statement was made by my attorney.
And you said, after I pointed out, Ranger, that your attorney made that statement, you were the one that said, I had heard that. And I am asking you, who told you that?
I would think it was Mark Penley.
Mark Penley. Okay.
Because Mark Penley was involved with that.
Okay. And your lawyer, Mr. Turner, Ranger, goes on to say, and then referring to Paxton, and then took him over to the DA's office and introduced him to them, where he went to the grand jury in the auspices of being his special prosecutor for the Attorney General's office and obtained somewhere around 40 subpoenas. So your lawyer is telling the committee that Ken Paxton took Brandon Kamek to the Travis County DA's office, to the grand jury, introduced Kamek to the Travis County DA's office grand jury, or the Travis County grand jury, and Ken Paxton got Kamek to get the 40 subpoenas. That's what your lawyer told you.
Objection. The objection is he's trying to cross-examine the witness from another person's statement. The lawyer, he's only recited what the lawyer said, not what the witness said in that statement.
I didn't think there was any confusion about that. You were sitting right there when your lawyer is telling the DA's office.
Sustained, try a different approach.
You are sitting right there when your lawyer is telling the committee that Ken Paxton took Brandon Kamek over to the Travis County DA's office, right?
Right.
Was that your understanding of what happened? That Ken Paxton took Brandon Kamek to the DA's office?
Like I said, I have no direct knowledge of it. I talked to Mark Penley a lot. He may have told me that.
Okay. And your lawyer goes one step further and says that Paxton introduced Kamek to the grand jury. Is that your understanding of what happened?
I don't know. I don't know if that happened or not.
Okay.
Yeah, objection to cross-examining from what the lawyer said, not what Mr. Webster.
I am certainly free to
said.
test this witness's memory about what happened and what didn't happen. And if this lawyer is making falsehoods while he's sitting there, I can cross-examine him about that all day long.
Sustained.
Did you tell your lawyer, or where did your lawyer learn from this? Where did your lawyer learn this claim that Paxton took Mr. Kamek to the grand jury?
Objection. This Law School 101 says you can't ask a client what he told his lawyer.
I'm not
Object to
asking
that.
him. Law School 101 would also teach you to listen to the question. Where did your lawyer learn that Paxton took Kamek to the grand jury?
I have an objection pending as to inquiring about conversations between Mr. Maxwell and his lawyer.
They're not privileged. They're in front of the House committee.
Can both of you come to the bench? Can you both come back? Mr. DeGuerin, Mr. Cogdill. Jurors, if you'll take your seats again, please.
Okay.
Hopefully we've worked this out.
Think so. Let me try it this way, Ranger. You with me? Can you hear me?
Yes.
Okay. Do you know how your lawyer knew, or supposedly knew, that it was Paxton that ostensibly took Brandon Kamick to the DA's office? Do you know how your lawyer?
I do not.
Do you know how your lawyer learned that Paxton took him to the Travis County grand jury?
No, I don't know how he knows that.
Do you know how your lawyer learned that Paxton was with Kamick when he obtained these grand jury subpoenas?
No.
Well, when those statements were being made, Ranger, did you, David Maxwell, stand up and say, whoa, 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 where'd you learn that from? Where'd that come from? What are you basing that on? Did you say anything to suggest to the committee that those statements weren't accurate?
I don't know if they're accurate or not.
But you don't know if they are or they aren't, apparently.
You're right. I don't have any knowledge of it.
Okay. So that I'm clear, are you suggesting to this jury, to these 31 senators, that it's perfectly permissible for you if your lawyer makes a statement to the House committee and you have no personal knowledge whether it's true or not, you're fine with that?
I am fine with somebody making a statement that they know something about. It doesn't, because I don't know, doesn't mean it's not true.
Okay. Well, do you think, Ranger, that Ken Paxton took Brandon Kamick to the DA's office?
I don't know the answer to that.
Do you think, Ranger, that Ken Paxton took Brandon Kamick before a grand jury?
I don't have any direct knowledge.
Okay. Do you think, Ranger, that Ken Paxton was with Brandon Kamick and helped him get those subpoenas? Do you think any of those things are true?
I don't know the answer to it.
Okay. So when you left the interview with the board of managers, after that point in time, did you learn that any of the information that you had been provided or that your lawyer had provided was incorrect? Did you ever find out anything that was said was untrue or inaccurate?
No.
Okay. And of course, had you would have brought that to their attention.
I would.
Okay. I have just a minute, Your Honor.
I'm sorry, say that again?
It's catching now. Everybody's got it. Can I have just a second?
Yes, yes. The acoustics in here are not the best.
Ranger, You never had any intention of investigating any of this, did you?
When I read the allegations, I never had any intentions to open up an investigation. That's correct.
You never had any intentions of finding out whether or not Mr. Kamek and Mr. Wynn were telling you, you never had any intentions of doing any investigation, right?
I plainly stated I was not going to do an investigation.
Okay. You didn't so much as make a phone call, right? You didn't make a phone call to investigate. You didn't get on PACER. You didn't do TCIC. You didn't do NCI. All that litany of accessible tools that you had at your disposal, you didn't do anything, right?
I did not run him through any of our databases.
And you never had any intention of conducting an objective, fair, reasonable, thorough investigation, did you?
There was no investigation to be done.
Objection, non-responsive.
Sustained.
Do you remember, Ranger, when we went through the litany of characteristics of a good investigator in the beginning of your direct examination?
Yes.
They should have an open and an objective mind, right?
Yes.
They should act without bias or predisposition.
Yes.
They should be willing to follow the evidence.
Yes.
Should conduct an investigation timely, right? Should conduct an investigation timely.
Yes.
And that they would know that no person is more or less deserving of their best efforts than another person, right?
Yes.
The investigation should be thorough, right?
It should be, absolutely.
And they should generate and keep accurate records and reports, right?
I didn't quite catch that last part.
Now I couldn't hear you. That's the first.
I'm sorry.
It's all right.
I didn't quite catch the last part of the question.
Yes, sir. That if someone's going to do a legitimate investigation, they should keep accurate records and reports.
Absolutely.
Okay.
Yes.
And you never had any intention of doing any of that, right?
There was no investigation.
That's a no. You never had any intention of doing any of that?
Right.
Okay. That's all I've had, Ranger. Thank you.
Redirect.
How much you got? You want me to get this out of the way? My name is Cogdell, by the way. Out of the way. How much time? Knock yourself out.
Mr. DeGuerin.
Once you were told that Nate Paul was the person that General Paxton wanted you to meet with, did you find out who Nate Paul was?
I did.
And once you found out who...
This is asked and answered on direct, same question.
Sustained.
Did that... When you found out what he was and who he was, did that make the back all that other stuff that Mr. Cogdell talked about unnecessary?
Leading and ask and answered.
Whether or not did it make it unnecessary?
Ask and answered on direct.
Sustained.
All right. Mr. Cogdell asked you several questions about your conversation with Don Clemmer, the man in the Travis County District Attorney's office. So what did he tell you about this?
Objection, hearsay.
You opened the door, Your Honor.
No, I didn't suspend the rules of evidence. Objection.
Starting
hearsay.
on page 78, line 15, there were a number of questions asked about the conversation with Mr. Clemmer, even to the point of what Mr. Maxwell said to Clemmer. I believe the door's been opened. I believe it's admissible, and I'm asking that the court allow it.
Open the door is not a hearsay exception.
Overruled.
Go ahead.
Yes, Don Clemmer told me that Ken Paxton requested the investigation be sent to me.
And what did he tell you about his opinions about the review?
Objection, hearsay. I didn't ask about that, even though I contend you can't.
Sustained.
In the presentation, this PowerPoint presentation, was there a part of it that listed 6 people to make targets of an investigation Mr. Paul wanted you to conduct?
Yes.
What was your opinion about whether that was proper?
If we followed the PowerPoint he created and conducted that investigation, we would have committed several federal crimes.
What are they? What are the crimes that you...
Obstruction of justice, interfering with a federal investigation.
That's all. Thank you.
Recross.
Yes. Let me get this straight, Ranger. So if the feds break into my house, break the door down, hold my wife at gunpoint, kick my dog, cut off my internet, search my house without a warrant, and I want that crime to be investigated, you're telling this jury with a straight face that that's obstructing justice and interfering with a federal investigation? That's your position? Ranger, you're smarter than that.
That's
they
crazy.
Did have a search warrant, and they did execute it, and it was lawful.
You don't know if the search warrant was lawfully issued or not. You don't have a clue, do you?
Mr. Nate Paul doesn't have any evidence that it wasn't lawful.
Witness, please.
Arguing with the witness. Objection.
Sustain.
Have you ever analyzed the search warrant affidavit to see if it establishes probable cause for each of the search warrants that were issued?
Mr. Paul did not provide us with the document.
Objection, non-responsive.
Sustained.
Ranger, you're smart enough to know what question I'm asking and whether or not to answer it.
Objection to the sidebar remark.
Ranger, are you smart enough?
Hold on, there's an objection pending.
Slow down, gentlemen. Slow down. I sustained your objection. Go forward.
Yes, sir. Ranger, are you smart enough to understand my question? And are you smart enough to answer my question?
We analyzed the material he gave us. That's all I have.
Sustain.
I think we're done here, Ranger. Good luck, sir.
That was insane.
Witness may step down.
That was totally nuts.
Can the witness be excused? Both parties? Both parties, witness excused? Yes.
I don't think we'll need Ranger on the call, but I have no problem.
Okay.
That's completely outrageous. The federal government is totally out of control. And even the Texas Rangers. This was the guy. This was the head of the Texas Rangers.
Yes,
saying that there's nothing.
Take a 10-minute break. Stretch your legs and be back at 4:40.
Yeah, they probably need a break because that was brutal. That was a brutal. My goodness, what do y'all think about that? That was nutty.
So we will adjourn until Monday morning at 9 a.m.
Okay, guys, so I will reset this in just one moment. Give me 1 second. All right, guys, I apologize for the delay. I'm away from the computer right now, so give me just a moment. All right. So I'm just gonna be reading through the comments, I suppose, until till they come back. Yep, there's some serious fuckery afoot. I agree with you. Let's see. Yikes, the process is the punishment, right? I mean, they know that they don't have a case anyway, so yeah, they're grinding this out. They may, yes, you know what? I believe they probably did say back on Monday because Dan Patrick said he wanted to stop around 5 on Friday, and it's 4:30, so unless they come right back, I don't imagine, they probably, they probably wrapped up because Patrick said that he did want to be done by 5 on Friday. He was willing to go to 6:30 or 7 the other days, but he said pretty clearly that on Friday he wanted to be done by 6. So, yeah, probably that is exactly what happened, is that they said, see you back on Monday. Now, here's what we'll do. If they do come back today, then we will recap that and we'll come back and give commentary on that. All right. So yeah, I think they're gonna go back. They're gonna come back on Monday. We'll see. I don't know if they're gonna do it tomorrow, because I thought I also heard Patrick say that he was willing to do these on Saturdays if need be. So thank you guys for being here. So let's see. Let me check the pill chat. Thank you guys so much for being here. Thank you, Diddy. Thank you, Truitt. Yeah, they adjourned. Yeah, I remember they adjourned till Monday. Yeah, because Dan Patrick wanted to be done by 5 on Friday. So thank you guys very much. Thank you, Diddy, and everybody. So, I mean, feel free to keep leaving comments down in the chat, okay? I'm gonna just put up one of our little closing banners, and y'all carry on having the conversation, and I'll be reading that for a few more minutes, probably maybe like 15, maybe 10, 15 more minutes. I'll leave that up in case y'all have any questions or want to discuss things. If I see anything I know the answer to, I'll come back in and answer your question. But thank you guys for being here. I appreciate a couple of the donations that we got today. That was so generous of you guys. That really helps out a lot. You have no idea. Like, the donations really help. They're not required, but they're very much appreciated. So thank you very much. And I'm not sure if I'm not sure if the people who donate want their name recognized. If you do, when you send a donation, you can say, "Hey, you can thank me," or you can just not say anything. How about this? If you don't want me to thank you, just say anonymous or whatever. Or I don't want to dox anybody. Anyone can donate to me, even if you're a Democrat. If you like the commentary and stuff. I know today I wasn't able to do as much commentary because I had to work. But thank you guys for being here and watching anyways. And anyone can donate. I'm not gonna like dox anybody. And so unless the IRS comes for me, which, and then publicize all my records, which I doubt they'll do. But yeah, I can keep everything anonymous. So I appreciate y'all's donations and it helps a lot. Thank you guys. And I'll come back in just a minute. Y'all go ahead and let's just chat amongst ourselves for a few minutes, because that was totally crazy, especially what was just established there at the end. Did y'all, I mean, I don't know how many of y'all heard that, where he established basically that the federal government can do whatever they want and there's no recourse for a rogue federal agent, which is what Nate Paul is alleging, what the House is claiming is a baseless complaint that Paxton was investigating. Right? Totally crazy. What do y'all think about that? And then what else did y'all hear today? Did y'all hear anything earlier today that really struck you? Because I'm going to go back and recap the couple of hours that I wasn't able to see while I was working and watch all of that, because I'm looking for something, I'm trying to figure stuff out too, just like you guys, trying to say, where's the connection here? Because there's a federal connection here and it's getting kind of creepy. I'm starting to be, are y'all creeped out? Because I'm starting to feel a little creeped out. It's like, dang. So, okay, well, I'll come back in. I'm going to just watch through the comments. I'll come back in and we'll close this out in about 10, 15 minutes. Sorry about that. So yeah, I'm not streaming until 6. I'm about to wrap this up, you guys. So yeah, so thanks for all the comments and all of y'all's participation. Yeah, I think they'll be back on. Let me see. We'll be streaming live again as soon as they're back on. Okay, so yeah, so we'll see you guys next week, and I'll have more commentary next week. So it's good stuff. We're watching the deep state, being exposed. Actually, if we're successful with this, we get to expose the deep state for what they do to people, and what they do to our patriot representatives, right? So thank you guys for watching. Don't forget to check out our website, takingbacktexas.org, and we will see you guys, I suppose, on Monday. But you guys might see me on some other chats. Diddy and I, we're going to talk about some of this stuff on some other chats too. So thank you guys very much. We will see you guys soon, maybe tonight, maybe in the next few days. Definitely Monday morning, we're going to be streaming this again, live in action, giving hot sports opinions. Okay. Thank you guys. Bye.